sequence of action. I hope everybody got the compendium law book. This book has been compiled by our director, Shri Anil Kishore Yadav, sir. And this is for your reference purpose. You can refer during the sessions, this book. And if any officer want to purchase, our staff will share the scanner in the group. You can purchase this book by paying rupees 1200. Yeah. And if you after the completion of this seminar, you can keep this book in this auditorium itself, and our team will collect. Thank you. Yes, sir. So all the officers have registered themselves. Please register yourself so that the other things can be smoothly conducted. If you have the registration, we have so many facilities for the officers who are our trainees who have participated in some training program at CAPT. You can have a stay free of cost at any of our guest house available at various in various cities like Hyderabad, Kolkata, Jaipur, New Delhi. You can, if you have attended some training at CAPT, then you have the access to our guest house available at various part of the country. So please register yourself, and all the study material available on our homepage of BPR&D, Bureau of Police Research Development, and CAPT. You can access that also. We have developed so many SOPs and so many study materials there. Yes, sir, we can. All set. I request all the officers to please keep your mobile phone on silent mode. Our chief guest, as you can see, is Honorable Shri Justice Anirudh Bose, sir, retired judge from Supreme Court of India, and presently sir is holding the charge of Director, National Judicial Academy at Bhopal. Thank you.
सर बुक सभी सर लोगों को मिल गया सर
मंगवा लीजिए सब। देखिए देखो गिरेगी, जल्दी दो, जल्दी से देखिए। और किन अधिकारियों को बुक नहीं मिली है? काइंडली बता दें बुक किनको। आगे राजू, सबसे आगे। और कोई अधिकारी जिनको पुस्तक नहीं मिली अभी? अच्छा, पीछे भी है, 5-6 किताबें और ले आई। लास्ट रो। मैं मैं स्टेट्स के नाम बता रहा हूँ। इन स्टेट्स के अलावा अगर किसी और स्टेट से अधिकारी हो तो काइंडली बताइएगा। महाराष्ट्र, छत्तीसगढ़, मध्य प्रदेश, वेस्ट बंगाल, कर्नाटका, झारखंड एंड हरियाणा। इनके अलावा किसी स्टेट से और अधिकारी हैं क्या? आप कहाँ से सर? हरियाणा? यानी मैं उड़ीसा। ओके। और इसके अलावा कोई स्टेट? कर्नाटक मैंने बोल दिया सर। उत्तर प्रदेश? एनी अदर स्टेट सर? आई एम वंस अगेन रिपीटिंग द स्टेट। महाराष्ट्र, छत्तीसगढ़, मध्य प्रदेश, वेस्ट बंगाल, कर्नाटका, झारखंड, हरियाणा, उड़ीसा एंड उत्तर प्रदेश। ओके, थैंक यू। जिन अधिकारियों को बुक नहीं मिली कृपया प्राप्त कर लें। हेलो। ऊपर कैबिन में कौन है? लांबा, मुकेश, देखिए स्क्रीन ऑफ हो गया। सभी ऑफिसर्स व्हाट्सएप ग्रुप में ऐड हो गए हैं? कोई अधिकारी ऐसे जो ग्रुप में अभी ऐड नहीं हुए? क्योंकि हम प्रेजेंटेशन सब उसी में शेयर करेंगे। काइंडली आप अपने कलीग के थ्रू या मुझे डायरेक्ट व्हाट्सएप मैसेज कर सकते हैं अपने नाम डेजिग्नेशन के साथ, तो मैं आपको ग्रुप में ऐड कर लूँगा। सभी अधिकारी मेरे कांटेक्ट में तो है, आई थिंक सबकी मेरी मुझसे तो बात हो रखी है, तो काइंडली मुझे पर्सनल पे मैसेज कर दें या ग्रुप में आप मैसेज ड्रॉप करवा दें अपने व्हाट्सएप नंबर के साथ। मुकेश ऊपर है? मुकेश, प्रोग्राम यूट्यूब लाइव चल रहा है? ठीक है। उसका लिंक काइंडली ग्रुप में शेयर कर दीजिएगा। जो ऑफिसर्स नहीं आ पाए वो ऑनलाइन भी कनेक्ट हो सकते हैं।
सर
सभी ऑफिसर्स ब्रेकफास्ट किए हुए हैं? कुछ शायद बाय रोड आए हैं, अर्ली मॉर्निंग निकले हुए नहीं, तो हम लोगों का भी हाई टी की व्यवस्था है। तो हम लोगों ने हाई टी इस प्रकार से रखा है कि अगर ब्रेकफास्ट नहीं भी किए हो तो यहाँ पे सुविधा वो उपलब्ध हो जाएगी। तो लगभग 11 बजे हाई टी होगा, उसके बाद में फिर 2 बजे लंच ब्रेक होगा। लंच ब्रेक में भी थोड़ा टाइम है, तो इसलिए हाई टी हम लोग ठीक से अपना कैलोरीज ले सकते हैं ताकि 2 बजे तक कोई इशू ना हो। लंच ब्रेक 2 से 3 के बीच होगा, और लंच यहीं पे लॉन में ही रखा जाएगा जहाँ पे हाई टी है, ताकि हम लोगों का जाने आने का समय बच जाए। और डिनर वहीं सर्व होगा जहाँ पे आप लोगों ने ब्रेकफास्ट किया है, विंध्याचल मेस में। हम लोग ग्रुप में एक लिंक शेयर करेंगे डिपार्चर प्लान का, काइंडली उसको ज़रूर फिल कर दीजिएगा, ताकि हम लोग आपको टाइम से गाड़ी प्रोवाइड करा सकें आप लोगों की रिटर्न जर्नी के लिए। स्पेशली जो एयरपोर्ट स्टेशन जाने वाले अधिकारी हैं, सेल्फ व्हीकल से आए हैं तो कोई इशू नहीं है, लेकिन जिन अधिकारियों को वापस एयरपोर्ट जाना है या रेलवे स्टेशन जाना है तो वो अपना डिपार्चर टाइम स्टेशन और एयरपोर्ट का लिख करके ज़रूर शेयर कर दें लिंक के थ्रू, और उसमें यहाँ से जिस समय पे आपको गाड़ी चाहिए वो मेंशन करना है, ना कि आपके फ्लाइट का या ट्रेन का टाइम। और कोशिश कीजिए कि जो टाइम आप शेयर करें वो 24 आवर फॉर्मेट में हो। जैसे 9 बजे अगर आपकी ट्रेन है तो आप 7 बजे 1900 आवर्स का गाड़ी का डिमांड प्लेस कर दें, ताकि 7 बजे हम आपको गाड़ी दे सकें और आप 8 बजे तक। स्टेशन एयरपोर्ट जाने में लगभग 1 घंटा लगता है ट्रैफिक वगैरह के इशू की वजह चलते चलते। तो आप लोग कंफर्टेबली एयरपोर्ट कम से कम 1 घंटा पहले हम पहुंच जाएं और रेलवे स्टेशन एटलीस्ट हाफ एन आवर पहले पहुंच जाएं। प्लीज़ सेटल डाउन फास्ट, हमारे बीच में हमारे मुख्य अतिथि महोदय का आगमन होने वाला है। Chief guest sir has arrived. Jain sir. Please बैठ जाएं सभी अधिकारीगण। Thank you. Jain sir, may I have the permission to start, sir? Respected chief guest for today's inaugural session, Honorable Shri Justice Anirudh Bose sir. Respected special guest for this inaugural session, Shri Rajiv Tandon sir. Respected Director CAPT Shri Anil Kishore Yadav sir, Deputy Director Shri Shailesh Kumar sir, and all the learned judicial officers, police officers, prosecutors, and correctional service officers. It's an honor and privilege for me to welcome you all in this one-day first national seminar on juvenile justice. And first of all, as the tradition of this academy, I would like to request our respected director sir to please welcome our chief guest and special guest with a book. It's a tradition of CAPT that we welcome our guest with a book instead of bouquet. Thank you so much, sir. Thank you, sir. Sir, in this first national seminar on juvenile justice, we have judges, total 26 judges, learned judges from various parts of the country. We have 48 prosecutors and 10 officers from correctional service and 10 officers from police service. If we talk about the state-wise participation, we have officers from Maharashtra, Chhattisgarh, Madhya Pradesh, West Bengal, Karnataka, Jharkhand, Haryana, and Odisha and Uttar Pradesh. So a very good participation from almost every part of the country. And for further course of action, I would like to request our respected director sir for his opening address. And before I invite respected director sir for his address, I would like to give a brief about sir. Shri Anil Kishore Yadav sir is IPS officer of 1996 batch of Bihar cadre. Sir was born in Uttar Pradesh and he has done civil engineering and masters in English and sociology and LLB. Sir was posted as superintendent of police in various districts of Bihar like Saharsa, Betia, Jahanabad, Gopalganj, Madhepura, Katihar, Nawada, and Bhojpur. Sir was range DIG at Munger and he was on central deputation to the Ministry of Health and Family Welfare. He was IG Weaker section in the wing of CID and he was IG training of Bihar. Then sir got promoted to the rank of ADG and sir was ADG Weaker section in the wing of CID and ADG training of Bihar. Sir joined CAPT as Director CAPT on 20th November 2023. So I would like to request respected director sir for his opening address.
Jai Hind, Chief Guest of today's inaugural session, Honorable Mr. Justice Anirudh Bose, sir, Director, National Judicial Academy, special guest, respected Rajiv Tandon, sir, Honorable Member of Madhya Pradesh Human Rights Commission, my colleagues on the dais, faculty, National Judicial Academy, Madam Shruti SOBS, learned participants from all over the country. We are very fortunate to organize this program on this large scale in collaboration with National Judicial Academy, Bhopal, under leadership of Honorable Justice Sir. All are welcome on this campus, Central Academy for Police Training. This campus was inaugurated on 31st of May 2018 by the then Union Home Minister, Mr. Rajnath Singh Saab. Since then, this academy has got many opportunities to grow, and last year, when even 2023, last week of month of December, on 25th of December, when new criminal laws were enacted and notified on 25th of December, very third day, that was 27th of December, we started conducting capacity building programs. And for 5 major pillars: police, judiciary, prosecution, forensic, and prison and correctional services, we conducted many programs or on new criminal laws. So this was another great opportunity. Now, first national seminar on juvenile justice. For this, we have assembled here today. This is very important subject for at least for this 21st century. And there are very few laws who have been twice enacted in a very short span of period, that is 15 years. We are aware that Juvenile Justice Act was first enacted in the year 2000, and within 15 years, this field was so much evolved, developed further, that we had to reenact it in the year 2015. If I'm not wrongly, mistakenly quoting these years. So this suggests that how important this subject is. And JJ Act in present form is one of those largest central special acts we have. More than 100 sections, and very, though it is still evolving, as this is very recent jurisprudence globally also, in our country also. So we need to work on these issues even more regularly. So we can understand importance of such seminars, such participations, sharing of knowledge and experiences, insights on the largest, greatest possible forum nationally and regionally also. So CAPT and our organization BPR&D is feeling privileged to host such program, and we are really very, very grateful to our Honorable Justice Sir, whose inspiration and hand-holding on this topic and regarding this seminar has been very, very important and first and foremost driving force for us. We are also very grateful to our senior respected special guest Tandon sir to be here, and Honorable Justice and Tandon sir, out of their very busy schedule, they have spared their very valuable time to come here. So we welcome sirs and each and every participant delegates from all over the country, ladies and gentlemen. We are quite positive about outcome of those sessions, respective business sessions to be conducted after this inaugural session. And I am sure that as Honorable Justice Ahluwalia sir once from this podium told every participant in that orientation program, which is being conducted quite regularly by this academy regarding new criminal laws for learned judicial officers, that every one of participants is resource person unto themselves. So this I always try to tell our delegates, our participants, that with great experience and insight, our every delegate is a resource person. So it's not a one-way process of learning that some SME or some very learned resource person, Honorable Justice, and other very learned SMEs, they share their knowledge and experience, but this is both ways. This out of your experience, your insights, your very active participation, SMEs, resource persons also learn a lot. So all of you are again very welcome on this campus on behalf of BPR&D and on behalf of Central Academy for Police Training. Thank you so much. Jai Hind.
Thank you so much, sir. And now, before inviting our special guest for his address, I would like to give a brief about sir. Shri Rajiv Tandon sir is a distinguished officer of the 1988 batch of the Indian Police Service, known for his extensive experience and remarkable contribution to the law enforcement, intelligence, and administrative services. Sir was posted as Superintendent of Police in the district of Guna, Satna, Gwalior from 94 to 2001, demonstrating exemplary leadership in maintaining law and order, handling complex criminal investigations, and fostering community trust in policing. Sir held significant responsibilities on central deputation, contributing to national level security and administrative framework during this period. Sir played a critical advisory role as OSD to Chief Minister of Madhya Pradesh, managing sensitive matters, coordinating interdepartmental initiatives, and ensuring effective police policy implementation. Sir led the State Intelligence Department as its chief, overseeing intelligence operations, counterintelligence strategies, and preventive actions against threats to state security. Sir managed key assignments in the Central Criminal Investigation Department, handling high-profile cases and directing specialized investigations critical to state security and justice. Sorry. Sir was posted as Director General Lokayukt and um, has led anti-corruption measures and investigations of complaints against public officials and upholding the integrity of the governance. Presently, sir holding the charge of member of Madhya Pradesh Human Rights Commission. And now I would like to request respected Shri Tandon sir for his address.
Good morning, everyone. Honorable Justice Bose, IG Shri Yadav, DIG Shri Sailesh, Mr. Prakash, and dear participants. I now belong to Bhopal, so I welcome you to the City of Lakes. It's a beautiful town. I know it's a very small course. You people have traveled a lot. So I request Yadav sir कि आप भोपाल भी घूम के जाएं. Thank you, CAPT. Thank you, Yadav sir and BPR&D for inviting me again and again. Over a period of time, what Yadav sir was saying, I have seen growing up this campus. This provides a unique opportunity for interdepartmental officers to interact. What he said informally as well as formally. जो अलवालिया साहब को आपने कोट किया था, टोटली एग्री करता हूँ. यू लर्न मोर इनफॉर्मली और आप अपने बैरियर्स को तोड़ते हो. They have organized so many courses over a period of time, constantly regarding new laws and this, they are doing a wonderful job. As far as Juvenile Justice Act is concerned, I am asked to speak something about the new challenges. I presume आप लोगों ने Juvenile Justice Act के बारे में बेसिक्स सबको मालूम है. ऑलरेडी आप उसको एग्जीक्यूट कर रहे हो, चाहे प्रोसिक्यूटर के रूप में, चाहे पुलिस वाले के रूप में, चाहे करेक्शनल एजेंसीज के लिए या एज ए जज. बट एक चीज बोलना चाहूँगा सबसे पहले बिफोर आई स्टार्ट. One of the major stakeholders is not there, which we always forget, and I'll request Academy to take note of that. WCD, Women and Child Development Department, which is the key department, which is the nodal department for the government, they are not invited. They are not invited either by judiciary in their academy, or they are not invited by the police in their training programs. 25 साल से एक्ट का इम्प्लीमेंटेशन है. 2013 के आसपास एज ए DG CID I was taking a active role in this. There were issues, but I request in future you always invite WC department, because they play so many crucial roles on coordinating with the government. They are the one who frames rules. Yesterday I was inquiring कि भाई 2022 के बाद से स्टेट रूल्स आए कि नहीं आए. 25 साल में जो आपका JJ एक्ट है, से ट्रेवल्ड अ लॉट. इट इज़ इवॉल्विंग. रोज अमेंडमेंट्स आ रहे हैं. 2000 था, 2015 था, रूल्स आए. देन स्टेट गवर्नमेंट से जब पूछा, पुलिस में आइडिया नहीं था. देन आई कॉन्टेक्टेड समवन इन द WCD. बोला साहब हमने 2000, क्योंकि इतना इवॉल्व हो रहा है, तो 2022 के रूल्स हमने एज इट इज अडॉप्ट कर लिए. हमने अपने रूल्स नहीं बनाए. आई वॉज गोइंग थ्रू यस्टरडे सम लिटरेचर की रूल्स बिहार ने बनाया या केरला ने बनाया. अगेन दे आर अंडर चैलेंज. टेक्निकल लीगल लैंग्वेज को लेके कई इश्यूज हैं. मैं इसलिए बोल रहा हूँ इस डिपार्टमेंट के बारे में कि JJB हो या CWC हो, दे आर मेंबर्स, they are workers, their institution, they are the one who are the main regulators. How can we neglect them? I was also inquiring about yesterday, state mein around 50, I am talking about Madhya Pradesh, 55 JGB and 55 CWCs are working. They are functional. Still there are 3-4 new districts, they still have to have this. But there are vacancies of more than 30-35%. This phenomena will be there in every state. इनका टर्म 3 साल रहता है, 4 साल रहता है, और नए वाले अमेंडमेंट के बाद इतनी कॉम्प्लेक्स सिचुएशंस हो गई हैं इनके बारे में. मस्ट टू बी डिसाइड कि किस क्वालिफिकेशन के लोग जो हम करेक्शनल इंस्टीट्यूशन से एक्सपेक्ट करते हैं उनमें हैं कि नहीं है. दूसरा एक और बोलना चाहूँगा, मैं क्रिमिनल जस्टिस सिस्टम में पिछली बार आया था तब भी बोला था, आज फिर से उसको रिपीट करूँगा कि वी डोंट वर्क एज अ सिस्टम, वी वर्क इन डिफरेंट साइलोज. हम कंपार्टमेंटलाइज हैं. पब्लिक की एक्सपेक्टेशन आपसे बहुत डिफरेंट है. आप जज हो, आप पुलिस वाले हो, आप जेल वाले हो, आप प्रोसिक्यूटर हो, बट दे डोंट सी दिस कि इसका आउटकम का इम्पैक्ट अगर पब्लिक में नहीं हो रहा है, देन देयर इज नो पॉइंट अनलेस अनटिल यू मेक ए डेंट ऑन दैट. तो ये मैंने जब कल देखा 30-35%, 35 डिस्ट्रिक्ट्स में कंप्लीट हैं, बाकी में अपॉइंटमेंट हो रहा है. सिलेक्शन कमेटी जो लोगों को अपॉइंट करती है, क्या वो प्रॉपर ट्रेंड है? क्या जो लोग हमारे CWC या वेरियस CCI चाइल्ड केयर इंस्टीट्यूशंस को मैन कर रहे हैं, आर दे कैपेबल ऑफ रनिंग? कैन एनीवन टॉक टू देम? हमने अपना जज एडमिनिस्ट्रेट कर दिया, पुलिस वाले ने ला के रख दिया, हम बच्चे को आगे छोड़ दिया, पर क्या कभी उनसे हम बात करते हैं? यू कीप रीडिंग इन द न्यूज़पेपर, कितने सारे इश्यूज होते हैं, बच्चे भाग गए, बच्चों के साथ एट्रोसिटीज हो गई। देयर वाज ए केस, डेफ एंड डम चाइल्ड था, देयर वाज नो इंटरप्रेटर जो उससे उसकी बात समझा सके। उसको रोकने के लिए आपको अपने बैरियर से, स्ट्रेट जैकेटेड बैरियर से बाहर निकल के काम करना होगा। अदरवाइज जो भी इस एक्ट की मंशा है, आप अपनी नज़र में सक्सेसफुल होगे, पर पब्लिक की निगाह में, पब्लिक परसेप्शन में, आई डोंट नो, दे विल ऑलवेज क्वेश्चन कि इसका कुछ फायदा हो रहा है कि नहीं हो रहा है। आप सब लोग लॉ एनफोर्समेंट एजेंसीज हैं या जजेस हैं, अल्टीमेटली बजट तो उस डिपार्टमेंट के पास है। दे आर द वन हु रेगुलेट एवरीथिंग। अगेन लॉट ऑफ थिंग्स रेयर कि फेयर अपॉइंटमेंट होता है कि नहीं होता है। आई एम टोल्ड नाउ ए डेज CWC और CWC में 20 sittings in a month is a mandatory, and they are getting 2,000 rupees per sitting. People want to join this for getting that money. I don't know ये वास्तविकता है कि नहीं, दूसरी स्टेट का नहीं मालूम, but that is what is happening in my state. तो I have told about this training. एक और चीज जो मुझे बताइए लेटेस्ट इसके बारे में, initially UNICEF was conducting this training for various JJBs or CWCs. I don't know whether they are party to it or not. I am told UNICEF is not participating in training. एक और इशू है इसी से रिलेटेड, JJBs को डिसाइड करना रहता है सारे केसेस विद इन अ पीरियड ऑफ 4 months। क्या वो कर पाते हैं? क्या टाइम एक्सटेंशन कितना लेते हैं? और क्या उनके डीजे साहिबान मॉनिटरिंग करते हैं? These are the various questions. I don't know, you have to think yourself. No one is going to ask about that. About CCI in Madhya Pradesh, we have got around 135 CCI child care institutions, जिनमें से गवर्नमेंट रन बहुत कम है, मोस्टली प्राइवेट हैं या NGO रन है। और जो उनके NGOs या प्राइवेट रन है, एवर वी हैव थॉट अबाउट देयर वेरिफिकेशंस। दिस थॉट ओनली कम्स एज ए पुलिसमैन कि भाई उनका वेरिफिकेशन पहले क्यों नहीं कराया गया, कैरेक्टर वेरिफिकेशन क्यों नहीं कराया गया। This is the same case for special homes, child homes, and other homes also. Then there are allegations about NGOs which run these CCIs that they basically it's a means of earning livelihood for themselves. NGOs इसको इस लिए चलाते हैं, तो इस बारे में हमको बहुत सारी चीजें सोचना पड़ेगा। Another thing which has come, which I don't know whether you people are aware or not, Government of India has issued a letter कि ये जो NGO run CCI से चाइल्ड केयर इंस्टीट्यूशंस थी, वो अब प्योरली चाइल्ड वुमेन एंड चाइल्ड डेवलपमेंट डिपार्टमेंट के एडमिनिस्ट्रेटिव कंट्रोल में रहेंगी, वही उनको मॉनिटर करेगा। अदरवाइज उनको वो ग्रांट जो सेंट्रल गवर्नमेंट का कंपोजिशन था वो नहीं मिलेगा। एक और जो इसमें चीज आई, जो इंटीग्रेटेड चाइल्ड प्रोटेक्शन स्कीम थी, उसका दे हैव चेंज द नेम, मिसल वात्सल्य कर दिया है, और वो फंडिंग उसी से एसोसिएट कर दी गई है। मैम, सिंस द टॉपिक गिवन वाज की चैलेंजेस, उसके बारे में बोलना चाहूँगा मैं। व्हाट करेक्शनल मेजर्स वी कैन टेक, वन ऑफ द मोस्ट इंपॉर्टेंट थिंग दैट कि ये जो डीजेस की मंथली मीटिंग होती है, जिसमें डीजेस SP एंड कलेक्टर पार्टी रहते हैं, उसमें व्हाई नॉट इश्यूज रिलेटेड टू JJ एक्ट कैन बी हाईलाइटेड। व्हाई नॉट मेक पार्टी टू देम कि भाई पॉलिसी लेवल डिसीजंस हैं, बिकॉज पुलिस वालों से आप पूछ लेंगे, दे विल ऑलवेज से कि हमारे पास फंड्स ही नहीं है। वुमेन चाइल्ड डिपार्टमेंट बोलेगा सब हमसे कभी मांगा ही नहीं पैसा। तो देयर आर लॉट ऑफ इश्यूज व्हिच हैज टू बी रिजॉल्व्ड इन दोस काइंड ऑफ मीटिंग्स। दिस एक्ट वाज अ मल्टी एजेंसी एक्ट, जिसमें पहली बार जुडिशरी एंड पुलिस से पॉजिटिव एक्सपेक्टेशन था कि हम उतना कर पा रहे हैं, एंड इसमें एक्सपेक्टेशन था कि हम अपने अपने साइलो से बाहर निकल के उनके लिए काम करेंगे। तो दैट सिनर्जी वी हैव टू डेवलप। दूसरा एक और है, इसमें जो लोग पोस्ट होते हैं, आई नो हम लोग का एडमिनिस्ट्रेटिव पोस्टिंग होती है जो भी जहाँ जाता है, बट वी नीड टू हैव दैट काइंड ऑफ एटीट्यूड, पॉजिटिव एटीट्यूड, माइंडसेट हमारा होना चाहिए, जिससे कि इसके बारे में हम सोच सकें। बीच में जो 2014-15 में बचपन बचाओ वाला जजमेंट आ गया था, उसके बाद से देयर हैव लॉट ऑफ चेंजेस हैव कम। People have started taking these things very sincerely, carefully, कि the moment missing report is come of a juvenile case, proper register होता है, proper investigate होता है। परंतु उसके बावजूद भी lot of things are still to be desired. I have told about motivation. Then another thing is more important is about the incentive. The persons who are doing good job, they have to be properly incentivized. उनको अगर reward नहीं मिलेगा तो उनके पास motivation नहीं रहेगा. We are living in a digital world. आज की तारीख में जिस तरीके से फैमिली टूट रही है, जुवेनाइल बच्चों के प्रॉब्लम, सोशल मीडिया, आईटी करण जितने अफेक्ट हो रहे हैं, उसका अफेक्ट और ज्यादा आएगा. तो ये एक्ट उस मामले में और इवॉल्व करना पड़ेगा, कॉन्स्टेंटली हमको उस पर भी करना पड़ेगा. हर बच्चे को उस तरीके से हमको क्रिमिनल ट्रीट नहीं करना पड़ेगा. पुलिस वालों के लिए एक और चीज बोलना चाहूंगा. पुलिस वाले चूंकि यहाँ पर हैं, जनरली जो ऑब्जर्व होता है, जब भी आप बच्चों को लेके आते हैं, यू ऑलवेज कीप देम इन लॉकअप्स. डोंट कीप देम इन लॉकअप. आई नो देयर आर कॉन्स्टेंट कि आपके पास स्पेशल जुवेनाइल पुलिस यूनिट्स नहीं है. इट इज एक्सपेक्टेड कि थाने से ही हुआ जाएगा, पर लेकिन और साथ ही साथ लॉकअप में उनके साथ वैसे ही बिहेवियर करते हैं, विच इज नॉट एक्सपेक्टेड फ्रॉम देम. उनका जब कैरेक्टर वेरिफिकेशन होता है तो उसमें भी गलत रिपोर्ट दे देते हैं, जबकि एक क्राइम, सो कॉल्ड क्राइम जो भी बच्चे के द्वारा है वो क्राइम नहीं माना गया है, उनके वेरिफिकेशन रिपोर्ट में अगर आप मेंशन कर देते हो, इट अफेक्ट्स देम ए लॉट. तो ये चीज़ें हमारे को देखना है. बट अगेन बिफोर क्लोजिंग मैं सबसे पहले बोलना चाहूँगा कि जहाँ भी आप रहे हैं, आपकी जो ये DCPUs हैं, उनको एक्टिवेट करने के लिए जो जुडिशरी के हमारे साहिबान हैं, बिकॉज दे आर द वन हु हेड्स JJBs एंड दे कैन प्ले a positive role and they have authority to do that. They should play a very positive role. Again, I thank Mr. Yadav for inviting me and giving me this opportunity to interact on this topic. Thank you very much. We hope to see this act again evolves and you people do a positive job in this regard. Thank you. Thank you very much.
Thank you so much, sir, for your words of wisdom. And now, before inviting our chief guest for his inaugural address, I would like to give a brief about sir. Honorable Mr. Justice Anirudh Bose, sir, right now holding the charge of Director, National Judicial Academy. After a career as a practicing advocate, Justice Bose, sir, was elevated as permanent judge in the Calcutta High Court in the year 2004. On August 11th, 2018, sir took oath as the Chief Justice of the Jharkhand High Court. He was elevated as Judge of the Supreme Court on May 24th, 2019. And sir retired from judiciary on 10th of April 2024. So I would like to request our respected Chief Guest, sir, for his inaugural address.
Good morning. I've come here several times in the past, so this CAPT is as familiar to me as my own institute, National Judicial Academy. And I thank Mr. Anil Kishore Yadav for this. I also welcome, I'll address you today. But before that, I thank Mr. Rajiv Tandon, who's given me new insights into this whole question of administration of juvenile justice. Then Mr. Prakash and Mr. Sailesh, we have been talking to each other for a long time for organizing various programs. In our programs also, Mr. Yadav has come whenever we have requested him. So this is a good synergy in two institutes, All India Institutes in Bhopal. Coming to the topic on which you shall be discussing, so this is slightly different from traditional criminal law in its application. The perception of people of criminal law is that the guilty should be punished. Not many people whenever I read the newspapers or watch TV serials, not many people are thinking of not punishing the innocent. So that somehow is not in our public psyche. And all of us who've done law have read there are three theories of punishment. The first one is retributive, which we always say doesn't work anymore. But in some of the law enforcers and the judges, etc., it is still a strong factor, unfortunately. The second one is deterrent, that you punish him so much or in such manner that no one else commits the crime. And the most important, and which is not in high priority of thinking of the criminal justice system, is reformative. Now we have named our jails reformatory, but that also we forget. Even in our orders we write mostly send back to jail. So that's we have to come out of this shell. Now juvenile justice system is wholly geared towards reform. We have senior policemen on the podium, and I think they will agree that no child anywhere in the world is born with propensity to commit crime. It's a flaw of the society in a way, or the family or the community, which drives people into crime. I don't know whether any study has been done or not, but one minister of France during Mr. François Mitterrand's cabinet, he was a lawyer and he was an abolitionist so far as capital punishment is concerned. He said that I haven't come across a single offender who was a born criminal. So far as children are concerned, if there are too many juvenile offenses, society has to introspect. But we cannot think for the whole society. That is the job of social engineers, planners, policymakers. But in this unique platform where the Qazi, Kotwal and Abhiyojak, I couldn't find a colloquial word for prosecutor. I asked my companions on the podium, but just Madhya Pradesh Hindi, which it is Abhiyojak. So we are meeting on rare occasions. 30 years back, 40 years back, the thinking was no. These might diminish the autonomy of each of these wings. But today, over a period of time, it's my personal realization also that if we meet together for dealing with a broad subject, not of a particular case, all these three wings of the justice delivery system mutually benefit. Now, a differential approach of the children can be traced back to the original Indian Penal Code, under which children under the age of 7 were not presumed to possess the criminal intent. Between 7 and 12, some inquiry was necessary, which is broadly the. Then there was a jail committee report of 1919, 1920, which made several recommendations for prison reforms, which included detaching juvenile offenders from the main offenders. Because again, all of us, in a way, there is a thinking that if you send a one-time chance offender into the clutch of seasoned offenders, this person comes out as a criminal. From 86, we are having special law on juvenile, but before that there was Children Act and rules guiding Bostel schools, vagrancy homes, but these words again we are not using anymore. They have a negative connotation. This legislation emphasizes on the welfare and best interests of child, especially care, protection, social reintegration and adoption in a child-friendly approach. But the challenges which juvenile justice system is facing in India relates to one of the big challenges relates to use of the juveniles for committing offense. The place I come from, West Bengal, the cross-border criminals, they are very often using the juveniles for smuggling in general and particularly drugs, narcotic substances. The other aspect is making assessment of age of an offender. Well, while I was discharging my duty in the court, one case came to me of a death row prisoner who had suffered 28 years of imprisonment. That it transpired that he was a juvenile at the time of committing the offense. So his plea for clemency was pending before His Excellency the President. But all these proceedings had to be dropped and he had to be released because he had suffered more than 3 years. He didn't put up the question, but he didn't possibly know also that there's something called Juvenile and Juvenile Justice Board. The present day reality is also that vulnerability of the children are misused by adults, and as I said, they are being used in committing offenses. The seminar provides a unique forum where various stakeholders in the juvenile justice system are present. But as chief guest Mr. Tandon points out, one of the essential stakeholders are missing. Maybe the next time they would be invited, and from our academy also we'll try and call them. We are having several programs on juvenile justice, and one of our representative faculty members, Ms. Shruti, she's edited a book on juvenile justice, which I found very effective. This workshop provides an avenue to discuss the issues and challenges in the juvenile justice system And I'm sure this seminar will result in constructive discussion and identification of solutions and best practices to tackle the present day concerns in the juvenile justice system. And I thank the Academy for organizing this seminar on this crucial subject and also for calling me here. Thank you very much.
Thank you so much, sir, for blessing us with your presence and guiding us, and for well wishes and giving insight about the subject. And now I will request our respected director, sir, to please present memento to our chief guest and special guest as a token of respect. Thank you so much, sir. And now I will request Shri Sailesh Kumar, sir, DIG Deputy Director Training, CAPT, to deliver the vote of thanks.
Jai Hind, sirs, on the podium, and Jai Hind to all the delegates who have come from all corners of this great country, and all the CAPT staff, they are present here. I thank our chief guest, Justice Bose, sir, for coming to this occasion and gracing this occasion and also giving his insights about juvenile justice. Sir, I hope this will be a guiding factor for all of us. I also thank our special guest for this occasion on first juvenile national level seminar, our Tandon sir, who has been coming on earlier occasions also here and gracing various occasions, for coming here and giving and talking from his heart. Thank you, sir, for your valuable guidance. I thank our director CAPT for giving us dynamic, progressive and bold leadership for organizing this type of seminars and various courses in Central Academy for Police Training, which is the flagship training center of BPR&D. I thank all the distinguished participants present here in this auditorium for coming and making a very valuable contribution. I thank our colleague, Conference Secretary Mr. Prakash, for making a lot of hard work for organizing this event. I thank every member of CAPT who is involved in making this program a success. Last but not the least, I thank BPR&D headquarters for giving us this occasion and giving us this responsibility to hold this. I wish all the success for this successful conduct of this seminar. Thank you very much. Jai Hind.
Thank you, sir. And now I will request all the officers to please rise for the national anthem.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उज्जल जगति तरंगा तब शुभ नामे जागे तब शुभ आशीष मागे तारे तब जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you. And now you can place all of your belongings in the auditorium and join us for the photograph session followed by high tea. Thank you.
On juvenile justice, something very important for the judicial system, because you see, children are the most valuable asset of a family, of a society, of a nation. And when we talk about the juvenile, so now, as per the international conventions and norms, which has been adopted by the India also, a juvenile is a person who has not attained the age of 18 years. So means below 18, a person is considered to be juvenile, जिसे कहेंगे हिंदी में किशोर. And when we say juvenile delinquency, so delinquency means a deviant behavior of a juvenile, which is not only not conforming to the social norms, but it is also violating the legal norms. So in this first session, I am going to share with you and discuss with you that what is the overview of the juvenile justice jurisprudence, when we say jurisprudence, then what does it exactly mean? Jurisprudence means the philosophy behind the law, a set of values or set of rules which has given rise to a particular legal framework. That is the jurisprudence. And when we talk about the jurisprudence with regard to the juvenile justice, occasionally I shall be referring to this write-up. By and large, I shall be just speaking with you. बाद में दे देंगे, कोई पहले ये कर ले। ऑनलाइन चल रहा है, नहीं अभी इतना तो काफी है ना। अभी इसको रहने दीजिए आप ऐसे। So, the juvenile justice jurisprudence, meaning thereby the framework of law and the philosophy behind it dealing with juvenile delinquency. Now you see that most of you must be aware of the Indian Penal Code, section 81 and 82, which is now substituted by the Bharatiya Nyaya Sanhita. So now section 81 provided that a child below 7 years of age is duly incapable, meaning that incapable of committing any offense, duly incapax. And section 82 further provided that a child between 7 to 12 years can be considered to commit an offense if he understands the nature of his act as well as the consequences of it. This was something with regard to the juvenility and the basic perception about the juvenile justice that related to the procedural aspect. And the procedural aspect was that the juveniles should be dealt with by a separate system and not by the regular criminal justice system. The approach behind this thought has been that the child which has come in conflict with the society and consequently in conflict with the law is not responsible for that. The responsibility lies exclusively with the society, with the family, and with other socio-economic and cultural factors which somehow created a dent in the personality of the child. There may be social factors that a child feels deprived of what he is entitled to. There may be family factors that the parents are not caring or parents are belligerent. There may be economic factors as well, that even the basic needs of the child are not, satisfied. So all these things in one way or other give rise some sort of resentment in the psychology of the child. Initially, this resentment is towards the family members. But if there is suppression of the resentment by the family, instead of trying to understand the causes of resentment and to do away with those causes, then what happens? This resentment travels beyond the four walls of the house, moves to the society. And again, you see, most of the time, the society is totally uncaring about the needs of the children. Of course, if there is a hurling of abuses by the child or pelting of stone by a child, maybe aged about 12, 13, 14 years, on your house, what is your first reaction? What is your first reaction? If it happens that your neighbor's child house abuses upon you and is also indulges in stone pelting on your house, what is your first reaction? Your reaction would be that the parents of this child are totally uncaring. The upbringing of this child is not proper. बच्चे को बिगाड़ के रखा हुआ है, बच्चे को ठीक से संभालते नहीं, बच्चे की केयर नहीं की, कैसा बना दिया है, क्या बनेगा आगे चल के. So that reflects that ultimately the parents, the guardians, the caregivers, the near and dear ones of the child, they are responsible for the deviant behavior of the child. So we can say that child is not a offender. He is a sufferer. She is a sufferer. Sufferer of what? Sufferer of familial and social negligence, uncaring, etc., etc. So this philosophy of law basically stems out from the fact that no one is a criminal by birth. Criminality is not there in any child. It is the circumstances surrounding the child which gradually breed criminality in the mind of the child. And child is not aware at that time that what I am doing is a crime. The child is simply expressing resentment against the system, family system and the social system. Therefore, the approach of the law, almost since the beginning of the 19th century, has been that the law and the legal institutions should take care of the child. And the child, instead of being treated as a criminal and dealt with as a criminal in the regular criminal justice system, should be treated separately and should be treated in the manner so that he or she can be brought back and reintegrated with the society. Rehabilitation in the society, reintegration in the society, just trying to improving the psychological approach of the child so as to make him a useful asset of the society instead of a problem to the society. That is the basic philosophy behind the juvenile justice jurisprudence. Even before enactment of Indian Penal Code, we had an enactment made by the Britishers, that was Apprenticeship Act. So if a child up to 18 is found guilty for commission of an offense, then instead of being sent to the jail or prison, he or she will be sent to the apprenticeship where he or she can learn something to become a useful member of the society. That was the approach we had in 1850. Then in 1892, again this law was brought with more modifications. After independence, in 1960, first serious attempt was made to address the delinquency of a juvenile. I have explained what is delinquency. A behavior unconforming to the social norms and the legal norms. That is delinquency. We will call that person a delinquent juvenile. Now this word has also been abandoned. You don't find this word in the Act of 2015. Gradually, the entire terminology is being improved. You don't find a word like trial in the JJ Act of 2015. No trial, no criminal, no offender, no accused. These words are totally missing in the Act of 2015. So this Act of 1960 was the first serious attempt to do something with regard to the juveniles who have been found delinquent, and in terms of the latest terminology. What is the latest terminology for a delinquent juvenile? A child in conflict with law. And exactly this is the proper term, because this conflict starts with the family, travels to the society, and goes to the limit of just violating the legal norms. So that is a conflict with the law, that is a conflict with the society, that is a conflict with the family. And that's why Act of 2015 very carefully adopts the term or expression, the child in conflict with law. So, if there is a conflict, then how to deal with it? Now, the Act of 1960 was an initial attempt, it's a very rustic attempt to deal with the problems. But after the Beijing Declaration of 1985, that we know is the United Nations Charter on the Rights of the Child, and considered to be the first and the most effective Bill of Rights for the children, the India has to reenact the law relating to juveniles. And then in 1986, just after 1985, we enacted Juvenile Justice Act 1986 to bring our law in sync with the international norms and international requirements to deal with the juvenile. Going further, another attempt was made. In between, we had the declaration of 1989 and two declarations of 1990. And after these three declarations, in 2000, we have a new law. That was Juvenile Justice Act 2000. So by that time, whatever international developments took place, they were incorporated in the enactment. The law was made more child-friendly. And the latest enactment of 2015 can be considered to be a very serious and sincere attempt to bring the law in conformity with the international norms with regard to child in conflict with law or child in need of care and protection. Subject to one or two exceptions, we will discuss about that. So now one thing is clear. You see, when we sit as a magistrate, or when we discharge our duties as a police officer or a prosecutor, our entire outlook is very rigid. We see crime as a crime and the person violating the law as criminal. Nothing less, nothing less. So you see, when the child in conflict with law is brought before the Juvenile Justice Board, the attitude of the magistrate. I have seen the system very closely because I am in the system since 1980. So it is almost 43, 44 years that I have seen the system very closely from each and every corner. So I can say that the attitude the magisterial attitude is there, or the police attitude is there, or the prosecutorial attitude is there. Nobody is going to acknowledge and consider that this child is the sufferer of the situations made by the society. And accordingly, despite legal mandate, we start dealing with the child in black and white according to the law, and otherwise in accordance with our own perception of criminality. This dichotomy is always there when we are trying to implement the law, and the greatest challenge for us as duty holders in this juvenile justice system is to remove this dichotomy, to consider a child as a, you see, as a sufferer and sufferer of the social situations, familial, social, psychological, and economic. This is a very difficult task. And the seminars like this, I have held so many seminars on juvenile justice system almost since 2003, 2004. So the challenge before the duty holders is to just bring their approach and attitude in sync with the philosophy of juvenile justice and to conduct accordingly. A difficult task, but not impossible. Now, next we come to that ultimately, what is this framework of law, which is before us in the shape of JJ Act 2015. So, instead of just, if I start reading section wise, the time will be too less and there will be a lot of gap, what I say and what you understand. So we have to find out a way that we can understand the scheme of the law. So we can divide this law conveniently into 5 parts. In the first part, we will put the definitions, the principles governing the law of juvenile justice, and certain miscellaneous aspects which are given in the 10th chapter of this enactment. So you can say chapter 1, chapter 2, and chapter 10. They can be put together in one bracket. And that is that what itself is the act, why it has been brought, what are the definition of various expressions used in the act, what are the governing principles behind the various provisions of the Act, and what are the miscellaneous aspects. That is part 1, chapter 1, 2, and 10. Now we can put chapter 3 and 4 in second bracket, dealing with the child in conflict with law and the institution created for that purpose. So chapter 3 deals with the constitution of Juvenile Justice Board, its duties, its functions, and chapter 4 deals with the procedural aspects governing the inquiry with regard to child in conflict with law. We will stop, we will pause for a while here, because child in conflict with law is very clear to you. Any confusion with regard to that? Child in conflict with law? Any confusion? A child below 18 years who is said to have committed a offense under the IPC or under any other law. Right? Now, in a parallel fashion, this act also deals with another type of child who is not in conflict with law, but who is orphaned, abandoned, mishandled, mistreated, abused, or in any manner not properly dealt with by those who are under an obligation to deal with him or her properly, including parents. Neglect in upbringing also is included. Abandonment is included. So now there are two child. One child in conflict with law. For that we have a JJB, Juvenile Justice Board, contemplated in chapter 3, and the entire procedure contemplated in chapter 4. Now this another child in need of care and protection. This has also received tremendous, attention of the legislatures, and they have just stipulated a very comprehensive scheme with regard to child in need of care and protection. Why? Can we contemplate why? This child in need of care and protection, if not dealt properly and provided proper care, is bound to jump into the area of conflict with law. Sooner or later, it is going to happen. So if it is not treated, not provided the proper means to develop his or her personality and potential, it is the end result that he or she will become a criminal, will come in direct conflict with them. So therefore, better to deal with this child so as to provide him what is due to him or her as a child. And that's why we have chapter 5 and 6. Chapter 5 contemplates an institution known as Child Welfare Committee, CWC. And now this CWC, which is a 5-member body, including the chairperson, has to deal with all those children who have been brought before it, who are in any manner neglected, abandoned, orphaned, ill-treated, whatever. So many things. The big list is there in the definition of child in need of care and protection. There are some 12 to 14 clauses that who is a child in need of care and protection. So now if this child is brought before the CWC, Child Welfare Committee, that is contemplated in chapter 5, then this child has to be dealt with according to chapter 6. The detailed procedure is provided in chapter 6. Then chapter 7, if I remember correctly, deals with the rehabilitation and reintegration of the child with the society. Because the purpose of the law is not to punish the child, despite the fact that the child has been found in conflict with law. That is not the object. There is no trial, there is no punishment, there is a finding. And the finding is not of guilt. Finding is about whether the child is in conflict with the law or not. Meaning thereby, whether there has been violation of a legal norm amounting to a crime. So in all these cases, and including the cases where the child is in need of care and protection, the child has to be rehabilitated. Punarvas hona chahiye. And reintegration of the society. Because this child has traveled away from the family and the society. He is having a grudge against the family and the society. He or she is having a grudge against the system itself. So there should be efforts to realign the child, to reintegrate the child with the society, so that the child becomes a valuable asset of the society. So that is dealt with in chapter 7. Then there has been a serious issue with regard to these children who are in need of care and protection. For the reason that the caregivers have abandoned their duty. Who are the caregivers? Natural caregivers, parents, very near relatives. If parents are dead, then there may be uncle, there may be aunt, there may be brother, there may be sister. They need to provide that care. That is the social norm. But they have failed to do. So now you see, one of the philosophy of juvenile law is non-institutional support to the juvenile. So here we have to understand what is institutional support and what is non-institutional support. Right? Now, when a child is found in conflict with law, during the inquiry, the child can be put in the observation, not detained. You see, words are very important. We can't say that the child has to be detained or should be confined in the observation. Child has to be put in the observation home. Observation home, as the name suggests, is simply to observe the activities of the child during inquiry, and also to provide some support during that period. Then there are children home, where the children who are sufferer of the neglect of care, etc., they are brought before the CWC and then they are put in the children home. So you see, the words are very beautiful. Home, observation home or children home, a place of safety. Home should be a home. It should not be a detention place. But unfortunately, I have been visiting these observation homes and children homes since 2005, exactly speaking, for last 20 years. And latest, within last year, I visited 2 homes, one at Morena and another at Gwalior. Visited with set areas in which I have to collect the information from the home itself. And of course, the district was accompanying me. I tried to ensure that no information about my visit to the observation home reaches the observation home before I reach there. So I found still in 2022 and 23, the things in very poor shape. 10 to 20 children just in a small hall like this, where you see dirty linen, the quality of food very poor, and the law stipulates that there should be a person of supervisor in the home who is well versed in the child psychology. And what I found, a class 4 employee working as a guard simply to escape the children from that home or from that facility. These are the things still involved. We need to understand them. And we need to understand them for the reason that we, being the duty holders, have a responsibility to see that the things improve. तो अभी भोजन तो हुआ नहीं है, नींद आ रही है, जी नाश्ता ज्यादा हो गया, ट्रैवल ज्यादा हो गया। ऐसा तो नहीं कि जो कुछ मैं कह रहा हूं उसमें काफी कुछ इतना बोरियत भरा हो कि नींद आने लगे, ऐसा होता है। I had the first hand experience like when I was director, I will call someone to deliver a lecture. I have to sit beside him. And sometimes it was very difficult to prevent this nap or the sleep, though I was the director. Because the speaker is speaking such a monotonous tone that you can't prevent. तो ऐसा तो नहीं है, अगर है तो कुछ सुधार करें। इसीलिए मैं बीच बीच में आपसे सवाल भी पूछ रहा हूं, जिससे कि आप जो है थोड़ा सा जागृत अवस्था में रहें। So we were talking about the institutional rehabilitation and non-institutional rehabilitation. The law favors non-institutional rehabilitation, or basically for good reasons. क्योंकि to do anything, the shape of these observation homes, children homes, safety homes is not going to improve much unless there is a missionary spirit to help by heart, and that may not be there by the time we are feeling that we are simply a government servant doing something for salary. That is not possible. Now, institutional care has to be substituted as far as possible by foster care, by group foster care, by providing a scheme for adoption, parenting, adoptive parents may be there, and there is, you see, a lot of demand for adoption. So, chapter 8, in very, you see, detail, provides provisions that how this adoption can be ensured with regard to the children who are free to be adopted. Free to be adopted means the children who cannot be integrated with their natural family because either the family is non-existent or non-traceable or non-willing, unwilling to take the responsibility of the child, authorized. So in all these cases, the effort has been that child can be given to willing adoptive parents who can take care of the child. And there may be, you see, foster care is something different from adoption. So if suppose I, as a person, ready to accept a child simply to foster him, to provide him care and shelter till he or she reaches the age that he can or she can look after himself or herself. So that is foster care. But then the best idea contemplated in this Act of 2015 is adoption. And this adoption is secular in nature. Religion, caste, region, no bar. Anyone can adopt anyone, except that a single male cannot adopt a girl child. And for, you see, precautionary arrangement. If there is a couple, they can adopt. So this entire scheme is provided in chapter 8. And then we have chapter 9. Shruti may correct me if somewhere I forget something. Now this chapter 9 is a very special part of this enactment. You know what is provided in chapter 9? How many of you are aware with chapter 9 of the JJ Act 2015? How many? Please raise your hands. None? None. Should I take it none is aware of chapter 9? I think 26 judges are here. ये तो बड़ा वेग बात हो गई पनिशमेंट के संबंध में, किसको पनिशमेंट देंगे, कब देंगे, कैसे देंगे, क्या करेंगे, कुछ पता नहीं, इतना। And you see, you are judges, you are police officers, you are prosecutors, you are coming to attend a workshop or seminar on juvenile justice law. You need to be basically aware about the framework, if not the nuances and niceties of the law. Right? So, this chapter exhaustively deals with various offenses which can be committed by anyone against a child. And it stipulates the punishment, and it stipulates the forum as well before whom the person has to be tried. If it is a serious offense, we will come to just serious offense, heinous offense, and simple offense. So there are a number of offenses, including but not limited to abandonment of child by parents. अगर माता पिता ही बच्चे को छोड़ दें, abandonment, serious neglect also amounts to abandonment. कुछ करना नहीं मुझे, ठीक है, बच्चा सो जाएगा, जाग जाएगा, बाकी कुछ कर लेगा, सड़क पर चला जाएगा, कुछ बैगिंग कर लेगा, हमको आके भी पैसे दे देगा, खुद भी पेट भर लेगा. This is abandonment. So all the possible, including this trafficking in children, abandonment of the child, inflicting any sort of pain, injury to the child, and so many, you see, if you go through the chapter, that will require a separate session to discuss the things. So that deals with the offenses against children. Very important. So that way we have 5 classified parts, of course 10 chapters, but then this classification is helpful in understanding the scheme of the law. So one is the introductory part, definitions, principles, and miscellaneous provisions. Second is the part relating to Juvenile Justice Board and the inquiry procedure before the board. Third is the constitution of the CWC and the procedure to be adopted by the CWC, right? Fourth is the adoption, and fifth is the crimes against children. So that conveniently we can have the entire, overview of this act. Now, what has been done in this act? Something new. We come to that. And first thing is that hitherto, or to say up to 2000, we do not have any guidelines. So what should be the principles which will guide the duty holders in discharge of their duties under the Act? Now, Section 3 of this Act very clearly, very elaborately, and very effectively provides the principles. 12 to 14 principles are there. But then most basic and important ones are 4 to 5. And the first is best interest of the child. So throughout the scheme of the Act, whether you are navigating the things as a board, whether you are navigating the things as a CWC, whether you are navigating the things as a court, just entitled to just do about the adoption matters, whether you are doing the things with regard to the offenses, best interest of the child should always be there in the mind of the duty holder. Now, what is best interest of the child? How to define it? That is the question. Best interest of the child is social welfare of the child, emotional well-being of the child, psychological well-being of the child, intellectual well-being of the child, and the environment in which the child is living, that thing. So all these things has to be considered again and again when a board or a CWC or a agency dealing with the adoption is going to transact the affairs or to pass an order. These things should always be done. The third thing is that dignity of the child should be throughout maintained. So see, right from the very beginning till the last breath, everyone is entitled by way of human right to dignity. But in our social setup, the children are something who are denied the dignity simply because they are children. छोटे तो हो, अभी से ऐसी वैसी बातें करते हो कि बराबरी की बातें करते हो. अरे why not? Why the child should be deprived of his or her natural rights? Right to live with the dignity is a natural right. It is a right, human right, and also a right contemplated under Article 21 of the Constitution of India. Then, right to privacy and confidentiality. You see, whatever is being done by a board or by a CWC or by any agency with regard to the child should not be go to the publicity in a manner so as to disclose the identity of the child or the whereabouts of the child, or we can say credentials of the child, because that may just go against the child himself. बच्चे की शादी होने वाली है. It is found that he was brought up in a facility under the Act. Now there will be some problem. So all these things should be totally private, confidential. Then the next principle is the principle of non-stigmatism. No stigma. No stigma for the reason that child is in conflict with law. No stigma for the reason that child has been found abandoned. No stigma for the reason that he or she is an adopted child. No stigma for the reason that some child, some foster care was provided to the child. No stigma for any reason whatsoever. That is the approach. तो पहला ही पेज अभी तक आगे नहीं बढ़ा ना. Let us see. ये हमने कवर कर लिया delinquency, neither hereditary nor anybody is born criminal. Social ill, we have covered it. These offenses are increasing. NCRB records are very clear. Constitutional mandate is there. What is the objective? We have been right now dealing with when we were discussing the principles. So one of the principle is rehabilitation and reintegration of the child. Non-institutionalized support to the child. This is also a principle. So these are the principles which should always be there in our mind. As I have been told, I think 90% of the participants here are not dealing with the juvenile justice system. Is it correct? So now you will go back, will involve in your duties, regular duties, and after 2 or 3 or 4 weeks, you will forget the things. So entire exercise is going to be a waste. Is it so? Or you will try to spread this message to those who are involved in the JJ work. Please discuss these things with them. Sit with them over a cup of tea and discuss that you attended a program. Of course, you are not directly involved in the discharge of the duties, but there are others. You can share it with them. Please mind it. So, we have already covered causes of delinquency. We have already covered historical development, guiding principles. We have covered. Non-stigmatic, we have covered. Non-penal treatment. Now, what is this non-penal treatment? You see, the inquiry by the board is not to ascertain the guilt. It is to find out what were the circumstances which made the child to violate the law and how he can be reformed in the future. That is the approach. So it is not a law to punish anyone for commission of a crime. Keep it very clear in your mind. Tell it in so many words to your colleagues who are working in the JJ boards or in the CWC that it is not a penal. It is a support system. It is there to find out the needs of the child. It is there to provide all-round support to the child who is either in conflict with law or who is either, you see, in need of care and protection, right? Then international norms we have already discussed. ये 90 के दो हैं, Havana rules and Riyadh guidelines. Then we have already discussed child in conflict with law, child in need of care and protection. Now we come to these offenses. Now one new thing which we find in the Act of 2015, that the offenses have been classified into 3 categories. So there are offenses, simple sitter, punishable up to 3 years, right? Then there are offenses which are punishable with more than 3 years but up to 7 years. And these are the first one is up to 3 years petty offense. Second one from 3 plus to 7 serious offense. And if it is more than 7 years, then it is heinous offense. Here there has been you see, juvenile justice jurisprudence never acknowledged or considered any offense qua a juvenile as heinous or serious. It was always in conflict with law. But with that incident, infamous incident in Delhi, that is कौन सा? So that ultimately force the lawmakers, force the society, force the people concerned with these affairs, that ultimately something should be done. Something should be done. A committee was constituted under the chairmanship of Justice J.S. Verma, former Chief Justice of India. And on the basis of the recommendations coming from the committee, as well as the social outcry, the law was little made classified that if an offense falls in the category of heinous offense and the child is above the 16 years of age, plus 16 or above, then such a child can be tried as a regular adult offender, but not in a routine manner. Again, first thing, the Juvenile Justice Board, if finds that the child is plus 16 and a heinous crime is said to have been committed by the child, then the board will conduct an inquiry into the psychological factors of the child, the background of the child, whether the child was aware of the consequences of the act, what led to the commission of the offense, and after collecting inputs from the psychologists, child psychology experts, the board will decide whether this child should be tried as a regular adult offender or should be tried as a juvenile. The decision given by the board in this regard with reasoning can be challenged by either party, by the state or by on behalf of the juvenile before the children court contemplated under the POCSO Act and the Children Act, and that court, which may be the POCSO court, maybe the children's court, or maybe if not both the courts not available, then regular session court can reconsider the entire things, can send the child and ought to send the child for further examination by the psychological expert independently, and on the basis of all the inputs has to decide whether the order of the JJB has to be sustained or has to be reversed. If the order is sustained, then this court will conduct the trial against the juvenile according to the JJ Act. And if the court finds that no, he has to be treated as an adult offender, so then again the trial will go before the children's court and the person will be treated as an adult offender. The procedure will be as per the Code of Criminal Procedure or Nagrik Suraksha Sanhita 2023. ठीक है? अब इसमें the question arises that if the child is below 16 years and is accused and is found to be in conflict with law with regard to petty offense, with regard to serious offense, or even with regard to heinous offense, but not facing regular trial or trial as an adult, then what should be the further course if he or she is found in conflict? So then there can be the maximum, what we will say, should we say confinement? No. Keeping the child in a facility or in a home where the child can be provided with psychological support, social support, educational support, so as to improve his personality. That is the maximum period of 3 years. So in Nirbhaya's case, that I think third or fourth accused was found to be juvenile, was sent to the home only for 3 years and thereafter let out. But if the child is treated in the age group of 16 to 18 as a adult offender, then what should be the course? In that situation, subject to the nature of the offense, this child can be punished with imprisonment up to life, depending upon the punishment prescribed under the law. But this punishment shall not extend to the entire life. So it will be again for certain years. In between, there will be review of his condition. If it is found that he is improving, then he can be just allowed to live. And no death sentence can be inflicted. That is a clear-cut matter. So no death sentence, no life imprisonment extending to the life, but any other sentence can be solved. Then now suppose the child is 17 years old, the trial has been as an adult, the punishment has been inflicted. Up to 21, he or she will be kept in a facility under the JJ Act, and thereafter he or she will be shifted to the jail, prison. So that these are the things which are a bit different from the international norms. But you see, as a sovereign country and a country having its own problems, its own peculiarities, the legislature is at liberty to enact a law which serves best interest of the child as well as of the society, because society is not persona non grata, right? So this is about these three offenses. Then we have already just seen salient features, right? We have discussed the adoption. So we have also discussed this. New offenses, we have already discussed this. Then there are so many, say, children institutions, children facilities. Prior to 2015, anyone was doing in any manner without adhering to the basic norms to conduct the institution. Now, registration of all the governmental as well as non-governmental institutions has been made compulsory. And it simply means that every institution has to adhere to the basic, provisions, basic requirements that have been made in the Act and the rules with regard to such institution. So we have already discussed it. Now, what are the challenges? And you see, the most serious issue with regard to the effective implementation of this law, right from the very beginning, to say right from 1986, has been that firstly, the duty holders are not at all conversant with the child psychology. They don't understand what is the child, don't understand what is the child delinquency. They don't understand how a child has to be treated. Long back, I was going through a fiction that was on a juvenile delinquency. I could not complete it, but I think 1 or 2 chapters I went through. And that was with a child which is given in the foster care of a lady. And the lady is a social activist. And this child is, unmanageable child. So now for the first 30, 40 days, this lady is grappling with the child, how to just take the child into confidence without inflicting pain. That lady is there. I think the lady's father is also there, an old man. And after after 6-7 weeks of just dealing with the child, they are able to take the child into confidence so that the child can share his or her problems with this lady and the father of the lady, and they can provide certain solutions and guidance to the child. That was something which left an indelible mark on my mind, that how a juvenile has to be dealt with if we really want to help such a juvenile to rejoin the social stream, to reintegrate with the society, and to make the child a useful tool of the society. That was something very important. So very inadequate, very recently I visited 2022. I have detailed, you see, parameters. No psychologists there, no medical visits are there, no even basic first-hand facilities are there, no support for education, proper support is there. You see what a teacher is doing. I just asked that whether someone comes to educate these children. Yes, sir. Somebody is coming. How he is managing or she is managing? Well, all the children sit together. The children are from the 8, 9 years to 16, 17 years. They will sit together and they will study. So one teacher, no distinction, class 1, class 2, class 3, which age group, what has to be taught, what has not to be taught. So is it education? It is simply performing a formality in the name of education. It is not going to help the child. It may further breed some sort of discontentment and resentment in the mind of the child with regard to the institution itself, with regard to the system itself. Therefore, these are the things we need to look very seriously. We can say that we have no funds. If we have no funds, no problem. We can repeatedly write to the persons who are providing the funds. Repeatedly, every 3 months, that this is the problem, please resolve it. Things will happen. So it is their skilled personnel. You see, in 2005, when I visited this juvenile observation home at Jabalpur, then we just went there without informing. So what we found that the child was lying on the floor, maybe 12, 13 years old. He was unconscious, surrounded by other inmates of that home. And one or two of them were just putting the sleeper around his nose, so he will smell it and gain consciousness. So you see, in 2003 or 4, such a treatment at a place like Jabalpur, which is the principal seat of the High Court, see, unimaginable. Thereafter, we held series of workshops, even calling the highest officers of the state. In one workshop, we even called the minister concerned, Minister of the Women and Child Welfare, including the Principal Secretary. We took so many commitments from them. Thereafter, certain probation officers were appointed, but still things are not in good shape. So as and when you just go back to your duties, have an interaction with the duty holders, please definitely share all these things with them. Proceedings, now the time frame is prescribed in the Act. So if there is a petty offense, the board has to conclude the proceedings within 4 weeks from the date of the first, presentation of the child. And exceptionally, it can be extended to 2 more weeks, so maximum 6 months time has been given. And if the proceedings are not complete, then in petty offenses, the proceedings have to be closed and the child has to be treated for his or her reform according to the Act. I don't think that this is also being done properly because there is no supervision protocol properly at place. So these things cannot be done that way, and no monitoring mechanism. Punitive measures, now this is a criticism that the 2015 law segregates these children of 16 plus into a where they will be treated as a regular criminal. But you see, it is a legislative prerogative, and you see social realities has always to be looked into. So that way it has been done. So friends, this is all about I wanted to discuss with all of you. These are the, same Muzaffar shelter home case. abuse and sexual exploitation of girls in a government-run shelter in Bihar highlighted the lack of monitoring and oversight in juvenile care institutions. 2018. And this is happening. It is not that exceptional incident is there. This incident has been brought to light. Other incidents are not being brought to the light. That is only the difference. Then another observation, home incident 20, several juveniles escaped due to lack of proper security and staff supervision, pointing to the infrastructure and administrative inadequacies. So these are the things, many of the things are beyond our control, has to be looked into by those who are in authority. But then a major part is there within our control also. And if we discuss the things, if we deliberate on these issues with our colleagues, with the duty holders, with other persons who can be helpful in improving the situation, then definitely be confident that things will improve. There is nothing to lose hope. When the law is there, then everything can be done in accordance with the intent and spirit of the law and the legislature. So this was something I wanted to share with you. Madam Shruti is here, very well versed in the law, and I also have written a book on juvenile. She has done a lot of work in that field. So she will just discuss her own perspective with regard to law. Have you any questions? I don't think you have any question. You can prove me wrong. Any question, please? Mic चाहिए? No questions. So I understand that you have, yes. इनको mic देंगे जरा सा.
So I am Sangam Kumar, Assistant Public Prosecutor from Ranchi, Jharkhand. So I have two set of questions. One relates to a recent judgment by the Honorable Supreme Court, in which this judgment is titled as Munna Pandey versus State of Bihar. This was a brutal rape and murder case of a 11-year-old girl in Bihar, Bhagalpur, Bihar. In this, sir, what happened during the trial? So the Sessions Court has pronounced the judgment, convicted, and given death sentence, which was confirmed by the High Court. Then it went in appeal.
Death sentence?
Yes, yes, sir. But it was reverted. It was reverted.
Trial against juvenile?
No. Against a
Major
person. But then there was a juvenile also.
Right.
So my question relates to that only, sir.
Yeah.
Now, in that case, what happened? The juvenile was declared juvenile after the examination of 3 prosecution witnesses.
Yeah.
So there was a juvenile and his relative who was a major was involved. So before the juvenile was declared juvenile, all the witnesses were saying this was also a case of last seen witness, last seen person.
Yeah.
So in that that juvenile was seen but then after he was declared juvenile, obviously the case of the prosecution will fail. The prosecution started naming the other major person. So, sir, this stage of declaring a juvenile, won't it be better only after the trial starts? Before that, it should be declared juvenile, because I guess this is. So this is one, sir. If I may, the second question. Sir.
Yeah.
Sir,
let me respond to the first before I forget it.
Sure.
You see, the moment a person is brought before magistrate or a court or a board, it is provided in the act itself. The board is sure that the person is juvenile, no issue. If the board has slightest of doubt that the person is not juvenile, then the board can conduct a preliminary inquiry. In that inquiry, the board can come to the conclusion that the person is a juvenile or not. If the board comes to the conclusion that the person is not a juvenile, then it will be referred to the magistrate. Magistrate will again commit the case to the session judge. The person against whom the order is made can go in appeal before the children court. and the children court can decide whether the person is juvenile or not. First thing. Second thing, if a trial is proceeded against a major person and a juvenile, then whatever is done in the trial qua juvenile is totally null and void. No evidence can be looked into. No inference can be drawn on the basis of anything recorded by the session judge, either in the evidence or in the judgment. Totally separate and independent inquiry has to be conducted according to the act by the board. What is the second question?
Sir, so my second question with respect to the classification of offenses, sir. So basically with the Juvenile Justice Act, we see, or wherever we try to use the term, we try to avoid using terms which are used for a major criminal or a major person. So while we use the term offenses, like obviously it becomes a it becomes that he's offender, he's
You
a
see,
criminal.
yes, yes,
Please.
very good question. And you see that the Indian Penal Code or Bharatiya Nyaya Sanhita or other laws, they provide with regard to various acts which amount to offense. Not as such, the crime word has not been used, offense word, violation of the law, that is an offense, right? Now the legislature wanted to draw a distinction between the acts. So in petty offenses, you see, ultimately what other you can say, will you say petty act? Ultimately petty offense, it is an offense. For the juvenile, it is neither a trial nor a offense. It is simply determination whether the law was violated or not. But basically it is an offense. So if you want to say that in petty offense, the trial will be completed within 4 months or maximum 6 months, and thereafter the trial will be wound up, and there will be, you see, as far as the punishment is concerned, simply admonition can be there, maybe wounding over on the bonds will be there, or the maximum that to keep the person in facility for maximum 3 years. So you have to refer it to petty offense. And then you want to go further. Offenses punishable with more than 3 years imprisonment up to 7 years. Serious offense. And then more than 7 years. So what could have been the alternate? Except to treat that there is a petty offense, there is a serious offense. It doesn't make any difference. Ultimately, it is a matter related to the approach and attitude of those who are duty holders under the law. They should keep in mind that it should be non-stigmatic, it should be non-penal, it should be reformative, it should be rehabilitative.
I have a question.
Jay.
Juvenile is facing inquiry before JJ board and is in charge under section 34 or 120B, and the major accused is facing inquiry before district court. The procedure, the inquiry procedure and the depositions which are recorded by the Juvenile Justice Board, Honorable Magistrate, whether it can be used against the major accused where a trial before court of session.
You see, the legal parameters are very clear and specific. Whatever to be used against the accused should be evidence in terms of the Evidence Act. A statement made in inquiry is not exactly evidence. Evidence is something which is after the commencement of the trial against the accused after framing of the charge. So that cannot be used. The limited purpose for which this evidence can be used is to determine the juvenility.
More often the defense counsel,
Sir,
more often the defense counsels are getting the certified copy and
you see, defense wants certified copy, it can be provided, subject if they are party to the proceedings, they can take it. But that evidence cannot be used. You see, what is happening? In inquiry before the board, the statements of witnesses recorded in the sessions trial are being prosecuted because 302 is the charge. In the juvenile justice proceedings as well as in the sessions trial. So those statements are proceeded before the JJ board to establish that the guilt is there. Or on the contrary, those statements in which the witnesses have turned hostile eyewitnesses and the accused has been acquitted by the Sessions Court, those statements again are produced before the JJ board. No, can't be admitted. Both the things are totally separate. Independent proceedings are there. One is the inquiry on the basis of certain basic rules. Another is the trial under the procedural law. You can't mix it.
Thank you, sir.
Situation in which statement of the witness trials was produced in certified copies before the another court just to corroborate that he has said something in a certain trial. It was not used as an oral testimony. It was produced as a documentary evidence. Like they attach a further to it and they mention it that PW1 had stated so and so in XYZ statement. So when they bring it in that form, I think then we can just consider that fact that, okay, it's like corroborating or refreshing the memory of that person, because I think in evidence act itself, we had something that if something was said in a previous suit or a trial, it can be later on quoted if produced in a certified form, just to refer to the witness that you said this. So now what is your stand on it? So I think, sir, in that position, maybe we can use the statements here.
पहली चीज तो ये है कि आपकी नींद पूरी तरीके से भाग गई है. Your question is testimony to the fact that you are totally awakened.
Yes.
First thing, I compliment you for this.
Thank you, sir.
Second thing is that the law of evidence, Indian Evidence Act, Bharatiya Sakshi Sanhita, the act very clearly stipulates the use of previous statement of a witness. So if a person is a witness in a proceeding, right? And if that person has given a statement before a judicial authority, matlab ki authority who is legally competent to record the statement, then that statement can be used to contradict and to corroborate also. The position is very clear. So if a witness has stated something before the Sessions Court, is trying to state something different before the Juvenile Board, then he can be contradicted by his previous statement under the law of evidence. Very much admissible.
Sir, I had a question.
Yeah.
Like it was a situation that I faced when I was presiding over the JJ board. The situation was that there was a juvenile, while he was convicted by the Honorable High Court, and he was
Juvenile convicted by the Honorable High Court.
By that time, he did not plead juvenility.
Acha, the plea of juvenility was raised after the decision rendered by the High Court.
Not even after that.
Oh.
The problem that happened was that when he was convicted by the Honorable High Court, and then his death sentence was converted into life statement by the Honorable Supreme Court. Now, till then also, he did not plead juvenility. But later on, there was some circular that said that we will look into the institutions and see in the jail which of those are juveniles, and we'll produce a report of it who is under 18 or not, the people who are convicted and are in jail. So when that notification came, he pleaded juvenility in front of the Juvenile Justice Board. Like they produced an application in front of the board कि हम juvenile थे, and that incidence was of I think 2001 or 2. So now he has already sentenced 14 years in jail already, sir. And as a juvenile 3 साल से ज़्यादा तो वैसे भी नहीं रह सकते थे. What the now send it to the Supreme Court or?
Okay. So the question basically is that a trial was conducted against a person and he was found guilty by the trial court. The judgment was upheld by the High Court and even by the Supreme Court. And thereafter, this person comes back and says that I was a juvenile at the time of the commission of crime. Going by the decision rendered by the Supreme Court, a person can raise this plea even before the Supreme Court. But once the Supreme Court has rendered a decision upholding the decision of the trial court and the High Court, then how the Juvenile Justice Board will acquire jurisdiction to reconsider the juvenility? You see, the pleas can be raised at different stages. The first stage is the magistrate, remand magistrate. Second stage is the board. Third stage is the appellate court. Fourth stage is the Supreme Court. If you don't raise this plea, there are cases in which the plea was raised before the Supreme Court. And then Supreme Court directed the district judge to conduct an inquiry in exercise of powers under Article 142. District judge conducted an inquiry and returned a finding that he was not a juvenile. So that is the jurisdiction vested in the Supreme Court. But once a decision is final after being decided by the Supreme Court, things have to close, and if the things have to be re-agitated, then to be re-agitated before the Supreme Court only. Otherwise, there will be, see, total haphazard situation. Anyone can decide anything at any time after 30 years also. No, that cannot be done. Thank you very much. So friends, yes, one more question. अभी कुछ क्वेश्चंस इनके लिए भी छोड़िए. चलिए, let us. अच्छी बात है कि आप सवाल कर रहे हैं.
सर क्या प्रोडक्शन वारंट जुवेनिलिटी के लिए लागू होगा?
Production warrant, right. You see, production warrant is a warrant calling upon the jail authorities to produce a person before the court who is either dealing with the committal proceedings or with the regular trial, right? That is the production warrant. Now, what you want to ask that whether juvenile board can issue a production warrant? Is it your question? Why can't? अगर ऐसी कोई बात है और juvenile board, if the juvenile board is apprised that there is a person in the jail and juvenile and facing, now you see, if he is in jail or she is in jail, then apparently he or she was not treated juvenile, because a juvenile can never be in the jail. Jail cannot be used to keeping confined a juvenile. So meaning thereby that he is not a juvenile, and if he is not a juvenile, then apparently his trial is not going to be conducted before the JJ board. But for 1%, if such a person is juvenile, or he claims to be a juvenile in a regularly instituted proceedings before the board, suppose दूसरा केस है, उसमें भी ये व्यक्ति accused है, प्रोडक्शन वारंट दूसरे केस में ही होते हैं, उसमें ये accused है, और as juvenile he has been brought before the JJ board, and of course the production warrant is the only solution.
Thank you. Thank you.
Sir, in case of petty case and serious cases, child रहता ना वो plead admit करता हो guilty. अब वो उनको after in future job के लिए verification होता ना police इसमें उसका IT में enter होए तो effect होता क्या बोल?
Yes.
Petty and serious cases.
And you say that a juvenile admits the guilt before the JJ board?
Yeah.
You see, that is basically the Juvenile Justice Board is not a place where a trial is being conducted or admission of guilt is there.
Petty cases में वो penalty
for the circumstances, so basically the board should reject it. No question of admission, there should be an inquiry. And when the juvenile is being interrogated, then he is at liberty to say what he wants to say.
Petty cases में penalty भर देते, penalty भर.
In petty cases, first thing admonition, right?
Yeah.
Second thing, bounding over by the bond, probation, maximum up to 3 years.
Yes.
Third thing, to keep in a facility for maximum 3 years. These are the 3 things. A social service, this community services is now a new thing that can also be done.
That is not affected in future.
No. Communities, the direction for community service can be given subject to the age of the child, plus 14 hai, and you see simply asking something, do some service in the hospital as a support person, you can do it.
Thank
you. 41A CRPC. What it says, What it says, what is the provision? Notice to accused. No, that will not apply. You see, the juvenile, after being apprehended by the police, has to be dealt with forthwith by the juvenile police unit and be produced immediately before the JJ board, not beyond 24 hours, and thereafter the board will exercise its powers. That is not available for the juvenile. You see, separate what this JJ Act 2015 has overriding effect over all other laws. It is provided in section 2 itself. I think section 2 subclause 4, I think it is there. It is not withstanding anything contained anywhere in any other law. All the proceedings shall be conducted 1/4. This subsection 1 clause 4. That is the overriding effect of this law, right? So everything has to be done scrupulously under this act. Thank you.
Sir, can I ask in Hindi, sir?
क्यों नहीं?
सर, जो अभी मैडम ने प्रश्न किया था, सर उसी से रिलेटेड है कि किसी बंदी को 376 आईपीसी के तहत पास्को एक्ट के तहत आजीवन कारावास की सजा दे दी गई और 6 वर्ष की सजा उसकी कट चुकी है। एपीलेंट कोर्ट ने कहा कि ये जुवेनाइल है और इसको जुवेनाइल बोर्ड को भेजा जाए और आरोपी को रिमांड होम स्थानांतरित किया जाए,
ऑब्जर्वेशन होम।
यस सर। तो प्रश्न यहाँ ये उठता है कि वो जिस दिन उसने ऑफेंस किया उस दिन जुवेनाइल है कि नहीं। ट्रायल के दौरान ये रिस्पॉन्सिबिलिटी किसकी है कि जो तय करे कि ये जुवेनाइल है या नहीं, क्योंकि जब 6 वर्ष बाद 7 वर्ष बाद जब उसको ये पाया जाता है कि ये जुवेनाइल है तो फिर उसका कोई औचित्य नहीं रह जाता है कि उसको सजा दी जाए या उसको जुवेनाइल माना जाए, क्योंकि वो 6, 7, 8 वर्ष की सजा भुगत चुका होता है। दूसरा सर क्वेश्चन, हमारे पीछे आदरणीय बैठी थी मैडम, इनका इन्हीं से रिलेटेड है कि यदि जुवेनाइल द्वारा कोई अपराध किया गया है और जुवेनाइल जस्टिस बोर्ड द्वारा उसको डिसाइड किया गया है तो क्या भविष्य में वो किसी शासकीय सेवा के लिए एबल होगा या नहीं होगा, उसके लिए योग्य होगा कि नहीं होगा?
So these are the two questions. First question is the determination of juvenility, by which forum at what time. If the person is brought before the magistrate for remand, claims to be juvenile or appears to be juvenile, magistrate को लग सकता है ना कि ये तो कभी अभी 15 साल का ही लग रहा है, कैसे बता रहे हो? पुलिस कभी कभी क्या करती है कि 16 साल के बंदे को 19 साल का लिख देती है। अब अपरेंटली दिख रहा है कि 16 साल का है, अब वो तो क्लेम नहीं कर रहा, वो कानून नहीं जानता जुवेनाइल का। So the magistrate is under an obligation to record it and to conduct an inquiry and to send the person before the JJ board. This can also be before the sessions court if the trial has commenced. This will also be before the JJ board before whom the person is produced. This will also before the High Court if an appeal goes to the High Court after conviction from the sessions court. There are numerous cases in which the Supreme Court has directed that this person claims to be juvenile, therefore an inquiry should be conducted whether he is a juvenile or not. Law is very clear, the person claiming to be juvenile can raise this issue up to Supreme Court at any stage. It doesn't make any difference that he or she has suffered a sentence or a prison time for 6 or 7 or 8, totally irrelevant, right? So that is something it can be corrected, but if the Supreme Court has held something finally, then you cannot start a new inning, right?
Sir.
Second क्या था? हैं? क्या? एक यही बताएंगे। हाँ, सेकंड क्या था?
नहीं, ये सर मैडम का क्वेश्चन था कि यदि किसी व्यक्ति को जुवेनाइल जस्टिस बोर्ड द्वारा कन्विक्शन तो हो ही नहीं सकता है, उसको फैसिलिटी होम में रखा गया है तो क्या ऐसा व्यक्ति आगे भविष्य में शासकीय सेवा के लिए उपयुक्त होगा या नहीं?
So you see the provision is there in the JJ Act 2015 itself. When we say that the entire proceedings and the findings are non-stigmatic, so it will never be used to disqualify a person to gain an employment either with the government or with the semi-government or with the private facility. It is totally, even it says that in petty cases, the records shall be totally destroyed after the appeal is decided. And in those cases, serious and heinous cases, then it will be with the court as per the rules. So it is totally non-stigmatic. A specific provision is there in the Act itself. Right?
Thank you, sir.
Sir.
जी थोड़ा सा माइक माइक इनको दीजिए। तो कहाँ तो आप सवाल पूछ नहीं रहे थे, कहाँ होस्ट ऑफ क्वेश्चंस, वेरी गुड।
Sir, where a CICL has committed a crime during the age of or below 18 years, and he was absconded and apprehended after 20 years. Then what procedure should be followed, sir? Whether he will
See, the controversy was there after the decision of the Arnit Das by the Supreme Court of India. In Arnit Das, the bench said that the juvenility has to be seen on the date when the accused is brought before the court. But then soon that judgment was reversed by the Supreme Court itself, a 3-judge bench, and now the Act of 2015 very clearly stipulates that juvenility has to be decided on the date of the commission of the offense. तो अगर 15 साल का बच्चा अपराध कमिट करने के बाद में 7 साल अगर जो है बाहर रहता है, फरार रहता है, तो कितने का हो जाएगा? 15 साल 22 का. When he will be apprehended, he will be brought before the observation home. Will be tried as a juvenile. Very clear. हाँ, अलग से है ना, उसके लिए प्लेस ऑफ सेफ्टी है. प्लेस ऑफ सेफ्टी में रखेंगे, ऑब्जर्वेशन होम में नहीं रखेंगे.
सर एक क्वेश्चन था, जुवेनाइल में जो बच्चों के केस चलते हैं, उनको क्या चिन्हित या सनसनीखेज में डाला जा सकता है?
क्या
सनसनी या चिन्हित केसों में?
सनसनी
या चिन्हित केसों में? सर जघन्य सनसनीखेज.
सनसनीखेज, देखिए, you see, सनसनीखेज तो वर्ड यूज नहीं किया गया लॉ में. There are only, you see, we very serious while using something. So don't use JJ court. It is JJ board, not court. Right? It is not trial, it is an inquiry. It is not an accused, it is a person in conflict with law. Be very careful while speaking something about the juvenile. And you see, if the juvenile is being tried before a board, then all the things which are there in the act has to be adhered to very clearly, right? So, yes. Yeah.
But against whom the offense will be registered?
POCSO case, both are juvenile. You see, again, we are using a wrong expression. Minor word has not been used in the act. It is child or juvenile. Minor is minority continues up to even 20 years. So it is juvenile, and if the juvenile is there and the POCSO code is there, firstly POCSO code तो बाद में पिक्चर में आएगा, पहले तो अपराध का registration होगा. So if the registration is at the police station, police consider that the person is not juvenile, definitely the matter will go to the magistrate. The magistrate's first duty is, if apparently he appears to be juvenile, to pass an order. If he claims to be juvenile, then to conduct an inquiry and pass an order.
Sir, it is confirmed that both are juvenile.
Bilkul. No, notwithstanding anything contained anywhere, such a person will always be dealt by the Juvenile Justice Board.
Sir, the offense will be registered against whom? Because the POCSO and rape comes under the
Offense will be registered. Offense will be registered against the persons who are said to have committed the offense. Don't use the word juvenile or minor. The offense will be registered against the person against whom the allegation is that he or she has committed the offense. Right?
Sir, trying to say that both are juvenile. One juvenile committed the offense against the other.
Against the other.
Yeah.
Right? So another is the victim.
Yeah.
So the victim So victim here is not coming within this purview of the act, right? Now there is an offense under the POXO Act. The charge is against a juvenile.
Yes.
You tried by the board.
No, sir. Sir,
Both of them, you see, both of them, one is the victim, one is the accused. One is the victim. Why you put them in the same boat? One is the victim, another is the accused. Now victim, of course, POXO Act में victim तो
victim. For example, sir, suppose a girl is a 16-year-old, boy is for 12 years old or 13 years old.
So
Then how we
So
can
the
decide
so
who
the
will be
girl
the victim and who will be the
so the girl is the victim, right?
sir? Suppose a girl is a 16-year-old
Yes,
and the boy is a 12-year-old.
yes.
Then who will be the victim and who will be the
If the allegation against the girl, the boy is that he committed, you see, sexual act against the girl, then the boy will be accused. Now he is,
he's a minor,
you see,
12 years.
don't confuse. Now the boy is 12 years, he is a juvenile,
Yes.
will be dealt by the board. The girl is 16 years age. She is the victim. She will be a witness. What is something which confuses you?
Hey, sir, if girl is a 16-year-old, she must have been
Don't
the more,
go old.
more the understanding. और उसके आगे
You see,
there is a
don't
books.
go on who is old and who is young. You have said the age very clearly, 16 years and 12 years.
सर लेकिन पोक्सो एक्ट में जेंडर कंसीडर नहीं किया है ना.
Gender consider नहीं किया है. Now the allegations will be looked into. The allegations will be looked into, and in that case, the act of sexual act that is against the boy who is 12 years.
Sir, we can consider कि अगर boy 12 years का है तो there must be expectation by the girl.
Why to consider? Why you as a judge or magistrate should propound your own theory? You go why. You see, firstly, the case will go to the police, right?
Now, I'm a police
No,
inspector.
no.
That's why
Police inspector, so it will go to the juvenile police unit. Juvenile police unit. Now, you as a police officer can't put your own views in the matter. You will have to examine the witnesses, right? Interrogate the witnesses. After interrogation of the witnesses, you will come as a police officer to a conclusion that who is the victim and who is the accused. If on the basis of the material collected by you as a police officer during the investigation, if you come to the conclusion that boy is an accused, you will file charge sheet accordingly. If you find that the girl is an accused, you will file charge sheet accordingly. It is not your personal whim. It is the material which you have collected during the investigation. On that basis, you will have to go. You can't say that कि नहीं लड़का तो ऐसा बोल रहा है लेकिन मेरे मन में तो लड़की की गलती. Not go by ages. No. You will have to go by the evidence and material collected by you during investigation. You see, don't go by the age. Don't be mechanical. Your discretion is very limited. You will have to base your finding as an investigating officer on the basis of what you collect during the investigation, nothing else. You see, अगर इस तरीके से confuse होंगे तो बड़ी दिक्कत हो जाएगी. जी, have you faced such a problem? Have you faced such a problem? तो आप क्या किया उन्होंने बताइए. जी. कैसे तय किया आपने? क्या अपने मन से तय कर लिया या मटेरियल आया है? अगर आप if you have collected the material, meaning thereby after interrogation of the witnesses, recording their statements under section 161, and on the basis of other evidence collected by you, if you come to the conclusion that the child of 12 years is a victim, you will file charge sheet accordingly. No problem. You are not forced to file a charge sheet only against the girl, only against the boy. But it will depend on what you have collected during investigation. तो इसमें एज के आधार पे मैकेनिकल डिसीजन नहीं लिया सकता कि अगर लड़के की आयु कम है, लड़की की आयु ज्यादा है, तो हमेशा नो 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 नो, दैट इज रॉन्ग. That is wrong. You can't take that mechanical. You have to decide on the basis of the material collected by you, right?
Thank you so much, sir. Please,
I
sir,
think
we are running short of time.
Just listen. There is a next session, and thereafter there is another session.
Yes, sir.
2 more sessions are there. I must be little, you see कि आपका लंच भी अभी आपका इंतजार कर रहा है. क्वेश्चन आंसर हम शाम तक भी कर सकते हैं, कोई दिक्कत नहीं है. ठीक जी. हाँ. No provision for remand is applicable. Section 12 of the JJ Act says that a person arrested, taken into custody under this act shall be enlarged on bail. That is a mandate. 12(1). Proviso says that if there is a chance that after release on bail, this person can come in the contact of known criminals, and that may be against the interest of the juvenile, then bail can be denied. If bail is denied, then the person has to be kept in the observation home. That is not remand. Right? Thank you very much.
Thank you so much, sir.
For being so much participative. Something कि पहले तो लग रहा था कि एक सवाल भी नहीं आ सकता है, लेकिन बाद में लगा कि सभी लोग बहुत जागरूक रहे हैं. Multiple questions, really very good thing. But please keep this thing आगे भी थोड़ा अपने colleagues के साथ में, duty holders के साथ में, stakeholders. Otherwise, you see the entire exercise goes in waste. आप इतनी दूर से आए हैं, इतना टाइम आपका जा रहा है. अगर ये सारी चीजें यहीं की यहीं खत्म हो जाती हैं तो कोई फायदा नहीं. So please discuss it with the other duty holders. Thank you very much.
Thank you so much, sir. And after this marathon session, I will request our Deputy Director, DIG sir, to please present a memento to our respected Justice sir. मुकेश, आप वो सर का, पांडे सर का ऑनलाइन सेशन स्टार्ट कीजिए प्लीज. सर को कनेक्ट कीजिए.
पांडे सर कनेक्ट. Understand or problems with the units. Of technical issues, it cannot be always a very clear.
स्क्रीन पे डिस्प्ले कर दीजिए.
ठीक है सर, ठीक. Thank you.
Thank you so much, sir. And now I will request Professor Kumar Pandey sir from Ram Manohar Lohia University to take the session, and sir is joining us online due to some commitments. Sir couldn't join us physically. And before inviting sir, I want to give a brief about sir.
Can I leave?
No, sir.
Am I audible?
We lunch करेंगे sir. Within half an hour lunch break होगा sir. Yes sir, you are audible.
Am I
sir.
audible?
Yes sir, you are audible sir. Unmute कीजिए,
Thank
please.
you. Thank you very much.
Yes sir. Please start the session sir, as we are running short of time sir. I will request you to please conclude the session by 2 if possible sir. At 2 at 14
Thank you very
hours.
much. Thank you very much. And I've been very keenly and with great interest, I was hearing all the submissions and very interesting questions that were being asked and also being answered by Honorable Justice Sharma. In fact, as it was mentioned that it was a marathon session, most every aspect of the juvenile justice jurisprudence has been very comprehensively been covered and dealt by Honorable Justice Sharma. So there is very little left for me. But never mind, as we know that lunch is scheduled from 2. And the most difficult sessions are those which are immediately before lunch. and immediately after the lunch. So without wasting any further time, just to pick up from where Justice Sharma left. In fact, in his introductory comments, Justice Sharma had mentioned that how the whole of Juvenile Justice Act of 2015 been devised and in what chapters JJ Act 2015 has been divided. तो उन्होंने एक प्रश्न किया था। प्रश्न ये था कि अध्याय 9 के विषय में जो प्रतिभागी गण हैं उनकी क्या समझ है? Are they aware of chapter 9 of the JJ Act of 2015? And as expected, the response was not very encouraging. Not to say that none from the audience are aware of that chapter which is titled Offences Against Children, which is a salient feature of the JJ Act of 2015. Those who are acquainted with the JJ system or those who are acquainted with its development in the past 25 years, they may be aware that even under the JJ Act of 2000, there was this chapter on offences against children. लेकिन जब JJ Act 2015 JJ Act 2000 की जगह पर लाया गया, तो इस अध्याय में जो अपराध हैं बच्चों के विरुद्ध, उन अपराधों की संख्या में बहुत सब्सटेंशियल एक इंक्रीज है। एक दो अपराधों का जिक्र किया था ऑनरेबल जस्टिस शर्मा ने। फॉर एग्जांपल, he had mentioned about cruelty against children. He had also mentioned that how abandoning a child even by the parents may amount to an offense under section 75 of the JJ Act 2015. Now, before I proceed with this chapter, I'll be specifically focusing on chapter 9, not only the substantive offenses, but also the procedure that has undergone, if I dare say, a little controversial amendment in the JJ Amendment Act of 2021 that got into force with effect from 2022. So one question that was asked by multiple participants that related to that whether a child would suffer from any kind of disqualification if a child is inquired into or the matter has been inquired into by the JJB and the JJB has passed a dispositional order. Sentence नहीं होता है, जस्टिस शर्मा ने ये बताया था, there is this overarching principle. One of the overarching principles is of non-stigmatizing semantics. ऐसे शब्दों का प्रयोग नहीं करना है जिन शब्दों का प्रयोग आमतौर पर एक वयस्क अपराधी के संदर्भ में हम जो एडल्ट क्रिमिनल जस्टिस सिस्टम है उस एडल्ट क्रिमिनल जस्टिस सिस्टम में करते हैं। तो हम सभी जानते हैं, और अब यदि आप मीडिया रिपोर्टिंग भी देखें तो मुझे लगता है कि मीडिया रिपोर्टिंग हैज आल्सो इंप्रूव्ड ऑन दिस फ्रंट। Mainstream media would not say that a child or a juvenile has been arrested. Rather, it would report that a child or a juvenile has been apprehended. So, because a child or a juvenile cannot be arrested and can only be apprehended, for the same reason, a child or a juvenile, even if the board after inquiry is of the opinion that the child has in fact committed that particular offense, the child would not be sentenced. Rather, those dispositional orders that are there in section 18 of the JJ Act of 2015, any of those dispositional orders, depending on the circumstances, nature, gravity, personality, other factors, of course, can be passed. Now, section 24 specifically deals with that concern which was being raised by several participants, that whether such a child would suffer from any kind of disqualification, I'm sorry. Section 24 is titled Removal of Disqualification on the Findings of an Offense. It doesn't read removal of disqualification on the finding of guilt, because there is no finding of guilt, of course, that is recorded. It says that notwithstanding anything contained in any other law for the time being in force, a child who has committed an offense and has been dealt with under the provisions of this act shall not suffer disqualification, if any, attached to a conviction of an offense under such law. Now, this is a sweeping provision. Let me make it very clear that not only children under the age of 16 years, but even children between 16 to 18 years, if they have been dealt by the board for any offense that they were alleged to have committed, they would not be suffering from any disqualification. The only class of children that would be suffering from disqualification would be those in the age bracket of 16 to 18 years and were tried as an adult by the children's court. Of course, after that preliminary assessment that would be conducted by the JJB on certain parameters, I need not elaborate. Maybe other speakers may be speaking on related issues. So the only children who would be suffering from any kind of disqualification would be those whose cases are transferred by the JJB to the children's court, and the children's court tries those children as adults following now the procedure as prescribed in Bharatiya Nagarik Suraksha Samhita 2023. Previously it was, as mentioned, CRPC of 1973. So how is this related to chapter 9 is something that I'll be coming to. In fact, chapter 9 very comprehensively deals with the variety of offenses. Innovative offenses are there. Offenses which aim to what we call nip in bud any criminal propensity that may arise because the child is being used for certain purposes. So there are two objectives as far as these offenses. I won't say that all the offenses have these twin objectives, but there are few offenses in chapter 9 of the JJ Act of 2015 that seek to achieve two objects cumulatively, साथ साथ. पहला है adults should be adequately dealt with. if they commit any of those offenses or make children do certain acts which may lead the child to further indulge in criminal activities. तो पहला ऑब्जेक्ट तो ये है कि उन वयस्कों को जो बच्चों से कुछ ऐसे काम करवाते हैं जो बच्चे की ओवरऑल डेवलपमेंट को अफेक्ट करेगा, उनको एडिक्वेटली पनिश किया जाए। दूसरा ये है कि उन तत्वों को, उन फैक्टर्स को सीरियसली देखा जाए राज्य के द्वारा, पुलिस के द्वारा, न्यायपालिका के द्वारा, जिनको इग्नोर करने से उस बच्चे के भविष्य में, जिसको हम अपराध का दुष्चक्र कहते हैं, द विशियस सर्किल ऑफ क्राइम कहते हैं, उसमें, या जिसको हम कह सकते हैं कि नशे के आदी होने में, एडिक्ट होने में, एडिक्ट होने की संभावना है। शायद अन्य सत्रों में जब वक्ता बात करेंगे रिहेबिलिटेशन को लेकर के, तो उन बच्चों के रिहेबिलिटेशन के जो चैलेंजेस हैं, जिनको हम जुवेनाइल्स या चिल्ड्रन इन कॉन्फ्लिक्ट विद लॉ कहते हैं, उनमें एक बहुत बड़ा चैलेंज है, दिस इज एविडेंस बेस्ड कंक्लूजन, कि कैसे उनका एडिक्ट होना, उनका नशे का आदी होना उनके रिहेबिलिटेशन में एक बहुत बड़ी बाधा है। तो शायद जो समय दिया गया है मुझे, उस समय में सभी अपराधों पर मैं विस्तार से चर्चा नहीं कर पाऊंगा। जस्टिस शर्मा ने भी ये कहा था और मुझे बहुत खुशी हुई थी उस ऑब्जर्वेशन से कि अध्याय 9 के लिए अलग से एक सत्र की आवश्यकता है, उसके समग्र रूप से, उसके होलिस्टिक डिस्कशन के लिए। धारा 74 एक बड़े विशिष्ट प्रकार के अपराध की बात करती है। इट्स वेरी स्पेसिफिक ऑफेंस। आमतौर पर हम केवल पॉक्सो के जो विक्टिम बच्चे हैं उनकी आइडेंटिटी का डिस्क्लोजर न हो, उसको लेकर के कंसर्न रहते हैं। उसको लेकर के अवेयरनेस भी बढ़ी है, मीडिया में भी बढ़ी है। धारा 74 ये कहती है कि चाहे वो बच्चा किसी अपराध का विक्टिम हो, दैट ऑफेंस में इवन बी सेक्सुअल ऑफेंस। If you see the definition of a child in need of care and protection, you'd find that the definition is so comprehensive that it includes a child who has been subjected to sexual abuse and refers to such a child as a child in need of care and protection. तो एक बच्चा जिसने अपराध किया है, जिसके ऊपर अपराध का अभियोग है, आरोप है, एक बच्चा जिसके विरुद्ध अपराध किया गया है, चाहे वो लैंगिक अपराध हो या किसी अन्य प्रकार का अपराध हो, और एक ऐसा बच्चा तो इन कांटेक्ट विद लॉ है, एक ऐसा बच्चा जिसने न अपराध किया है न ही उसके विरुद्ध अपराध हुआ है, बल्कि वो अपराध का प्रत्यक्षदर्शी है, वो विटनेस है। Such a child is also a child in contact with law. Disclosure of identity of such a child unless and until such disclosure is either permitted by the board or the committee, or such disclosure is in the best interest of child, is an offense. Such disclosure is an offense unless and until it is authorized by the CWC in most cases, JJB in certain cases, or such disclosure is in the best interest of child. अब कौन सा डिस्क्लोजर एक बच्चे के बेस्ट इंटरेस्ट में होगा? जैसे कोई बच्चा खो गया, मिसिंग चाइल्ड इज अ चाइल्ड इन नीड ऑफ केयर एंड प्रोटेक्शन एज वी नो. So if you read rule 92 of the JJ rules, you'd find that the police has to publicize by pasting posters, making a hue and cry, by broadcasting the details, identity details of such a child. So that is disclosure of identity, but that is in the best interest of child. 2022 में धारा 74 में जो संशोधन हुआ, वो मुझे लगता है कि उस प्रश्न से जुड़ा हुआ है जो प्रश्न पूछा गया था अबाउट डिस्क्वालिफिकेशन. This is about issuance of a character certificate, which often is a condition precedent before joining a government service. एक सरकारी नौकरी ज्वाइन करने के पूर्व प्रायः यह जरूरत होती है, प्रायः यह एक रिक्वायरमेंट होती है कि कैरेक्टर सर्टिफिकेट, चरित्र प्रमाण पत्र जो है वो पुलिस जारी करे. तो क्या चरित्र प्रमाण पत्र जारी करने में उस बच्चे के आइडेंटिटी डिटेल्स का डिस्क्लोजर किया जा सकता है? इसको लेकर के जो संशोधन हुआ है, वो संशोधन में पढ़ रहा हूं. धारा 74 की उपधारा 2 ये कहती है, द पुलिस शैल नॉट डिस्क्लोज एनी रिकॉर्ड ऑफ द चाइल्ड for the purpose of character certificate or otherwise in the pending case or in the case which has been closed or disposed of. Pending case है, केस क्लोज हो गया है, केस डिस्पोज ऑफ हो गया है, किसी भी परिस्थिति में बच्चे के कैरेक्टर सर्टिफिकेट के संदर्भ में भी उसकी पहचान को उजागर नहीं किया जा सकता. और यह धारा सीधे सीधे पुलिस को एड्रेस करती है, यह उपधारा सीधे सीधे पुलिस को एड्रेस करती है. अब धारा 75 को लेकर के मैं थोड़े अपने विचार भी व्यक्त करूंगा. Section 75 punishes all form of cruelty against children. किसी भी प्रकार की क्रुएलिटी बच्चे के विरुद्ध अपराध घोषित की गई है, चाहे वो शारीरिक क्रूरता हो, चाहे वो मानसिक क्रूरता हो. प्रत्येक प्रकार की क्रूरता बच्चे के विरुद्ध अपराध घोषित कर दी गई है. लेकिन धारा 75 में एक परंतुक है, एक प्रोवाइजो है जो ये कहता है कि यदि किसी बच्चे के बायोलॉजिकल जैविक माता पिता, आमतौर पर ऐसा जैविक माता द्वारा ही होता है, उन परिस्थितियों के कारण जो उसके कंट्रोल में नहीं है, ड्यू टू सर्कमस्टांसेस बियॉन्ड देयर कंट्रोल, अगर किसी बच्चे को एबंडन कर दिया जाता, ऐसी बहुत सारी घटनाएं दुर्भाग्यवश हमारे समाज में घटती रहती हैं, जहां पर जिसको हम अनवांटेड चाइल्ड कहते हैं, उन बच्चों को एबंडन कर देते हैं पेरेंट्स. देन दिस ऑफेंस अगेंस्ट दोज बायोलॉजिकल पेरेंट्स इज नॉट मेड आउट. ये स्पेसिफिकली बायोलॉजिकल पेरेंट्स के विषय में, बायोलॉजिकल पेरेंट्स के विषय में ये प्रोविजो जो है वो अप्लाई करता है. लेकिन उनको यह सिद्ध करना होगा, जिसको सिद्ध करने का भार बायोलॉजिकल पेरेंट्स पर ही होगा, कि परिस्थितियां ऐसी थी जिन पर उनका वश नहीं था. वो परिस्थितियां आमतौर पर सामाजिक परिस्थितियां हो सकती हैं, वो परिस्थितियां आर्थिक परिस्थितियां हो सकती हैं, आमतौर पर सामाजिक परिस्थितियां ही होती हैं. जैसे एक अनमैरिड महिला का मां बनना भारतीय समाज में आज भी एक मुझे लगता है कि एक एबरेशन के रूप में ही देखा जाता है और एक ऐसी घटना के रूप में देखा जाता है जहां पर उस माँ को तरह तरह के लांछन और तरह तरह की प्रताड़ना, सामाजिक प्रताड़ना का शिकार होना पड़ता है। और प्रायः ऐसे मामलों में बच्चों का एक्सपोजर, अबंडनमेंट होता है। ये परंतु जो बायोलॉजिकल पेरेंट्स को प्रोटेक्शन प्रोवाइड करता है, ये परंतु हमारे पुलिस के साथी और हमारे जो लर्नेड जजेस, मजिस्ट्रेट्स बैठे हुए हैं ऑडियंस में, वो रिलेट कर पाएंगे। सेक्शन 317 आईपीसी से, 317 आईपीसी जो अब सेक्शन 93 है भारतीय न्याय संहिता का, जहां सेक्शन 75 applies to abandonment of every child up to the age of 18 years without any further classification or qualification. Section 317 would apply only when the child is up to the age of 12 years. But unlike section 75 of JJ Act of 2015, section 317 of IPC or now section 93 of Bharatiya Nyaya Sanhita has no proviso exempting biological parents from liability provided that the child is under 12 years of age. तो जो प्रैक्टिस रही है वो मैं आपको बताऊं, एंड ये भी जरूरी है, मुझे लगता है पुलिस के लिए ये जानना इक्वली इंपॉर्टेंट होता है। Whereas the offense under section 75 is non-cognizable and bailable. Non-cognizable है और bailable है। The offense under section 93 of भारतीय न्याय संहिता is cognizable and bailable. Bailable तो ये भी है, लेकिन cognizable है। ये बात मैं इसलिए कह रहा हूं, अब चूंकि समय भी मेरा पूरा हो रहा है, क्योंकि यदि आप इस अध्याय के अपराधों को देखें, और मैं बहुत क्विकली इस अध्याय के जो अपराध हैं उनका एक बहुत संक्षिप्त सा परिचय आपको देता हूं। धारा 74 के विषय में मैंने बात की, धारा 75 के विषय में मैंने बात की। धारा 76 किसी बच्चे को भीख मांगने के प्रयोजन के लिए इंगेज करने को पनिश करता है, चाहे वो पेरेंट्स ही क्यों ना इंगेज कर रहे हो। ऐसे बहुत सारे परिवार हैं जो अपने बच्चों से, वो खुद तो भिक्षावृत्ति करते हैं जो विधि विरुद्ध कार्य है, हम सभी जानते हैं। there are anti-beggary laws which are state laws, they themselves are committing offense. They also engage children, and then there are gangs who employ and engage children for the purpose of begging. Every such act would be punishable under section 76 of the JJ Act of 2015. Giving of intoxicating liquor, any narcotic drug, or even a tobacco product to a child is again a separate offense under section 77. ये सारे अपराध 2022 के बाद से ये सारे अपराध असंज्ञेय अपराध हैं। लेकिन यदि हम आईपीसी के या भारतीय न्याय संहिता के रेलेवेंट प्रावधानों को भी इन अपराधों के साथ संयुक्त कर देते हैं, तो हम पाएंगे कि चूंकि भारतीय न्याय संहिता में वर्णित डिफाइंड ये सारे अपराध भारतीय नागरिक सुरक्षा संहिता की अनुसूची 1 में संज्ञेय अपराध के रूप में है, इसलिए पुलिस को वही अधिकार प्राप्त हो जाएगा इन अपराधों के विषय में जैसा कि एक संज्ञेय अपराध के विषय में प्राप्त होता है। तो क्रूएलिटी अगर एक बच्चे के विरुद्ध हुई है जो नॉन सेक्सुअल प्रकृति की है, सेक्सुअल प्रकृति की है, तो निश्चित तौर पर पॉक्सो के प्रावधान लगेंगे और वहां पर पुलिस का काम जो है वो पॉक्सो के अंतर्गत जो उसके कर्तव्य है उसके अनुसार डिटरमिन किया जाएगा। लेकिन अगर ये नॉन सेक्सुअल प्रकृति की क्रूएलिटी है तो निश्चित तौर पर ऐसी क्रूएलिटी शारीरिक होगी 99% मामलों में, और ऐसे में भारतीय न्याय संहिता के रेलिवेंट प्रोविजंस भी आवश्यक रूप से ऐड किए जाने चाहिए, जैसा कि धारा 317 आईपीसी या 93 भारतीय नागरिक सुरक्षा भारतीय न्याय संहिता के विषय में मैंने बताया। और इससे कॉग्निजेबल ऑफेंस में या संज्ञेय अपराध में पुलिस को जो शक्तियां प्राप्त हैं वो सारी शक्तियां आप जो है वो रीगेन कर सकते हैं। मैं विशेष तौर पर ध्यान आकृष्ट करना चाहूंगा जो पुलिस के अधिकारी बैठे हुए हैं उनका, धारा 77 और धारा 78 के विषय में। एक बच्चे को सिगरेट देना, बेचना नहीं, केवल बेचना ही नहीं, एक बच्चे को सिगरेट देना फॉर वॉट एवर पर्पज, एक बच्चे को कोई गुटखा देना या कोई दूसरा टोबैको प्रोडक्ट देना फॉर वॉट एवर पर्पज, नॉट नेसेसरली सेलिंग it to a child, is also an offense, though the punishment is 7 years imprisonment and fine is up to 1 lakh rupees, but it's a serious offense, and that shows the intention of the legislature that you can gather by looking at the quantum of punishment. तो इन अपराधों को इस अध्याय में शामिल करने का जो दूसरा उद्देश्य है वो ये है कि बच्चों में नशे की जो प्रवृत्ति बढ़ रही है और जो उनके प्रत्येक प्रकार के डेवलपमेंट पर प्रभाव डालती है, न केवल शारीरिक डेवलपमेंट पर बट मानसिक और नैतिक विकास पर भी, और उनके अपराध के दुष्चक्र में फंसने की भी संभावना रहती है, उस पर कैसे रोक लगाई जाए उसको एम करते हुए नारकोटिक ड्रग्स और इंटॉक्सिकेटिंग लिकर का बड़ा लिबरल इंटरप्रिटेशन कुछ हाई कोर्ट ने किया है। मैं एक एग्जांपल दे करके अपनी बात यहां समाप्त करूंगा। आयोजकों को निश्चित तौर पर एंजाइटी हो रही होगी। तो थोड़ा अधिक वल्नरेबल चिल्ड्रन हैं, जो थोड़ा अधिक दुर्भाग्यशाली बच्चे हैं, उन बच्चों में भी जो बच्चे विशेष देखभाल और संरक्षण की आवश्यकता वाले बच्चे हैं, उनमें वो बच्चे जो स्ट्रीट चिल्ड्रन हैं, जो सड़कों पर रहते हैं, जिनके सर पर छत नहीं है, जिनके कोई पेरेंट्स नहीं है, उनके नशे के दुष्चक्र में फंसने की संभावना ज्यादा रहती है, क्योंकि बहुत सस्ते नशे जो शायद नारकोटिक ड्रग्स की डेफिनेशन में नहीं आएंगे, इंटॉक्सिकेटिंग लिकर की डेफिनेशन में नहीं आएंगे, साइकोट्रॉपिक सब्सटेंस की जो स्ट्रिक्ट डेफिनेशन है उसमें नहीं आएंगे, वो उनको सुलभ है। जैसे सुलोचन जो वल्कनाइजिंग सॉल्यूशन होता है, जो मटेरियल होता है, जो केमिकल होता है, वो बड़ा एक क्विक, जिसको कहते हैं हाई प्राप्त करने के लिए या नशा प्राप्त करने के लिए बहुत सारे मामले ऐसे रिपोर्ट हुए हैं, बच्चे यूज करते हैं। दिल्ली उच्च न्यायालय ने अपने कई निर्णयों में ये कहा है कि किसी बच्चे को ऐसा कोई भी केमिकल देना जिसका नशे के लिए प्रयोग किया जा सकता हो, whitener even if the child is addicted and is known, or vulcanizing solution if sold may also attract section 77 of JJ Act of 2015 with one quick observation। धारा 83 जो जेजे एक्ट 2015 की है, इसी अध्याय की, वो ये कहती है कि किसी बच्चे का किसी अपराध के लिए इंगेज किया जाना, इंप्लॉय किया जाना एक अपराध है, भले वो अपराध हुआ हो या ना हुआ हो। उसके लिए धारा 83 सजा का प्रावधान करती है। भारतीय न्याय संहिता में भी धारा 95 को शामिल किया गया पहली बार, जहां धारा 83 नॉन कॉग्निजेबल एफआईआर नहीं हो पाएगी। आप जहां धारा 95 जोड़ेंगे भारतीय न्याय संहिता की, या जब आपको तहरीर मिलती है और उसमें आपने ये देख लिया कि ये केवल धारा 83 जे एक्ट का अपराध नहीं है, ये धारा 95 भारतीय न्याय संहिता का भी अपराध है, आपको पूरे के पूरे वही अधिकार प्राप्त हो गए जो एक संज्ञेय अपराध में इन्वेस्टिगेशन के लिए आपको है, इंक्लूडिंग द पावर टू अरेस्ट विदाउट एनी वारंट फ्रॉम द मैजिस्ट्रेट. So because of a paucity of time, I would not be detailing anymore as far as these offences are concerned. I hope that in future sessions, if time permits, certainly other learned speakers may take up related, connected and cognate issues. So thank you very much. And I'm sorry I exceeded my time by 5-6 minutes. Thank you very much.
Thank you very much, sir. And for sparing your valuable time for this online session. And now we will break for lunch. And after lunch, we will join again for the next session. The next session will be taken by Shruti ma'am. She is joining us from National Judicial Academy. So we can break for lunch.
Thank you.
Lunch is arranged in the adjoining lawn where you have the high tea.
After lunch, next session.
Hello.
We create an alternate system. We say, these are our children. This is not a suitable environment or a procedure for them. And these are not the suitable measures we can take to deal with these children. Let's provide an alternative system. So a diversion. We take these children, send them to an alternate procedure. And why we do that is because we want to reclaim these children. So the entire purpose of having an alternate system is to rehabilitate and reform these children. We need to ensure that they are brought back. We correct the reasons that they are going off track and we bring it. And why do we do it? Because the grander principle, as Justice Sharma mentioned, is the best interests. I wanted to focus on section 3 a bit because all of us, whichever stakeholder we are, wherever we are in our country, these are what bind us. And we need to observe this in every aspect, whether it is pre-inquiry, whether it's post-inquiry, whether it is in the inquiry. Number one is the child is innocent. He has his constitutional right under Article 20 to be presumed innocent. He has to be presumed innocent. So the first thing you have to consider is this child is innocent. So when you have him coming before you as a police officer, consider that he's an innocent person and deal with him with all his rights that he is entitled to. He is not a criminal or an offender before you. That is for the JJB to decide. And then at that point of time, we are not even calling them criminal and offender. We are saying he's a person who's conflicting with the ordered society and the ordered legal system. So our presumption of innocence becomes relevant. Participation is one thing I am pretty much engrossed with. And I think this is one area that all of us need to understand and enforce. Here we are talking best interest of the child, welfare of the child, parent, support, protection. But this person we are dealing with is an individual as well. What about his rights? What about his views? So participation, this is coming from the UNCRC. And the most important thing is in everything that we do, he has a right to know, number one. So if he's apprehended by the police, he has a right to know why. What is it that he's apprehended for? He has a right to know that. He has a right in the inquiry to know what is going on, what will happen, what is the outcome, what are my options. And because he's incapable, immature, he can't mobilize the legal system, he has a right of support. So number one is parental association, legal assistance. If he's apprehended, he has a right to have somebody informed that he is apprehended, he's with the police. So somebody should know, that is, he has to have support and assistance to mobilize his way through the legal system. Right to have all information. And there's a recent judgment of the Supreme Court which says, it's an empty formality if you do not give him the documents. What is the material against him? Like any other person, he has a right to fair trial. So he must have those documents and that information so that he knows what is the matter against him, what is the content of the material against him, so that he can defend himself. And the most important part of it is a right to be heard. And this comes from the UNCRC Article 12, which is also now recognized in our statute, which says you will hear the child in conflict with law so that you hear his view. He has his own life. He has his own view. Why did he commit an offense? One, you could get an information regarding that. Secondly, what does he feel? What do you think were the reasons he committed? What do you think would be a conducive alternative to reform him? All these things you have to hear him and consider. It's not enough ki, acha, he said ABC, okay, done. Was that ABC considered and made part of your order? As a magistrate, I would say, was that made part of your order? Is also important. So it's not enough to hear him, it's also important to consider and give weightage to the child's view. I would say two things with regard to presumption of innocence and institutionalization. And this would go to the matter of bail for our courts. When we are talking presumption of innocence and we say institutionalization, they should not be considered guilty and they should not be kept in institutional care unless absolutely necessary. And that includes bail as well. The remaining principles, I think, have been covered. I will not spend a lot of time on that. I wanted to go into this whole concept of best interest. We had discussed a bit about it in the first session, but where is this concept coming from and what does it signify is also important, because all of us in our own capacities have to adhere to this principle. What is best interest? Number one, this has come from the UNCRC, that is the mother document. It was the first charter on rights of the child. And there it says, best interest of child is in all actions concerning children, whether undertaken by public or private. That is any stakeholder taking up action concerning a child. The best interest of the child should be the primary consideration. So that becomes your primary, not the only, but primary consideration. Please focus on the word primary. So that is, you in all actions, including judicial and legislative actions, the best interest becomes your primary consideration of all decisions and all actions that you're taking, whether you're apprehending him, whether you pass your order, whether you give him bail. All these things are rooted in best interest. We have brought this provision in our act, that is the 2015 Act, in section 2, clause 9, which says the best interest is the basis for any decision. And what is it to be in furtherance of? His rights, his needs, and all the other things that go towards his development, intellectual, physical, social, emotional, I would say as well. Social. Why social? So that he is reintegrated. So best interest is taking care of the child as an individual as well as a member of society. Two aspects become relevant here. Best interest is not just a broad parameter or a principle. It has many connotations. Number one, when we are saying best interest is the primary consideration, you have now given a right to the child. And the right to the child is that I have a right that you, stakeholders of the juvenile justice system, consider my best interests. You assess what is my best interest, and you consider and you enforce that best interest. So as a substantive right, you are now creating a right in the child to have his interest recognized and upheld in the procedure. Secondly, as a mandate for the procedure you all will follow, best interest says whatever you do, whatever actions you do should be for the welfare of the child. So if you are going to take him, is handcuffing in his best interest? Possibly not. It's going to stigmatize him. It's going to leave a lasting impression. So best interest, maybe handcuffing is not one of them. Okay, if you have a person who's in uniform coming and taking the child, apprehending, not arresting, apprehending, is it in his best interest? Possibly not. Our courtrooms, our JGB setup, you have a dais, you'll have the judge and the two members, the presiding magistrate and two members on a dais. Below them, we'll have the stenographers and the court staff, and then we have a place where the child will stand. There'll be an advocate on the opposite side. Is that good for the child? So is it in his best interest? So everything you will have to consider whether your procedure is in his best interest or not. So consider this as a rule of procedure that whatever you do has to be for the welfare of the child. as a guideline for decision making. Now here it becomes for everyone who's taking a decision with regard to the child. Whatever decision, what order you pass, is sending him to an observation home in his best interest? Or is there an alternative order that you could have passed which would have been better to address the problem? Would admonition work? Maybe, maybe not, depending on the facts. Would it have been better to send him for community service rather than keeping him in an institution? All these things are considerations you would have to take up. Is it in his best interest to pass a certain order under section 19, right? And as a framework, now here it is giving you a power. It's not just a mandate, it's also a power. That is, you have a beneficial legislation before you, which says take care of the child and his welfare. So now you have a power that if there are two alternative procedures, two alternative options, you consider the one that is most suitable for the child, which is more beneficial for the child. That becomes the place where you have some power to interpret the law. Consider the law and apply it in the benefit of the child. How has best interest been interpreted by the judiciary? A couple of things I wanted to highlight. Number one, they say it's an element of judicial decision making. Why? Because there are two things, best interest and wishes of the child. A child will say, I prefer to go with my parent, like say in a custody matter. I'm taking another example which does not have relevance to JJB's and juvenile justice per se, but let's say that the child says, I would rather stay with my parent A. I'm not mentioning gender because it could be any parent. I prefer to stay with my parent A. There may be reasons in the child's mind which may be extraneous, because of which he feels, oh, no, I don't want to go to parent B. He's afraid of parent B, so he wants to stay with parent A. Maybe there is feeding, maybe there's a fear element. You never know what is there. But then you are not bound only to take up what is the wish and desire of the child. You have to consider, will parent A be able to provide all the requirements that the child needs to grow up? Can they economically handle? Can they provide him a family setup? The social needs of the child, are they able to provide a stable environment where the child can grow up and have a normal emotional and social development? Also, you would consider if he's vulnerable. So which is the better parent in a custody matter? It's an element of the judicial decision making. So you have to decide what is the best interest, not just depending on what, say, the child says, or even some other party comes and says before you, it's better for the child, but you have to decide. Ultimately, for the magistrate, it is the decision. Factors that go into best interest, one, parental association. Being with your family is one of the better outcomes. So as Justice Sharma mentioned, having the love and affection and association of your parents being living in a home environment as opposed to an institution is a better option. That is a consideration that you would have in best interest. If they are able to provide him that, good. It's not just limited to love and care of the parent. It is also factors of economic, social, religious, etc. Anything that is for the development of the child and to provide him a stable environment. Not just money, not just physical, not just parent, even moral and religious character also plays a role here. So it is interesting that there are many factors that go into determining what is best interest. So all these factors as a JJB, when you are deciding, you will consider. If you want to send him in the custody of his parents, under the supervision of his parents, are his parents a suitable person to supervise and correct him? If not, is it better to send him under the supervision of a probation officer? If not, if he still, is it institutional care that becomes the solution? All these factors you will have to consider. With regard to, this is all repetitive, but with regard to procedure, we were talking best interest. Number one is when we are passing orders, as far as possible, best interest would be better served if they are set up in a social environment which is more conducive to the child rather than institutions. So if you can, in your orders, determine that the possibility of providing him a positive family environment, that would definitely be in his best interest. And in your procedure, ensuring that you have a fair trial, due process, is an important part of best interest. That is, you ensured that the child was treated with dignity and worth. He had his rights and they were enforced. And he was given an environment where he felt, he did not feel stigmatized. You did not treat him like an offender. We don't use these words, offender. You did not treat him like an offender. He did not feel that he was in a place where they said, okay, you've done something really bad. We have to take this up. If you provide a conducive environment where the child feels comfortable and realizes the import of his act, realizes that this is for his benefit, whatever proceeding is happening, That would be a thing that is in the best interest of the child. So all these factors, I think, would be what you need to enforce when you deal with best interests. Another aspect that I'm very passionate about is we often, when we talk about children, and I mentioned this earlier, when we talk about children, we are considering them as extension of our families, extension of parents. Children are individuals in their own right. They have just as much right, if not more, than us to be an individual. So the number one thing is we do not overshadow them with the parental presence. We consider them as an individual. So their rights must also take precedence and must be definitely enforced. The number one rights that they are entitled to, as all human beings are the natural justice rights. I think you know about this. I will not spend a lot of time on that. The second rights that we have are our constitutional rights of Article 20. And definitely with regard to how we deal with the juvenile, the third right becomes relevant, right against self-incrimination. How often have we heard of these cases where we say, "Bachcha, sab bata do, tumhare sath kuch nahi hoga, sab sach sach batao." Does he have to tell you? Is it against his right of self-incrimination? Is a consideration you would have to consider. That is, are we asking him to confess whether it is his, whether he has a right against incriminating himself? And are we, under what guise are we asking him to confess? Is it in his best interest to incriminate himself? That's a question. Legal aid is a right, which I think we all know. The Legal Services Authorities Act gives us the provision where the child is entitled to legal aid. There are varied rights under the juvenile justice system, and we need to think of these. Number one, when he is at the first instance, when he's apprehended, he is not arrested. These are gone in some random order, but I will start from the beginning. When he's apprehended, first of all, it is not an arrest. So he has the right not to be arrested. So number one is a person who is supposed to handle him. And that's a problem in our jails, because often we don't have a special juvenile police unit or a child police welfare officer. It's a problem. But can the solution be a plainclothes police officer coming if they have to apprehend him? So number one, if he's not being arrested, it should be by a person who does not cause a stigmatizing effect. So plainclothes officer, one. Second, if he is not being arrested, if he's being apprehended, then all the procedures of arrest should not be followed. Apprehension has to be done in a very dignified way. That is, you're bringing the child. Third, he should not be put in jail or a lockup. Fourth, he should not be kept with adults, whether it's in the police station or whether it's in your observation homes or jails. And that's a important thing that even magistrates have to play is under your provisions. There is a section, I will tell you that in a bit, where it says you need to go actively and go to visit jails to identify if there are juveniles in the jails and ensure that they are taken out. So that's an important thing. Right to be produced in 24 hours before the nearest JJB is an important right. Right to bail, Section 12. Right of support of parents or guardian. Right of participation, that is, if there's an inquiry against him, he has every right to the materials. He has every right to speak up in his defense. He has a right to have a legal assistance speak up for him. He has a right of defense, that is cross-examination and examination of witnesses. Production of materials to counter the findings in preliminary assessment as well as age determination. All these things go into a participation, that is, allow him a moment to speak and give him adequate time to prepare as well, and adequate time to marshal up the assistance he requires. Speedy inquiry becomes a mandate because our Juvenile Justice Act itself gives timelines. And unfortunately, it's more noted in the breach rather than in the compliance, because most of our juvenile trials inquiries are going longer than 6 months. Right against capital punishment and life imprisonment, we know that. Right against ill treatment and torture, the provision is there, and right of fresh start. We talked about this in the first and the second session, where we talked about disqualification. Section 24 was amply dealt with, which said, barring the cases which apply for adult trial, everything else, the principle of fresh start applies. That is, there is no disqualification when you commit a petty or serious offense. But if it's a heinous offense under 19, then the disqualification does definitely apply. Critical aspects, I would like to take you first through bail. I think this is an important aspect which most of our states have varied stance on. And why is it important? Because the rule that is there, standard for general bail, the principle, in fact, is far more importantly emphasized in juvenile law, which says bail is the rule and jail or institutionalization in this case is the exception. And this has further been enforced by the Supreme Court in 2020. I've given you the citation for your reference, so you can use it where you require. And why is it important? Because they are individuals who have a right to life and liberty. So when we are keeping them in institutions, when they are not required to be in institutions, we are violating their presumption of innocence, as well as violating their right to life and personal liberty is an important aspect. So when are they to be kept in institutions are only in these three exceptional cases. Now here the wordings I find are very interesting. Number one says, bring him into association with any known criminal. Now, what is interesting, which I find in many judgments, this has been emphasized as well, known. I say he's likely to come in association with a criminal. Which criminal? Is there a particular criminal in mind? Have you identified him? Where will you identify him from? So known criminal. The first point is known criminal, any known criminal. So the criminal in question he is likely to come in association should be known. And how will you identify it? The simple solution before you is the social investigation report. Go back to the background report, go back to the social investigation report, which will reveal his past activities, the place he belongs to, the persons who are in that place. All these things will be revealed from the social investigation report. So if you have to identify whether there is a criminal and he's likely to come into association with that particular criminal, a particular criminal, I would say, you need to refer back to the document that is before you. Expose him to moral, physical, or psychological danger more or less has not been interpreted in High Court judgments. Supreme Court, it has not come yet. Defeat the ends of justice is where the problem lies. So now the question is, what defeats the ends of justice? There are varied interpretations. And I'll give you a few examples to give you an idea of how varied the interpretation is. And I'm giving you because I think we ultimately need to come back to the point that bail has to be given. Is everything could defeat the ends of justice? Now, for example, likely to cause injustice is a criteria some High Court has given. Madhya Pradesh, my own state. It says if he is let out and it causes injustice. What is injustice? Injustice to whom? Is it the system? Is it the victim? There's a further point where several of the High Courts have said, when you release him, it won't be fair to the child. It won't be fair to the system, the justice system. It won't be fair to the victim as well as to society. Now, varied examples of this. Now, for example, I would say if the child is released on bail and he lives in the same community or the same locality as the victim, could that be a factor that affects the ends of justice? Possibly. Could you release him on condition that he does not reside in that place? Release him on surety under the parent's guard. See, there are one way I can say that he lives in the same community as the victim. Don't release him on bail. Could I also examine the possibility of giving him bail with a condition that he does not reside and ask his parents to ensure that he does not reside in the same locality where the victim is? Can bail be given then? There are ways to make sure you give bail. There are ways to make sure you don't give bail. But then the question is, are you doing it for the benefit of the child or not is the question. Because here you're looking at the child in question, that is the child in conflict with law. So as far as possible, if you can grant him bail while managing to balance the ends of justice is a measure that you will have to take. The problem that is lying is these things. Often, the nature of the crime becomes the determinative factor in grant of bail. Oh, he committed rape, sexual assault, not fit to be let out on bail. Many cases have been there. The merits of the case show the grievousness of the act done, the nature of the act done. He doesn't seem to be a likely candidate for grant of bail. Is that a factor mentioned in the three clauses? Probably not, but they have interpreted it as ends of justice. That is, he's committed such a serious act that it would defeat the ends of justice, sending a message. And this is how the analogy works. He's committed a serious act. It would send a wrong message to society if I let him out on bail. And here we are going wrong because we are treating bail as part of incarceration. Bail is not a punishment. Bail is only to ensure that one is your child in conflict with law is not put to danger. If you see the three things, it all talks about the child being in danger, one. And secondly, if it is going to interfere with the proceedings, then you do. It's not about, oh my God, we need to send a message through this. You need to send a message, you will have to send it through your order, but not through bail. Likelihood of coming into contact, we already dealt with. Anticipatory bail is a gray area. And for the magistrates in the house, I would just point out, there are two varied views on this. That is a child in conflict with law entitled to anticipatory bail? Can he claim anticipatory bail? Can he move an application? Two views. One says not applicable. And why? Because the provision section 12 has a non-obstante clause. It says notwithstanding anything in any other law, child shall be granted bail. So they say in view of the non-obstante clause, there is no other right of bail other than section 12. And second point rationale they've given is you are not arresting a person. So where's the question of anticipatory bail? If he's being apprehended, there is no question, and he will be given bail anyway. The second view that is, which says it is applicable, anticipatory bail, goes on 2-3 grounds. One is it's a beneficial legislation. So if it's a beneficial legislation, anything that is for the benefit of the child, including anticipatory bail, should accrue to the child. That is a view. And second point they have said is it's not expressly or impliedly excluded despite the non-obstante clause. Okay, so even though there's a non-obstante, it is not expressly said that only bail under section 12. So they have interpreted variedly. But the question, I think the final word on this has not been said. It could go either way. Both have valid points to make. Preliminary assessment. We talked a little bit about this in the first session, talking about preliminary assessment, and a couple of things that I wanted to focus upon in preliminary assessment was number one, this is a very prima facie view taken, preliminary assessment. So if there is a prima facie view taken, the standards of proof are lesser. Okay, so what is the capacity? You have to, first of all, the challenge in this is the moment you're assessing his capacity to commit an offense, you have transgressed into the line of presumption of innocence. We are presuming for the purpose of a preliminary assessment that he has done what he has been alleged to have done. So there is a question, and this is a ground we need to be very careful about, that in the process of preliminary assessment, we don't cross into presumption of innocence. It may be a very prima facie view, and that is a careful line that we need to maintain. Now, the problem with these three factors that have to be assessed, one is there is no guideline whatsoever. Physical or mental, we have the NCPCR guidelines, definitely, I would say, but it is extremely subjective, is my view. For example, let's take a sexual assault case. A person is before you, he's 16 to 18. You have to assess his capacity, physical capacity, sexual maturity. Is it a criteria? Possibly. That would go to his physical maturity, that is his build, his growth, his development, one. Mental capacity in case of sexual assault, how will you assess that? How are you going to say that he had mental understanding of what sexual activity is? And question is, are judges and social workers enabled, equipped to make that assessment? It's an extremely subjective criteria. Ability to understand consequences. Now here there's an interesting judgment of the Supreme Court which says, it says consequences. So it doesn't talk of one consequence that I did A, the outcome is this. I murdered somebody, he will spill blood. Blood will come out, he will die. That is one consequence. But the bigger consequence of it, that is taking a life, that is a graver consequence. Understanding consequences. But now the question is, how do you determine who had a understanding of consequence? I have a 10-year-old child. If I tell him you throw a stone, what happens? He will tell me what happens with it. And what is the impact if it hits somebody? So is that enough criteria to understand the consequences of offense? Where do you draw the line to understand that, okay, he's culpable enough that he needs to go for adult trial? Please remember, here the consequences are far more grave. The moment you make this assessment and you say he's adult enough to face an adult trial, the disqualification wipes out. The beneficial provisions of the JJ Act go away and he's going to face a trial like an adult. The outcomes also follow suit. So when you're making this decision of determining if he's grown up enough, are these criteria a subjective issue? Is a problem I see further. The next issue I find is procedure. It says you shall decide, you may and consult psychologists for this. In most districts, psychologists may or may not be available. So often the magistrate and the social worker members are making this assessment by themselves. What is the procedure for doing this? What do you do? Do you hear the child? What documents do you consider? What assessments do you get done? Does a medical doctor get involved? What are these assessments? What is the procedure? It's a question mark still. So there is a problem with regard to the preliminary assessment criteria. Here, a couple of things I wanted to say was, one is they have said the time period for preliminary assessment is a directory thing, mandate. It's not that you have to complete it within the time frame mentioned in the statute. It's a directory because the consequences of not following the time period have not been specified in the law. So the moment you have not specified the consequences of not complying with the timeline, it becomes a directory provision and not a mandatory. In Ajit Gurjar, why I'm referring is this, I would urge you all to go back and read it. It has underscored the role of the court. That is, the court is not to be a bystander watching how things are going. They need to take a very proactive role when you're dealing with preliminary assessment because, as we talked, the criteria is subjective, the procedure is questionable. It's up to you how you do it, and you need to take an active role. We were talking about age determination, and this is yesterday's news. My director, Justice Bose, mentioned about a case he handled himself. This is yesterday where a man who was on death row had, the matter had gone as far as the president for clemency, was found to be a juvenile after spending 25 years waiting for death row punishment. He was found to be a juvenile, and yesterday the order has come through where they said if he's a minor, then, but he has spent 25 years in prison waiting to be sentenced. He's sentenced to death, waiting for death. Just imagine how things are. And what can we, this is a reality. And it is obviously because the provision says at any time before, after the final disposal of the case, a plea for juvenility can be claimed. So they can claim it even after the case has come to an end. They can do it at any time. But the question is, can we at our ground level address this issue is a solution that we should come up with? Because the reality of the provision is this. They will claim juvenility. Sometimes they may not raise it before the JJB here. They will raise it at the High Court or maybe even directly at the Supreme Court. What are you going to do? In that case, they will definitely have to be entertained. Couple of provisions go in our favor. And I would say, look at that provisions and talk about it. Number one, we'll talk about Section 9. Section 9 is with regard to age and the general court. So if there is a person who comes before you and you see him and you have a doubt that he's a minor. So now here the court has the power to record this. So I would say take use of that provision, act proactively, and further to that Ajit Gurjar matter, act proactively. If you're finding a person, and you can do a lot of maths in this, if there's a person who's come to you for an offense which was committed 5 years ago, and he is what, 22, you can do the backward maths and say, if he's 22 now, was he a minor when the act happened? Record a finding under Section 9, possibly send it to the JJB. But a proactive role under Section 9 is required from all our courts. That is, if there is a case where there is palpably a minor before you, or at least a person who was a minor at the time the act was done, use that. 94, we all talk about age determination. Now, this is with regard to JJB specifically. 94, we talk about age determination, that you shall determine age by considering document 1, 2, 3 or medical board, right? But there's a first clause to that which talks about presumption. So when you have a person before you, and because there might be claims of juvenility later, when you have a person before you, record the finding of age. If you have a prima facie case, you see, he's before me. And I would say, as a matter of caution, in all orders, a presumption of age, if you are applying, record that in your order, that there is a person before me, a child, apparently seems to be within this age. It might be problematic because if he's on 16 to 18 criteria. So given a broad assessment of the age, to my mind, he seems to be somebody who's below the age of 15, possibly a ballpark figure of say 14, for example. Record this finding. It may help further because this matter is likely to come up when somebody claims that he was a minor at the time of the commission of offense. Procedure and the duty of the court, I will not focus. I've already spent more than half an hour with you. You can read this at your own leisure. It is how you have to do an age determination. The procedure specifies that. And we have lost the PPT. One sec. The duty of the court, again, in Om Prakash, that is yesterday's judgment, says, please go the extra mile. That's what they're saying. Go the extra mile and see if the 2015 Act applies to any case before you, whether you're a JGB or you're a court in normal circumstances. See if the 2015 Act applies, and please use a beneficial construction. My last point, which I wanted to make, was this is an area where it will not be successful if we do not have collaboration. Every one of our stakeholders has an important and extremely crucial job to do with regard to the child. And if each of us, any one of us does not do our job, the entire project is a failure. So the first thing is, I'm starting from inception. So the first contact that the child has with the system will be the police. So now ensuring that the first contact with the system is positive is a responsibility on our police officers. That's the first thing I would like to say. Our probation officers, because everything that our orders, everything that we do, how we treat the child, what are we going to do to rehabilitate depends on what the probation officer finds. So doing his job properly is important. If the background report and the social investigation report are done well, then everything will be revealed and it will be easier to find a solution to solve the problem. Child welfare police officer, we obviously dealt with. DCPO and SCPS also, in that sense, we are not here, but they have an important role to play because the overall policy, the financing, the infrastructure, all that depends on them, and they have an important role to play. And last but not the least, the JJB, both the magistrate as well as the social worker members have an important role to play because they're going to deal with the child also. So what orders you pass become relevant. And where is this relevant? Because we have two reports, two documents, and I would end by only focusing on these two. And this is a problem area in our juvenile justice law. We have a social background report that is at the first instance, the moment intimation is given to the probation officer that he has been apprehended, he's supposed to create a social background report, which gives the basic details about the child, where he's from, who his parents are, etc., etc. Is he in school? Is he not in school? That kind of basic details. The social investigation report is far more detailed. It gives everything you need to know with regard to the child in question. What are his parents like? Are they financially capable? Is he educated? Does he want to be educated? Why is he not educated? What is his interest? Why did he commit the crime? Who is influencing him? What is his family setup? Are his near relatives helpful or not helpful? All these details come out through your social investigation report. So if that document is done well, half our problem is solved. The solution will lie there. The second document which I want to enforce is, and unfortunately, to my knowledge, and correct me if I'm wrong, this document is not being used. And that's where the problem lies. We have an individual care plan. That's a document given at the back of our statute. It's a format. Number one problem, the first thing is it's a document which says, I find that this child has committed the offense. Now it's linked to the social investigation report. From the social investigation report, the causes of delinquency come through. And the factors which may help or not help also come through, right? Linking that to the individual care plan, which says, I find these are the reasons why he's committing an offense. How can we address that problem? Comes through your individual care plan. That is, I have a child A. His problem is he has nothing better to do. Let's put him in school. Why am I putting him in school? So that he is gainfully engaged elsewhere. Okay, the longer plan that I have with him. So why am I sending him out under the guidance of his parents, under the supervision of his parents? Why? The parents have to ensure he's educated. The parents have to ensure he does this, put him in sports. These are activities. Why you do that? Not just because, oh, you felt like, oh, it would be good for him to be educated. No. How does that address the problem that has led him to come before you? So the individual care plan becomes that document which says, and here is the problem, because number one, we don't know who has to make this document. We are currently just shifting responsibility. We say probation officer has to make it, but ultimately it is attached to the order of the JJB. So whether the magistrate and the social worker members as well have a role to play in formation of this plan, I think we should take up a positive role and say, okay, let me make this document. So I would say make an individual care plan, whether you're a probation officer or you are the member of a JJB, magistrate or otherwise, make sure this document goes with every order that you have. And what actually happens is, and that's where the problem lies, we have now started thinking of institutionalization. The last order in section 19 says, he shall be kept in an observation home for 3 years. Is that a sentence of imprisonment? Are we putting him in jail? Why did you keep him for 3 years? What good will that do? Other than keep him with people of his own age who've also done the same nature of things. Why you keep him with you for 3 years? Are you better than his parents? Keeping him behind in a closed room is a better solution? Possibly not. What do you do with him in 3 years? Are you going to educate him? Are you going to teach him vocational skills? So where? So the question is, are we treating, and because we don't have an individual care plan, we are treating this as a fallback as he's kept in the observation home for 3 years. 3 years is not a sentence. Nowhere does it say that you have to keep him and just close him up there for 3 years. And then after that, he goes back. What good does that do to any of us for society as a whole? Because after 3 years, he's just as he was, if not worse. Because now he's learned a few more tricks from others, which he had not imagined. Because somebody has done an offense another way. So the question is, are you treating that 3 years as a sentence of imprisonment, or are you going to treat that as an opportunity to reclaim the child? And that's where I wanted to enforce, use the individual care plan. Make sure that you use that 3 years wisely and for the benefit. I would urge you today itself, go back to your barracks and look at this individual care plan. It's not a very difficult document. It's a very simplistic document, which requires very few words that you need to write. But you are seeing the child before you, consider him, and note down what you think should be done. That individual care plan must go to the observation homes and the institutions that the child is, and they must follow and adhere to that as a document that this is the instruction of the court. And that is what is important. And that would be my final word, because I find individual care plans are not, across the country, not being used at all. In fact, I would say not even one person I have met till date who has said, yes, I've made an individual care plan. So with that, I think enough and more has been said from my side. I'll stop here. If you have questions, definitely I will try to answer them to the best of my ability. There was one question, I found it very interesting that Sir had mentioned about POCSO and minors in consensual cases. It's a very big challenge, sir. And in fact, the Law Commission has gone into this. The reality, as you mentioned, is it's true. What actually happens, and for the rest of the audience, POCSO is a gender-neutral statute. There might be cases where, and this goes back to our patriarchal thinking. We think only a boy will rape a girl. It could also be the reverse. POCSO recognizes the fact that there might be situations where a boy might be the victim of an offense, right? So now the question is complicated in a case where and POCSO doesn't make this exception for cases of consent. So if you have two children under the age of 16 to 18, in that bracket, both of them are 16 to 18, it becomes more complicated there. Both are 16 to 18, and they have willingly undertaken, and the unfortunate problem is it's a natural biological development marker, but unfortunately it's a status offense, it's a criminal act in our country. That is, if you indulge in sexual activity. So it attracts serious punishment. So if you've done it more than once, 20 years is your sentence. And if you've done it once, probably I think 10 years is a sentence. So very serious. And it becomes more complicated when you have them being 16 to 18, you do a preliminary assessment and send them for adult trial. Now that entire activity of consensual sexual activity is on his record forever, his or her. Okay, it's on his record forever. Now the question is, if it's a consensual, which Sir mentioned, if it's a consensual case, who is the offender? Is it the boy or is it the girl? That's a good question. But then that's a good suggestion, but then the letter of the law goes contrary, because if there is a factum of commission of offense, then by not taking cognizance, are you violating the law is a question. That's a important parameter to consider. You could also, they could be dealt with, your point I have taken positively, it could be that they could be both a child in conflict with law and a child in need of care and protection, right? But still, the letter of the law and the procedure that follows will follow because they have committed an offense. Now, the question what Sir placed was very interesting. That is, if both have consented, both are around the same age, who's the offender? And unfortunately, this is the statistics reveals, and the Law Commission itself has also noted this. We still continue a patriarchal approach where if it is a boy and a girl and a consent matter, the boy will be the offender and the girl will be considered a victim. So that is the reality in our country right now. Mm-hmm. Possibly. Mm-hmm. That's to the point that Justice Sharma mentioned, that is, if you see the materials, what the allegations make out who's the offender, then on that basis you will do.
Would make a difference there. It is because of
Hmm,
who
that's true.
instituted the suit first. If the guy's family instituted the suit first, the suit will be instituted in their name against the
I would say patriarchy comes one step earlier. In fact, the fact that he took my daughter and went away.
But the court cannot be
Court
patriarchal
cannot be,
when it decides a case.
So the question is, then you have to be a little more careful. That is this a patriarchal notion? Is the facts making out something else? Is a question that we have to consider.
Patriarchal, then even there are cases when the girl's family files a suit against the boy. Well, when the statement under 164 is recorded, the girl denies anything of that sort, or she'll simply tell a story that she ran away or got angry with her parents. In that case also, no matter how minor that girl is, we cannot
You can't compromise the case.
Because there was earlier the situation where the courts used to say कि 164 में बोल दिया है कि उसके साथ assault हुआ है, rape हुआ है, तो you will presume, मतलब कि एक single statement पर you could convict the accused.
Right.
But now because हमारा social scenario change हो रहा है, तो even the Supreme Court is also the view कि अब हम 15 साल से ऊपर की अगर लड़की भी है, तो we will try to see कि और situations क्या थे. रात के 12 बजे she herself opened the door, which is not very common in the Indian
That
scenario.
is problematic because that goes contrary to all the sexual assault judgments that have come till now.
So that is why we are progressing in the legal arena.
I would be very frank and honest and say at the trial court level, there's little much we can do. Because number one, you can't compound these offenses. They are serious offenses. They cannot be compounded. They have to go to the logical conclusion.
So ma'am, trial court के level पे ही तो सबसे ज़्यादा compromise, सबसे ज़्यादा
conversations
होती है मैम.
True.
क्योंकि जब तक sessions पर बात जाती है, वहाँ nobody cares कि victim क्या कह रही है और accused क्या कह रहा है. It is we who listen to both the parties.
Absolutely.
कई बार parties बहुत आतुर होती है कि वो जेल ही भेज करके मानेंगे लड़के को या उसके परिवार को. But it is the trial court जो उनको सुनती है, and if we feel even juvenile court में I have presided over the JJ board, तो वहाँ पर if we see कि लड़की को हम लोग अलग से भी पूछते हैं कि तुम बता दो, अच्छा like if there was an affair going on, तो even we are not favorable कि accused उसको juvenile को आप वो कर दो कि sentence कर दो या उसको 3 साल तक का सजा दे दो. तो I think कि letter of the law से अगर जाएं तो सजा मिलनी चाहिए. पर practically में आप conviction rate देख लीजिए, बहुत lesser conviction rate.
Absolutely, I agree. The point what I'm trying to make is very simple. That yes, many of these cases get compromised at their level. But the thing is, whether these are legal compromise or not, whether you are taking cognizance is a question. I will just leave that open. But the point is, whatever the evidence is on board before you, you will have to take the case to its logical conclusion.
हम compromise नहीं करते हैं. The girl comes, she gives a hostile statement.
Yeah.
That is the end of the litigation.
How will compromise come before your court? You'll have
तो हो ही नहीं
people
पाएगा.
turning hostile. That's how compromises appear before you. But the point is, what I'm trying to say is, whatever be the evidence, whatever be the transaction in reality, in fact, there might be cases that the two of them are married and have a family of their own. But still, the case will continue to its logical conclusion because you cannot compound this. With all the evidence or lack of it, you will have to come to a finding. So that is the reality of the trial court.
Several times we ask the prosecution to just file an application that you do not want to give any further evidence. Because ma'am, if the FIR writer did not come or the Vivechak does not come for the statement, there are multiple case laws. For example, judgment is just grammar, ma'am. Like what we have understood in past 5 years, it's grammar. On the same set of facts, on the same set of documents, I can convict a person, I can acquit a person. है ना? तो it's just कि हम same चीज लिखवा करके acquit भी करते हैं कि विवेचक को नहीं बयान नहीं कराया, और हम same चीज को pass by भी कर जाते हैं कि just because विवेचक को नहीं परीक्षित कराया doesn't mean कि entire evidence discreditable हो गई. तो it is not just a single witness or a single paper.
Right.
It's the matter on the whole itself.
On the whole, yeah.
तो conviction rate इसीलिए बहुत कम है मैम, because जजेस को भी दिख रहा है, prosecutors को भी दिख रहा है, और parties का भी कुछ टाइम बाद थक जाते हैं, लड़की के परिवार वाले भी.
We're dealing with social realities, and
हाँ,
that's
तो that
the
is why
problem.
ना मैम, it's not a
That's the problem.
black and white नहीं हो सकता.
I'll tell you what the Law Commission realizes. They've looked at foreign laws as well. There is a law called the Romeo-Juliet law. That is, if there's a pre-existing relation between the two, even if one is slightly older, say beyond the age of majority, we might be 21 for that matter, she's 18 or 17, the factum of a prior relation between them will draw out an exclusion. But the reality in our country is we can't adopt that simply. Why? Because we have made several strides to eradicate child marriage. So if we allow a clause like this to come into our country, we will be undoing whatever we have done to tackle the issue of child marriage, because our realities are different from the other countries. So what the Law Commission has suggested, and that is to empower the trial court. And they have said, of course, we cannot draw an exclusion for them, but we can provide a discretion to the judge that is less than the mandated, because there is a minimum punishment for POCSO offenses, less than the minimum where the need arises. So considering consensual cases, the judge who sees them, understands the realities of the case, is able to exercise a discretion. We are waiting for that kind of a provision to come into POCSO, because the operation of the law, status offense, because the same act done by an adult will not be a criminal case. But then there are cases, and I will give you an example. I will not name the High Court purposely. I know which High Court it is. There is a case of a 25-year-old man having a relation with a 13-year-old girl. And at the time of bail, the High Court has observed that this is not a case of lust, this is a relation between them. So at which point do we consider pedophilia? At which point do we consider grooming? Sexual grooming is also a reality. At which point is it? So we have to be very careful with this whole entire idea of consensual relations. So it's a problematic area. There is no fixed answer, but it's a very close. You might have cases like this also, where you might have major age gap, but are they, is that okay to have a 13-year-old with a 25-year-old man? We have 10-year-old age gap between people who are married as well, but 13 and 25, it's a question. True. True. True, true.
Like maybe she was not a very ideal doctor, but you're also not being a very
Ideal parent. Yeah. That's where I think the point that you made, that they are a child in need of care and protection, again, best interest. Are their parents acting in her best interests? Are the interests and wishes of the parents conflicting with the best interest of the child? By staying with them, is she going to be married off against her wishes? It's an important thing. They're worse. Yeah. Right. Maybe there's need for a mental health evaluation in these kind of cases. But let me tell you, a bad example doesn't make good law. So there might be aberrations, definitely. There will be many aberrations. I won't say some. There are aberrations where you might need a mental health professional to evaluate. There might be a lot of things that go to there might be medical health issues, or there might be environmental, parental, while they were raised, they faced some things, which is now manifesting in these ways. So these are things we will have to consider. Right. Until a few years back, until this judgment came of 2023, you had a problematic area where the girl is pregnant, goes to the doctor is required to mandatorily report that she's a minor and she's pregnant. That means somebody has committed a sexual act on her. So now doctors had to, otherwise they will be penalized. Now what will happen is, if now they are afraid that they will report it to the police, women will stop coming for medical assistance.
Ma'am,
That's a
I have
problem.
question.
Sir, please. Sir, hold your mic closer. I can't hear you.
Okay. Ma'am, whether prosecution and the defense counsel has a role to participate during preliminary assessment by the board?
Sir, the
Because it is an
section is
available order
vague.
under section 101, subsection 2, ma'am.
The section is vague. It does not provide for any right whatsoever. But I would say definitely by the judicial pronouncement, I will pull it out. It's in my folder. I'll give it to you after the session, where it says that even at the preliminary stage, the child has a right to lead evidence against it. There is a recent judgment, I think Barun Thakur, the matter of Ryan International. That matter, they've said at the preliminary assessment stage, definitely they have to be heard. So that means the right of the defense to lead evidence to counter. So I would say if they are saying defense, then prosecution also is a natural conclusion. But the section is vague. That's the unfortunate problem with preliminary assessment.
Another question.
Yes, sir.
Section 164 CRPC old law and 27 Evidence Act, whether applicable to a child?
That's a good question. Is it applicable to a summons trial? Because the procedure summons trial applies to juvenile justice. So if you're dealing with a serious offense, petty offenses, it's a summary trial. So if you have 164 applicable, yes. So the entire procedure of summons trial and summary trial apply according to the provisions. So whatever is natural in the CRPC for these two procedures will follow. Right. Will apply. So, but specifically the summary procedure does apply and summons procedure. Sir.
Ma'am, ma'am, I have a question with respect to the changing nature of crime. So what it is coming after this websites and internet, social media and everything on the peak, it's growing day by day, the kind of population that we have. And also this is a cross-border thing. IT Act as such does not take care of juvenile thing particular. There's no chapters where it says how this thing has to be dealt with. However, Budapest Convention 2001, if I'm not wrong, there are things which have been standard which have been set in that. And as well as till now, whatever seminars is going on, it is accused-centric kind of thing which I'm saying. So what about victims? Like, those, they all, the who are in need and care. So what can be done in that respect? Because you yourself have a international exposure. If you can highlight how internationally, countries are doing, because what I have, as a prosecutor, what I have felt, whatever we are speaking as of now, that a child should not be stigmatized and all that. But while a person and a police officer should not wear a dress while bringing a child or dealing with a child. But unfortunately, what I see, a court premises where there are police officers, advocates in robes, everyone sitting.
The entire environment is not exactly the best.
They are brought in courts for their statements before the magistrates. They are taken from one place to another.
Right.
So, these things I feel, and with respect to vulnerable witnesses rooms, how a child who has come for any deposition, how they should be. So how internationally it is dealt, and then with respect to the changing nature of crime, then about the internet, the dark web and all. Because a lot of times it may be a case that where a child is not involved with the other person in a crime, but online, he might be committing some kind of crime.
Right.
So can you put a little light on that?
Internationally, I would say there are plenty of conventions which talk about varied forms of child exploitation. That there's a list is quite a long one. I can pull it out at leisure. There are many. They talk about the worst form of child labor. There's talk about many. But yeah, a growing area is children and the digital world. And that, I think there's a lot needed to be done. I think the second part of your question, which you said, I think India is a leader in that compared to the rest of the countries. And I've seen this. I'll give you an example. I visited the Supreme Court of USA, and I'm emphatically telling you, they don't use one laptop, a phone, nothing is allowed inside the courtroom. They have one courtroom. So there is not a single electronic device in their courtroom. We are far ahead of them. And why I will say, with the specific point you said, we have vulnerable witness deposition center, we've taken one step further. And that is a Supreme Court judgment in rape child in street situations, which talks about a situation where there are children who have to depose before the court or they are victims. In that case, they said, don't bother bringing them before the court, have a video conferencing. Use video conferencing for these kind of situations. That is, if there are children involved, let them record their evidence from far away. They don't have to meet the accused. They don't have to come to court. They don't have to face the realities of the court premises. That would be a way forward. So I would say, in fact, more than other countries, India is the leader in these things. We are far more sensitive. And I think in terms of digital, we are far more active. So the e-courts that we are bringing in, and we have taken several strides further, most countries have adopted this. So yes, it's a reality in the international forum. People do realize it. There are conventions coming about it. But the solution that we need, our Supreme Court has given us. Okay, I think 4:15, we've been at it for an hour. If I think you have another session also, if I'm right. So we can conclude.
Thank you so much, ma'am. And now I will request our Deputy Director, sir, to please present a memento to our respected ma'am as a token of respect. मुकेश ऊपर कैबिन में कौन है? मुकेश? अच्छा, सोलंकी कनेक्ट करिए मैडम को. कनेक्टेड है, ठीक है. हमको अनम्यूट कर दीजिएगा. Thank you so much, ma'am. स्क्रीन पे आशा मैम को डिस्प्ले कर दीजिएगा. मैम का सेशन है अभी ऑनलाइन, और ज्वाइन करें और उनका सेशन मैम के बारे में थोड़ा बताना चाहूँगा. प्रोफेसर डॉक्टर आशा वाजपेयी मैम entered full-time academics commencing from the National Law School of India, University Bangalore, where she also obtained her MPhil and PhD in law. She has specialized in child rights law, public health law, access to justice for vulnerable and disadvantaged, involved in teaching, research, training, and gender justice issues, legal aid, clinical education, and legislative reforms relating to vulnerable for more than 3 decades. As Professor of Law and founding Dean of School of Law, the Tata Institute of Social Sciences, she designed the unique LLM course on access to justice for preparing community lawyers. She has also been involved in several law reforms, projects, and capacity building of judicial and law enforcement officials. She was project director of field action projects such as Legal Services Clinic for the Marginalized and Vulnerable Groups and Chunauti Challenge for Rehabilitation and Social Reintegration of Orphan Children in Institutions. Invited as amicus curiae and expert by Mumbai and Delhi High Courts in public interest litigation, she was also invited expert at the UNESCO high-level meeting on ECCE and by UNODC on education for justice. She has taught at several international law schools. She has several publications to her credit. Her book on child rights in India, Law, Policy and Practice, published by OUP, is now in its 3rd edition. Her other publications include Human Rights and Legal Services for Children and Youth, From Exploitation to the Empowerment by Macmillan, Adoption Law and Justice to the Child Sexual Abuse, Need for Law Reforms, etc. So we are very fortunate that Madam has spared her valuable time for this session, and Ma'am is joining us from Chennai. So thank you so much, Ma'am. And I will request you to please start your session, Ma'am.
I'm going to share this screen. I've already shared. Is it shared? Can you see my screen?
Yes, ma'am, we
Hello?
can see your presentation. Yes, we can see your screen, ma'am.
Okay, thank you. Thank you.
Yes, ma'am.
Okay. Hello. Okay, good afternoon, everybody. And you have been talking about children in conflict with law. But as you know, we have both children in need of care and protection and children in conflict with law under the JJ Act. So today, both of these categories of children need rehabilitation and reintegration, and social reintegration, as it is mentioned in Chapter 7 of the JJ Act. So Chapter 7 of the JJ Act talks about rehabilitation and social reintegration of children in conflict with law and children in need of care and protection. So both the categories of children need rehabilitation and reintegration, because that's the objective of the JJ Act of 2015. It's not punishment. It's not, it is mostly rehabilitation, reintegration, and so that they go back into the society as reformed people. So based on that, the entire Chapter 7 is on rehabilitation and reintegration. In the earlier session, they spoke about the individual care plan. Now, this individual care plan is a very important document for rehabilitation and reintegration of victims. The process of rehabilitation and reintegration of victims starts at the beginning at the beginning when the child is in an institution. As you all know, institutionalization is the last resort. Initially, there are various other orders that can be given. But when the child is an institution, whether child in need of care and protection, or CNCP, as we call in short, or CICL, as child in need in conflict with law, both these categories of children, when they are in institution, for instance, they have not got bail for CICL, or for children who have not got a family-based, uh, uh, rehabilitation, in the sense they have not been able to go to the family is not fit for them. So in those cases, they are in an institution. And the process of rehabilitation and reintegration starts as soon as they enter the institution. Whether they are in a special home, or they're in an observation home, or they're in a children's home, the process of rehabilitation and reintegration starts at that time. And the individual care plan is a very important document in that aspect. So how do we make it? You were told about the individual care plan format. What we did do is we joined together various expertise for rehabilitation and reintegration of for the child. We have the counselors, we have the doctors, medical doctors, we have the mental health experts, we have the what is that called, the superintendent of the home, the social workers in the home. All of them together, all their expertise is required for for preparing the individual care plan. And the court has always said the individual care plan is a very important aspect of any order. And also, the individual care plan has to be made by by an expertise of various sciences. For instance, you need social work, you need medicine, you need psychology, you need counseling, you need mental health, all of them together. And that is required in the individual care plan. So every individual care plan, if you go and see the format, or you must have already seen it, has the age of the child, the background of the child, and also what is the medical condition of the child, what kind of measures for improving the medical health of the child is required. Maybe some disease that, so what kind of reform is required for that. Then if it is a child who needs some kind of a mental health inputs, maybe a psychological inputs or a therapy that is required, so that comes into the individual care plan. Then what kind of nutrition the child needs? Maybe the child has some kind of a deficiency, so in that case that goes into the individual care plan. What kind of counseling the child needs? Maybe the child is in a trauma, so the child needs trauma counseling, so that goes into the individual care plan. What kind of education the child needs? That kind of, maybe the child has already gone to school, or the child has never gone to school, or the child is a dropout. All this goes into the individual care plan. And based on this individual care plan, you need to see what kind of measures are required for the child. And this is a dynamic document. It goes on changing. As the child develops, as the child grows, the individual care plan goes on changing. It can't be one static plan which you make when the child comes in the institution and when the child goes out. No, it goes on changing. It's a dynamic document that is there. And when the child is going out of the institution, then in that case, you have an exit plan also. What will the child do when he goes out or she goes out? So that, and what the child needs. The child needs shelter, the child needs finance, the child needs some tools. So all that is an individual dynamic care plan that is there. I would like to share with you something that I got an opportunity to do, since I have a time constraint here. I had an opportunity as an amicus curiae in one PIL or 182 of 2010, where I had an opportunity to do a rehabilitation and reintegration of certain orphan children who were intellectually disabled. Now, rehabilitation, as you all know, is a process that takes into account all the unique needs and circumstances of the child. So, as I mentioned to you, nutrition, health, education, food, mental health, all that is required. What are the needs and circumstances of the child for social reintegration? Because that's the aim of our JJ Act of 2015, and to promote the best interest of the child at every stage, whether it's education, whether it's nutrition, whether it is mental health, or whether it's physical health. All that you have to take the best interest into consideration at every stage, even for this. Now, secondly, I had a child who has been, say, sexually abused. A child sexual abuse victim is a child in need of care and protection under the JJ Act of 2015. You all are aware of it. Now, this child who's a victim of child sexual abuse, as we all know, is of betrayed trust. We as a society have failed him or her. We as a society has, betrayed the trust of the child. The child trusted an adult. The child trusted the person who looked after him or her. The child and that same person betrayed the trust. So that is a condition of betrayed trust. So rehabilitation of a child is equally important as punishing the offender. The offender is punished. What happens to the child? You leave the child? No, the child needs rehabilitation and social reintegration. And that's why Section 7 of the JJ Act is a very important section to promote the objective of the JJ Act. Now, since it's an online thing, I just would like to ask some of you, if you can give me, what do you think are the needs of a child sexual abuse victim? You can just put it in the chat box if you want, or you can just say it if it is possible. Any needs you think of? You have a child sexual abuse victim, say, in an institution, maybe an orphan child. What does that child need? What will you put it in the individual care plan? What kind of needs will be required for such a child? Any idea? Is it possible? Okay, so can I go ahead then? Okay, maybe it is not possible to say it. So rehabilitation includes medical needs, physical needs, psychosocial needs, educational needs, and protection needs. Maybe safety and security of the child is important after the sexual abuse. Maybe the child needs, because the same people may, or their friends, their relatives may come and threaten the child, or the child's maybe a dropout in the education, child's education may be stopped, and maybe the child needs counseling, the child needs medical needs, child is physically, some of physical needs are there, maybe the child is not physically, maybe some kind of a disability is there. So all kinds of needs assessment has to be done for rehabilitation. A first step, an assessment has to be done, a needs assessment has to be done, so that the survival and security of the child is taken care of. After this, after the rehabilitation and reintegration, are distinct elements of access to justice. Your access to justice is not complete, I would say, till the rehabilitation and reintegration happens. Yes, the accused has been gone to the prison, but the child still needs your help. The child still needs, for the entire access to justice, the rehabilitation and reintegration of a child are very important components as far as these victims are concerned. This seems to be the weakest component in our system. We need to strengthen this, and it's all in your hands. Many of you are doing it, but you need to see to it that we have to, even the witness protection is important. I remember in one case that I dealt with, the accused were arrested, but some family members of the accused went to the institution where the children victims were there, and they told the institution people that we are their relatives and we would like to meet them. So the institution allowed them, and inside they threatened the children. And later, after their visit, when the institution authorities visited the children were literally shivering. They had become pale and they were shivering because they were all were threatened. So the witness protection needs also are very important to be looked at when you're talking about rehabilitation and reintegration. Post-abuse trauma. Post-abuse trauma like anxiety, depression, memory lapses, insomnia, flashbacks. In the night, they get up crying. They get up crying in sweat, thinking of what happened to them. All this comes to them, anxiety. Many of them go into depression. And there are some psychosomatic symptoms like stomach aches and fever. Some are just scared of coming out of the house or trusting any other person. Some are, guilty that why it happened to us. Something is wrong with us. That is why it has happened to us. We are bad. We are wrong. They are, wrecked with guilt and shame. Parents and caregivers are equally traumatized. Sometimes the parents and caregivers are also so upset, so and that they say, oh, this has happened to you. Why it has happened to you? How it has happened to you? So they further traumatize the child. So healing is important. Healing of the child is important. This is a rehabilitation plan. This must be included in the rehabilitation plan, as it is called. Then you have post-abuse, medical support. Children need medical support. For instance, some of them may be pregnant because of the abuse that they have gone through. And when a child is pregnant, they may have to undergo, say, empty medical termination of pregnancy, maybe an abortion. And the post-abortive care has to be done. Or if they have delivered the child, then the post-delivery care is important for the child's health. There are free government hospitals who take care, but then all the medical needs are not taken care of. The examples that we have, the experience that we have, that many times in many of these government hospitals, all the medical needs are not there. Sometimes they tell us this equipment is not there, this medicine is not there, so you go and get it. So many times they are deprived if they have no one to look after them. Sometimes, as I mentioned to you, they lack equipment for certain tests. Oh, this equipment for this test we don't have. So families many times have trouble keeping up with all these additional costs, or if they're in an institution, the institution say we don't have funds for it. So that is where we have to take all this aspect into consideration. Many times the waiting list in the government is so long, and many have to make several visits before they get their turn. And many of them, suppose if they are poor, doing daily wages, then how can they do it? They can't afford it, and they lose their daily wages. So these kinds of problems needs to be addressed when we are talking about rehabilitation and reintegration orders. And education is a very important casualty as far as children who are victims of child sexual abuse. They must have dropped. Oh, we are not going out anywhere. We are too scared to go out anywhere. Or they may have dropped before the incident because they must have felt that if we go there, something is going to happen to us. Maybe some people change the school. If the child does not go, cries, does not go, they don't. So they say, okay, change the school. Sometimes they don't go to school. They just don't want to go to school. They're too scared to go to school. So these aspects impact the education, and because of that, the education is often suffered. So that aspect of order, it must see to it that their education needs are taken care of. The relocation. Many families, are ashamed that the child has been a victim of child sexual abuse. So they start receiving threats. So they try to change their location of the house. They go to a different house. They relocate. So in those relocation means jobs. Many times they do not get jobs. Sometimes they have to pay higher rent for relocation. Then, in case the abuser is within the family, then in that case, they have to be placed in shelter homes as the child is not safe in the home itself. And shelter homes have their own problems that are there. Now, need for documentation they need. Suppose I go to a bank to open an account. You need Aadhaar card, you need all those cards. So these people don't have those documents many times, especially children in institutions, orphan children in institutions. Where is the documents? Where is Aadhaar card? Where is PAN card? They don't have anything. And to get admission in school nowadays, it is clearly said no documentation is required. But for any program, any government schemes, any government benefits, you need some kind of a document. So getting the documentation, we have to make it easier for them to get the documentation. Then, so that kind of aspect has to be taken into consideration. Now, if you look at the international law on rehabilitation of sexual abuse victims, there are certain convention. One is the UN Convention on the Rights of the Child, which they were talking about in the earlier session, which, as you all are aware by now, has 4 core principles: right to survival of a child, the right to protection of a child from any form of exploitation, abuse, right to development of a child, right to participation of a child, and non-discrimination of the child. And everything has to be in the best interest of the child. So these are the core principles of the rights of the child. And based on these core principles of the rights of the child, we have a section in the UN Convention on the Rights of the Child, which says all the state parties who have ratified the convention, including India, we ratified the convention in 1992. State parties should take all appropriate measures to promote physical, psychological recovery and social reintegration of a child victim of any form of neglect, exploitation, or abuse. This, I put it in red because this is the most important aspect of the rehabilitation and reintegration of a child. Physical recovery, psychological recovery, social reintegration of a child back into the society, back into the community, and these victims have to be done that. So this is an important UN convention that is there. And the dignity and self-respect of the child has to be taken into consideration. There is an optional protocol on sale of children and child prostitution, which says that the children have to be rehabilitated and reintegration, even if they are victims of child prostitution and child pornography. Then there is a protocol to prevent, suppress, and punish trafficking in persons, especially women and children. This also talks about rehabilitation and reintegration of the child. Then you have the ILO Worst Forms of Child Labor Convention, which talks about the worst forms of child labor. That also talks about rehabilitation and reintegration of child victims of abuse and exploitation. Now we have recent developments. There is therapeutic category of law which talks about therapeutic jurisprudence, the healing aspect of it, to examine the therapeutic dimension of law with the tools of behavioral sciences. So law and behavioral sciences, law and social sciences, so that the impact of the abuse, the impact of exploitation is reduced and it is minimized, and so that it increases the potential for healing. It increases the potential for healing and rehabilitation. It examines legal rule. This therapeutic jurisprudence does not stop only at punishing the offender. It goes into seeing to it that the courts, the police officers, the judges, the lawyers all play their roles so that they heal the victim and they become therapeutic agents to heal the victim. This therapeutic jurisprudence is developed a lot. In our country also it has come, but it needs a further development so that you address the needs, emotional needs, physical needs, mental needs, educational needs, nutritional needs, psychological needs of the victim, and you heal the victim. You heal the victim. That's the part of access to justice. The entire justice will happen only when the victim is healed. not only when the offender is punished. I had the opportunity, as I told you, by the Bombay High Court, where I was asked as an amicus curiae. What happened in that was that there was this case in PIL of 182 of 2010, which was a suo motu public interest litigation in the Bombay High Court. Now, in this, what had happened was there was this Mumbai Mirror, which broke out the news of death of 5 children in a home near Mumbai, in Thane district, which is near Mumbai. It was 23rd August 2010. The Mumbai High Court took suo motu cognizance how the 5 children have died there. I was the amicus curiae in that case. 11 boys and 5 girls, we went and rescued them and closed the home, and the criminal cases were filed against the superintendent and the staff. The court in the PIL I asked for a child protection committee, and we had a child protection committee formed. We went around all the districts in Maharashtra saying that where is this such cases may happen. And we found another home in which we found 19 girls who were abused there. And there also we took those 19 girls. The girls were rescued, and with the study report of these 24 homes that we studied gave to the High Court. The High Court, gave various directions to improve the standards of the care of such children and victims, and for their rehabilitation and reintegration. This is the whole story of Chunauti that I'm talking about, which is a project that we did for children who were abused and for rehabilitation and reintegration of such children. Now, we started this project in 2012, and it went on until 2018. And through all these years, the court was with us. The directions were passed, and we as a committee saw to it that these directions were implemented. And it was a teamwork that went in and reported to the court. The court remained with us till 2018. Here is the child victim in the center. The High Court is here. The Department of Social Justice, Women and Child Development, Social Justice was there. The Directorate of Health was with us. The TIS, our project and our staff, the police, the experts and in institutions, the High Court committee that we had formed, the Children's Aid, which is an NGO there, an institution for children who stay there, and we had the funders for us. All of us together gave us, and also one important working together in this project were the media. All of us helped in this project. All of us cooperated in this project, and this project was done. And quickly going through this project, we did assessment of these children. As I told you, we brought all the children together, added the children in at home also, some few of them, and there were 100 children in this project. First thing we did was, since there were disabled children, and all orphans, first thing we did was a detailed assessment of all the children, their IQ, OTs, speech, EEG. That means individual care plan was done for each child. And based on them, and the needs were identified, a needs assessment. Did they need counseling? Did they need trauma counseling? What kind of life skills they need? Did they go to school? Have they gone to school? Have they never gone to school? Are they dropouts? What kind of vocational training they can get if they don't want to go to school? What kind of therapy they need? What kind of social reintegration we can do? So individual care plans were formed based on these assessments, and the implementation of these care plans was ongoing. As I told you, a care plan is a dynamic document. It can't be stopped at one stage. You have to go on changing it. So we went on changing the care plan as the children developed. We had to develop the capacity for the staff, superintendent, caretakers, everybody. Now, next thing that we did was we did interventions based on the individual care plans of each child, medical checkup, IQ of the child, SQ of the child, occupational assessment, what kind of work they can do, speech and hearing assessment of the child, and EEG, what kind of intellectual assessment is required. We made a counseling plan. We made a life skill plan. That means many of them didn't
Amitabh sir or Vivanshu sir, stage पे आ जाइए, please.
how to wear clothes. Many of them did not know how to eat. So all this life skill plan was done. educational plan. Somebody needs literacy, somebody needed to go to school, somebody needed to go to needed vocational training. All that was done. Occupational therapy plan, vocational training plan. All this was done in the individual care plan that was there. So we did activities that included counseling, life skills, special education, schooling, positive disciplining. This was required because what happened, many of these children had faced trauma. Many of these children had faced sexual abuse. Many of these faced physical abuse. So what was happening is they were using that because they had experience. They were trying to do that on the other members in the home. Many of the staff didn't know how to react. So many of them they started beating them up. But then positive disciplining aspects had to be taught to them. Then we explored the open schooling, National Institute for Open Schooling, because many of them had to be sent to open schooling after the schools were closed. Then for them, or they were overage, occupational therapy, dance therapy, toy bank activities, gardening training, planning for rehabilitation and reintegration, and a sign language. This was typical of this case because many of them did not know the official sign language. They had developed their own sign language that was there. So the official sign language had to be taught. So we found a lot of changes. Children had overcome their trauma. They were better. Stopped fighting with each other. They formed friendships. Children were able to form, stop quarreling and fight. They were also made to understand their rights. Many of them started thinking of the future. And they said, okay, well, we want to go out, we want to work, we want to earn. Some of them who could study or wanted to go to school, they were very happy when we sent them to school. Social skills of children improved, behavior problems changed, and children expressed a desire to learn, to grow, to develop. Then occupational therapy we did for them, education we did, independent living we did. Remember, all this was done with the help of police, with the help of courts, with the help of institutions, with the help of NGOs, with the help of government departments, and with all of us together. Okay, so it was a big teamwork. So we had a clear goal of social reintegration, and we had several new indicators that we developed, and we formed we had inclusive education for them. We put them in a school for normal children. It was not easy. They were not accepted first. We were asked to take them out, but then we had to tell the principal, talk to the teachers, talk to the parents, and the court also intervened, and we saw to it that they were in the school. We had special teaching for them down. A resource room was established as per the Samagra Siksha Abhiyan, the government scheme that is there. IQ test we found were not conclusive. Many of them took IQ test when they were very under trauma. So that IQ test should be repeated again. And these IQ tests were not standardized according to in all the institutions. They need to be standardized. That is there. Many hospitals, many districts did not have IQ testing equipment. So all these have to be developed that are there. After all this, 3 girls were referred for independent living through vocational training. They were trained in hospitality and they got jobs. They got jobs since they were orphans. We put them in jobs which gave them residence. So now they are doing very well, and they are into independent living on their own. One of them has even got married now. So we have now this replicable model that we have established, which are there. I'm not going into challenges. As I told you, lack of vision. We need a vision for this, policies for this. Many times wrong assessments in IQ, wrong labeling, lack of accountability, and lack of government-supported employment schemes for children within employment. These were the challenges that we faced. Now, these were the interventions that we did with those children. We can't reveal their identity. And then we have to see that they have got, these 3 girls have got the jobs. And one of them is the best employee where they are working. The government is also in the picture. The police were there with us. All of them were there with us. The courts were with us throughout, as I told you. This is the model. I can share that with you there later. So this is the model. We took a child rights based approach. We took a regular review. We have to see, we made
sorry to
protocol.
interrupt you, ma'am.
Yeah, I'm finishing. I'm
Yeah,
finishing.
ma'am.
Yeah.
Thank you.
So I'm just getting over. Now, there's this 2 minutes, 4 minutes film. If you can, I can show it. Otherwise, if you want, I can stop. This is the model, small thing that is there. If you can
Ma'am,
you hear
I
it?
have already shared this in the group, ma'am.
Okay, then I stop here.
Children are
I
the
can
world's
stop here.
best hope for future.
Should I stop here?
Thank you so much, ma'am.
Thank you.
Have a
Thank
good day,
you.
ma'am. Thank you,
Have a
ma'am.
good- Thank you.
अब हमारे बीच में श्री विभांशु जोशी सर उपलब्ध हैं और श्री अमिताभ सर है। मैं सर लोगों से निवेदन करूंगा कि हमारे पास 15 मिनट का समय है सर, तो कंक्लूड इसी से होना है ये पैनल।
कहीं रहने वाला हूँ। 10 साल मैंने लंदन में ब्रिटिश जो सोशल वेलफेयर बोर्ड है उसमें काम किया हुआ है और वर्तमान में मैं जो हमारे फॉरेस्ट ड्वेलर्स हैं जिनको हम आदिवासी या ट्राइबल्स बोलते हैं उनके बीच में काम कर रहा हूँ और मैंने 2 टेन्योर जेजेबी बोर्ड और सीडब्ल्यूसी के जो सिलेक्शन कमेटी उसमें भी मध्य प्रदेश की उसमें मैं रहा हूँ। तो उसके आधार पे मैं जो भी उद्धृत करूंगा प्रयास करूंगा करने का। Is it good if I speak in English and Hindi mix both? Yeah, because somebody mentioned that the Hindi that you speak in Madhya Pradesh is very difficult to comprehend. Okay. Right. Would you like to introduce yourself? No? Introduce the community. Okay, all right. So we have a very short span. My talk will be divided in 2 sections. One is about how the British government manages it. I don't know what your perception is. Having worked there was a very rich experience there. Care plans were mentioned here, that how care plans are being made, and that's where we are faltering. I'll give you 2-3 instances how the British Social Services or the Social Welfare Board manages it, the depths that they go to, and the depths they go to implement their policies. I'll give you instances to comprehend or to understand. First is you cannot, I'm talking in terms of the children's services part of it, because there are 2 parts. One is the adult services, the other is the children's services. For us, the children's services, of course, is more relevant. So they will go to the extent that you cannot leave your child alone at home, a 5-year-old, and go and get milk or bread or anything. That is also seen as an offense. So that creates grounds for the state to take your child away. So this is where they start. If you are a mother of, let's say, a 12-year-old, you cannot wear a nightie in the car and drop your child there at school, because that tantamounts to, or that leads to bullying in school, that tumhari mummy to nightie pehen ke aati hai. This happens with South Asian kids. So they will pull up parents on these regards also. So they're very strict about children being abused. Forget about children or minors abusing others. So they take it very seriously. But again, the system is failing. There's still armed robberies happening. Underage children are parts of these armed gangs. Citizens pray कि स्कूल अभी नहीं खुल जाए, क्योंकि बच्चे इतना हल्ला और शोर करते हैं पब्लिक ट्रांसपोर्ट में, ट्रेन्स में, बसेस में भागते रहेंगे, आप उनको हाथ नहीं लगा सकते। आप अगर क्लासरूम में झगड़ा हो रहा है तो टीचर के पास ये राइट नहीं है कि दोनों बच्चों को हाथ लगा के अलग कर दे, पहले वो ब्लेड से या चाकू से एक दूसरे को काट रहे हैं। So they have gone to that extent. So I see that the state is doing well. I have filled myself, I have interviewed so many people with these care forms that we have filled. There's a team of psychologists, there's a team of mental health professionals, and they're really good. You'll be impressed how they work, and they're very clear. Very dedicated people become part of these social service units. There are units, one of them was called under 16 pregnancy team, because the girls getting pregnant before 16 years of age. So there are dedicated teams working on that. And, in their own right, they're doing a good job. But then, why do you need these teams in the first place? That is the question. So I see the government agencies, the government departments playing a good role. So where is the problem? The problem lies in the social fabric. Two brothers will not live together after their marriage. There. And why do you think that is? एक शब्द है हमारी संस्कृति में, हजारों साल पुराना है वो. Can I use this? I think bend, stoop. Hello. I don't know how it starts. Can somebody help us with the mic? I have to bend actually. Not used to bending, metaphorically and literally also.
Hello.
Yeah. This is better, I think. Can you hear me? Still? Okay, yeah. So, वो शब्द है मर्यादा. कहाँ लाइंस ड्रॉ करनी है एक फैमिली को? ये जो विषय हमको बताया गया था वो था कि सोसाइटी में जो जुवेनाइल ऑफेंडर्स हैं और चिल्ड्रन दोज आर इन कॉन्फ्लिक्ट विद लॉ, हाउ कैन वी इंटीग्रेट और गेट देम बैक. हमारे यहाँ बहुत अच्छा सिस्टम है. वहां पे इस्कॉन का मंदिर था, वहां पर जो उसके चीफ प्रीस्ट थे, इस्कॉन के बारे में सभी को पता है, इस्कॉन के मंदिर सभी को पता होगा आपको. तो he was a white British man and he said that India has such a wonderful system. And I kept thinking, what is he going to say? हमारे ब्रिटेन से कौन सा अच्छा सिस्टम है? And he said it is the caste system, the Varna system. You have stratified, divided your society in such an intelligent manner. Right? हम क्या जब भी हम कास्ट के बारे में सोचते हैं तो हमको डिस्क्रिमिनेशन, अगड़ा पिछड़ा, इनको रिजर्वेशन मिल रहा है, हमको नहीं मिल रहा है, ये सारी लड़ाई हम लोग लड़ते रहते हैं. There's a book, very good book. I can post it on the group. It's called Caste as a Human Capital. Now, why am I saying this? Is because I run an NGO. I don't like the word, but that's literally what it is. We are trying to get in touch with different Samaj and Jatis in Bhopal. The Khatiks, the Valmikis, या आप जो भी समाज बोले, हम हर जगह जाने का प्रयास कर रहे हैं. यूरोप में ये व्यवस्था नहीं है जातियों की, जहां आप जाकर उनसे संपर्क कर सकें और उनको बता सकें कि आपको अपने समाज का, आपकी जो बस्ती है वहां पर बच्चों का ध्यान देना है. हमारे यहाँ ये व्यवस्था है. All forms of crime can come down. A lot of discrepancies that we have or have been facing in our social fabric can be brought down. I think it's supposed to be a panel, so maybe you want to pitch in. I can pitch in again. Actually, he wants to have the last say. It's a very good technique. So, am I making sense? Some feedback, if you can give. Am I making sense? Any questions so far? Any? सब घर जल्दी जाना चाहते हैं, I think. जी? अब कैसे हो सकता है? Anyways, so what I'm trying to say is the basic unit of society is family, परिवार, जो वहां पर टूट गया है. आपको आपके पिता से कैसे बात करनी है? हम काफी बात करते हैं पेट्रियार्की की कि भाई बहुत सारी खराबियां हैं. हाँ हैं, बहुत सारी खराबियां हैं, लेकिन रामायण महाभारत ने आपको एक सिस्टम दिया है कि अपनी भाभी से कैसे बात करना, एक देवर भाभी का क्या रिश्ता होता है. वहां पर वो मर्यादा है ही नहीं, उनको समझ में ही नहीं आता है, उनके सिस्टम में ही नहीं है. पिता पुत्र के संबंध कैसे होते हैं? 35-40 वर्ष के पुत्र को भी यदि पिता बाजार में चिल्ला दे तो वो सुन लेता है. वहां ऐसा नहीं होता. वहां 16-17 साल के बाद आप बच्चे को घर से निकाल देते हो, और जब आप बूढ़े होते हो तब वो ध्यान नहीं देता है. तो हमारे यहाँ एक व्यवस्था बनी हुई है. We have a pre-existing system, but unfortunately what we're trying to do, all these presentations were very good. I got to learn a lot, but what we're trying to do essentially here is we're trying to copy the West, right? These care plans, these child in need, these are very good things. But for some reason, maybe because of the colonial hangover, we believe that whatever comes from the West is good. And maybe whatever we have right now always has a problem, especially caste. So my appeal to all of you being in law enforcement in different forms is that try and remember what Rabindranath Tagore said. He said that भगवान ने सारे देशों को एक अलग प्रश्न पत्र दिया है. उनकी समस्याएं अलग हैं, उनके प्रश्न अलग हैं. तो स्वतः ही उनके जो उत्तर हैं वो भी अलग ही होंगे. So if we start working on families which are already strong, एक चाचा भी अगर बच्चे को समझाए तो बच्चा समझ जाता है. वहां पर ऐसा नहीं है. वहां पर पुलिस का रोल, लॉ एनफोर्समेंट एजेंसीज का रोल बहुत महत्वपूर्ण है, क्योंकि परिवार तो वहां विघटित हो गया है ही नहीं. 51% of the people in UK are now divorced. The only marriages that are working are the second or the third marriages. They are in a minority. तो उनसे सीखना अच्छी बात है, बहुत अच्छी चीज मैंने भी सीखी. But my urge to you and the wider civil society and the citizens of this country is that try and capitalize on the resources that exist. And that is connecting with different samajas. Try and make them understand कि आपके बच्चे कहाँ जा रहे हैं, किस दिशा में जा रहे हैं. वो सुलोचन का नशा करते हैं. I was in the selection committee of, as I mentioned earlier, JJB and CWC. Many social workers from all the 55 districts of Madhya Pradesh would be there. मंडला के आसपास वहां पर बच्चे नशा कर रहे हैं. शायद अमरकंटक के का जो एरिया है वहां पर भी आ गया है इस प्रकार का नशा. So there are several agencies which are working. There are, I think, rackets running to destroy our futures. माँ बाप का ध्यान नहीं है तो आपको माँ बाप को पकड़ना पड़ेगा. You cannot reform, like this is a very Western approach that you know, target the child and try and improve him or her. You have to make parents the stakeholders in the welfare of the child. अब हम किसी ना किसी समाज से, किसी ना किसी जाति से आते हैं, तो try and talk to those leaders, take them in confidence and say कि आपकी जो समाज के इतने सारे लोग हैं, ये जो बाहर घूम रहे हैं बच्चे, स्कूल नहीं जा रहे हैं, तो इनका थोड़ा ध्यान दीजिए. हम आपकी क्या सहायता कर सकते हैं उसमें बताइए. So these leaders wish to connect. I was in Nagaland for about 20 days, bang on the border with Burma. So I held certain sessions there for Assam Rifles. I do consulting work with security forces also. So I started speaking about something and they could not connect. पीछे लोग बैठे थे, आगे बहुत senior लोग बैठे थे. And I was trying to connect with the people behind, trying to ask them that this can be done in a better way, X, Y, or Z. After a while, I realized that they would not speak because the elders were sitting at the front. There's a term called Assam Rifle से कुछ लोग अगर यहाँ पे हैं deputation पे तो मुझे नहीं पता. तो एक term होता है GB, which means गांव बूढ़ा. And then there's a chairman of the council, and then the third person, most powerful person, is the youth leader. So if these three people are with you, then you can reform that society. And that is exactly what the Indian government has been doing in Nagaland via Assam Rifles, that they're trying to connect with the society today. Coming back to my argument, after which I'll give my colleague a chance, a fair chance, that unless we do not connect with our existing resources at the government level or as a department or as a judiciary or as a police department or as public prosecutors, you can succeed. But as a society, we may still fail. Because you can have the best systems in place, and if your social fabric is being eroded, then I think even the gods and the goddesses cannot help us. So with this appeal, I think, unless you have any questions, maybe after he's spoken, I'm very happy to reconnect back with you. Thank you. You have a question?
सिस्टम को कास्ट सिस्टम से कैसे कोरिलेट करेंगे?
नहीं, मैं ये बोल रहा हूँ कि जो जुवेनाइल, जो चाइल्ड इन कॉन्फ्लिक्ट जो होता है, विधि बाधित जो बच्चे होते हैं, वो किसी समाज से आते हैं.
बच्चे किसी न किसी समाज से आते ही हैं सर।
हाँ, तो उसी से संपर्क करें, उस समाज से संपर्क करें कि भाई आपके ये 15 या 20 बच्चे इस बस्ती में जो रहते हैं, इन पे थोड़ा ध्यान दीजिए। आप इनके जो माँ बाप हैं इनको समझाइए। दोनों माता पिता यदि शराब पी रहे हैं, हमारे इधर ऐसे केसेस हैं, आदिवासी समाज में भी है, मैं बिलाला समाज में काम करता हूँ, तो बच्चे को केवल समझाने।
पर्टिकुलर एक रीजन से रिलेटेड हो सकता है, जैसे सर आपने नॉर्थ ईस्ट की बात की थी, तो ट्राइबल रीजन के बेस पे वो हो सकता है, बट पर्टिकुलर कास्ट सिस्टम से कोरिलेट करना है, समझ में नहीं आ रहा है। वो तो हर एक फैमिली की बात कर रहे हैं, फैमिली हर कास्ट में होता है।
बिल्कुल होता है, और उस कास्ट के कुछ लीडर्स होते हैं कि नहीं?
लीडर्स का बहुत बड़ा रोल नहीं है इसमें सर,
हाँ,
ये
वही तो मैं
फैमिली
बोल
का
रहा
रोल
हूँ।
है।
हाँ बिल्कुल, आई एग्री विद यू, नहीं है रोल, होना चाहिए, ये बोल रहा हूँ मैं। हो सकता है, पोटेंशियल है, ट्राई करके देखिए।
गवर्नमेंट एजेंसी डिफरेंट, जैसे आपने कहा आपकी एनजीओ है और बहुत सारे एनजीओ ये काम कर रहे हैं सर,
सफल हो रहे हैं हम।
बहुत हद तक हमारा जो ट्रेडिशन है उस हिसाब से सफल है, इसलिए हम वेस्ट से डिफरेंट है सर।
हाँ, तो वही तो बोल रहा हूँ ना, लेकिन आदर्श स्थिति में पहुंच गए क्या हम लोग?
इसका कास्ट सिस्टम से हर कास्ट में इस तरह जो फैमिली हमारा बैकग्राउंड जो ट्रेडिशन का रोल है सर, वो है ही एक मर्यादा है हमारे यहाँ जो वेस्ट में नहीं है।
हाँ।
उसका पर्टिकुलर एक कास्ट से कोई लेना देना नहीं है, हर कास्ट में ये चीजें हैं,
एक
क्योंकि ये
कास्ट को नहीं बोल
ट्रेडिशन
रहा हूँ
हमारा
मैं।
कंटिन्यू करते आया है।
एक कास्ट को नहीं बोल रहा हूँ मैं सारी
पूरे
कास्ट को
कास्ट सिस्टम की बात कर रहे हैं सर,
हाँ।
कि हर कास्ट में अलग अलग लीडर की बात करें, इसलिए मैं बोल रहा था।
तो मैं सारी कास्ट को बोल रहा हूँ, मैं सिर्फ
ठीक बात है।
हाँ, ओबीसी को भी बोल रहा हूँ मैं, SC ST को भी बोल रहा हूँ, ब्राह्मण ठाकुर सबको बोल रहा हूँ मैं। अब आप रीवा में चले जाएंगे तो वहां कास्ट डोमिनेंट नहीं है, राइट? वो रीजन उस प्रकार का है कि वहां पर इक्वेशन अलग होती है।
इसका एक दूसरा एस्पेक्ट क्रिएट होगा सर, कि हम डिस्क्रिमिनेशन को एक तरह से बढ़ावा देने की बात कर रहे हैं।
अरे भाई, आपने कास्ट तो आपने रिकग्निशन दिया है, आपने रिजर्वेशन दिया है कि नहीं उनको? आपने कैटेगरीज बनाई है ना? हाँ, तो वो तो है ही, कास्ट तो रियलिटी है आपकी, देश की रियलिटी है कि नहीं? कास्ट है, वर्ण भी है, तो मैं केवल उसको माध्यम बना रहा हूं एक सकारात्मक प्रयोग करने के लिए। ठीक है, हम बाद में बात कर सकते हैं, आपकी इच्छा होगी तो बाद में कर जी।
सॉरी टू इंटरवीन सर, क्योंकि हमारे पास समय का बहुत लिमिटेशन है, तो मैं आप रेस्पेक्टेड श्री विभांशु जोशी सर के बारे में 2 लाइन बताना चाहूँगा। सर मोटिवेशनल स्पीकर हैं, एडवोकेट हैं, राइटर है, सोशल वर्कर है, थिंकर हैं, और ही वाज अ मेंबर ऑफ board member of National Bal Bhavan, an institution of Ministry of HRD, Human Resource Development, under the leadership of Prime Minister, the then Prime Minister, Swargीय Shri Atal Vajpayee sir. And sir is our regular faculty for the courses we are conducting for crime against women and children. So I will request Vivanshu Joshi sir for his address.
देखिए, चिंता मुझे भी घर जाने की है। मेरे बेंगलोर से मेरे मेहमान आए हुए हैं, इसलिए आप चिंता मत करिएगा, मैं जल्दी 5 मिनट में ही अपनी बातें खत्म करने वाला हूँ। तालियां। सबसे पहले तो मेरी जो आपको स्माइली है वो आपसे रिक्वेस्ट करती है, स्वयं खुश रहें और दूसरों को खुश रखें, ये जीवन में बहुत ज़्यादा जरूरी है। कानून पर आज मैं बिल्कुल भी आपसे बात नहीं करने वाला हूँ, ऑल्दो मैं पूरे देश में IAS IPS जजेस सबको कानून पढ़ाता हूँ। राष्ट्रीय बाल आयोग के लिए मैं कानून वाचक हूँ। राष्ट्रीय बाल आयोग के अध्यक्ष ने मुझे उपाधि दी है कानून वाचक की। देश में 1000 से ज़्यादा कानून पे मेरे व्याख्यान पूरे देश में हो चुके हैं। कई प्रिंसिपल डिस्ट्रिक्ट जजेस जो हैं वो मुझे अपने कोर्ट रूम में बुलाकर सम्मानित कर चुके हैं। हालांकि मैंने काफ़ी कोशिश करी थी कि जस्टिस JK महेश्वरी साहब भी आज इस कार्यक्रम में ऑनलाइन जुड़े, लेकिन वो चूंकि आज मणिपुर में है तो उन्होंने मुझसे कहा कि विभांशु मैं आज नहीं जुड़ पाऊंगा। तो हम सबसे पहले जो नया वर्ष 2025 है वो आपके लिए शुभ हो। CAPT में आपका जोरदार स्वागत है, और सबसे अच्छी बात यह है कि आज यहाँ पर CAPT ने व्रत का भी साबूदाना आपके लिए रखा था। ये इनकी एक ऐसी सोच है जो हमें यह बताती है कि हमें जब भी किसी व्यक्ति के बारे में, विशेषकर जब वो बच्चा हो, तो हमारी सोच बहुत बारीक होनी चाहिए। एक एक व्यक्ति का, जैसे CAPT ने ख्याल रखा कि एक भी व्यक्ति यदि व्रत वाला है तो उसके लिए साबूदाना यहाँ पर उपलब्ध होना चाहिए। तो जब भी हम कोई भी केयर प्लान बनाते हैं तो हमारा उसको बनाने का मकसद उस व्यक्ति की विशेष जरूरतों को देखते हुए बनाया जाना चाहिए। देखिए, जुवेनाइल जस्टिस सिस्टम या जुवेनाइल जस्टिस एक्ट ये आज के परिदृश्य में बहुत ज्यादा महत्वपूर्ण होता जा रहा है, क्योंकि आप जैसे जैसे समाचार पत्रों में पढ़ेंगे देखेंगे, बच्चों को अपराध के लिए लगातार दुरुपयोग किया जा रहा है। ऐसे में बहुत ज्यादा जरूरी है कि उन बच्चों का जिनको कॉन्फ्लिक्ट विद लॉ के लिए इस्तेमाल किया जा रहा है, उनको वापस समाज की मुख्य धारा में लेकर आया जाए, क्योंकि वो समाज वो यदि कहीं भी किसी जगह रखे जाते हैं ऑब्जर्वेशन होम्स में, तो 3 साल बाद वो वापस समाज में आकर जुड़ेंगे। यदि वह हमारे समाज के अनुरूप नहीं हुए तो वो पुनः हमारे लिए नुकसानदायक हो सकते हैं। इसलिए हमारे लिए बहुत जरूरी है कि हम उन्हें समाज की मुख्य धारा से जुड़ेंगे। मैं आज कानून की यहाँ बिल्कुल भी बात नहीं करने वाला हूँ। उसके लिए देखिए, मैं अंतिम ओवरों में बैटिंग करने आया हूँ। पुराने बल्लेबाज सारे रन बना चुके हैं। मेरे लिए जीत के लिए 1-2 ही रन बाकी हैं, उनको खत्म करने वाला हूँ। बहुत बड़े पोएट जो कि विलियम वर्ड्सवर्थ 1802 में बड़ी सुंदर बात कह गए हैं, जो कि जुवेनाइल जस्टिस एक्ट पर साफ तौर पर लागू होती है। विलियम वर्ड्सवर्थ कहते हैं, द चाइल्ड इज द फादर ऑफ द मैन। उनका कहना है कि पोएट का कहना है कि जो बचपन में खूबसूरत इंद्रधनुष में देखा करता था, वही आगे चलकर मेरे जीवन में मुझे दिखाई देता है। तो बचपन में जिस तरीके का जीवन होता है, वही जीवन आगे मनुष्य के जीवन में आता है। अर्थात पोएट ये कहना चाहते हैं, जो कि जुवेनाइल जस्टिस सिस्टम का केयर प्लान भी कहता है, ए पर्सन्स बिहेवियर एंड हैबिट्स डेवलप्ड इन चाइल्डहुड शेप देयर पर्सनैलिटी एज एन एडल्ट। तो हमारी हमेशा कोशिश ये रहनी चाहिए हमारे चाइल्ड केयर प्लान में कि उनका जो एडल्ट शेप ले वो इतना बढ़िया हो कि समाज को श्रेष्ठ भारत बनाने के लिए अग्रसर हो। देखिए, हम 2 प्रिंसिपल्स पर हमेशा बात करते हैं, बेस्ट इंटरेस्ट ऑफ द चाइल्ड और चाइल्ड फ्रेंडली प्रोसीजर्स। ये 2 ऐसी पटरियां हैं जिस पर बाल विकास की रेल दौड़ती है, बेस्ट इंटरेस्ट ऑफ द चाइल्ड और चाइल्ड। और जो हमारा जो डेस्टिनेशन है वो है बच्चे का डेवलपमेंट। मेरा ये मानना है कि जो हमारा जुवेनाइल जस्टिस सिस्टम है वो 5 खंभों पर, 5 पिलर्स पर टिका हुआ है। पहला पिलर है सरकार, दूसरा पिलर है संस्थाएं, तीसरा पिलर है समाज जिसे हम समुदाय बोलते हैं, और चौथा पिलर है मीडिया, और 5वां पिलर है परिवार। जब ये 5 पिलर मजबूत होंगे तो जो जुवेनाइल जस्टिस सिस्टम का जो ब्रिज है, जो विक्टिम बच्चे से लेकर उसको विकास की तरफ लेकर जाता है, वो पुल तभी मजबूत होगा जब ये 5 पिलर्स जो जुवेनाइल जस्टिस सिस्टम के हैं वह मजबूत होंगे। तो सरकार के तौर पर हम जैसा जानते हैं कि सरकार के जितने विभाग हैं, जेजेबी हैं, CWC हैं, इन सबको मजबूत होना चाहिए। पुलिस विभाग को मजबूत होना चाहिए, शिक्षा विभाग को मजबूत होना चाहिए, ऑब्जर्वेशन होम्स अच्छे होने चाहिए। ऑर्गेनाइजेशंस के बारे में मैं जरूर कहना चाहूँगा, जितने NGO हैं उसमें यूनिसेफ भी इंक्लूडेड है। सबसे अजीब बात यह है कि आम तौर पर भारत की जितनी सामाजिक संस्थाएं हैं वो शासन या CSR के पैसों पर ही आश्रित होती हैं। उनके निजी कार्यों में बहुत कमी आ चुकी है, जो कि एक चिंता की बात है। वो सिर्फ सरकारी फंड पर आश्रित होती हैं, सीमित दायरे में काम करती हैं, उन्हीं लोगों के बीच में काम करती हैं। मैं मध्य प्रदेश बाल अधिकार संरक्षण आयोग का सन 2011 से लेकर 2014 तक सदस्य रहा हूं। मध्य प्रदेश की SCPS स्टेट चाइल्ड प्रोटेक्शन सोसाइटी का मेंबर रहा हूं। 1993 से मैं मानव अधिकारों पर काम कर रहा हूं। मुझे याद है कि 1993 में इलाहाबाद का, आप जानते होंगे, अमरनाथ झा हॉस्टल, AN झा हॉस्टल, जहाँ की सारे के सारे एक ज़माने में लड़के IAS हो जाया करते थे, लड़के लड़कियां, वहाँ पर 1993 में अमरनाथ झा हॉस्टल में मैं मानव अधिकार कानून पढ़ाने 1993 में गया था। मैं प्रेस काउंसिल ऑफ इंडिया की तरफ से भारत का पहला पेड न्यूज़ कमेटी का मेंबर हूँ, जिसमें मेरे साथ जो सहयोगी सदस्य थे जिनके समकक्ष मैंने मिलकर काम किया है, उनका नाम है जस्टिस कृष्णा अय्यर जी के साथ, जो कि एक बहुत बड़े जज माने जाते थे देश के। पीआईएल की शुरुआत उन्होंने, तो 1996 में मैंने जस्टिस कृष्णा अय्यर साहब से साथ एक हैसियत से पेड न्यूज कमेटी का मैं मेंबर रहा हूं। तो मेरा जो अनुभव बच्चों को लेकर है वो ये कि अब भारत, जैसा कि हमारे साथी अमिताभ जी ने बहुत साफ तौर पर कहा कि दुनिया का समाज बहुत छोटा होता जा रहा है, परिवार बच्चों से दूर होता जा रहा है। आज हम भारत भी बहुत तेजी से, अभी तक हम न्यूक्लियर फैमिली सिस्टम की बात करते थे, नाउ वी हैव वेंट अप टू माइक्रो न्यूक्लियर सिस्टम। माइक्रो न्यूक्लियर सिस्टम मतलब माता पिता और एक बच्चा। ऐसे में हमें जुवेनाइल जस्टिस सिस्टम को बहुत मजबूत रखना होगा, क्योंकि हमें किसी को नहीं मालूम किसके परिवार का कौन सा बच्चा अपराधियों के संरक्षण में आ जाए और अपराधी के द्वारा उसका दुरुपयोग किया जा सके। हालांकि कानून देश में मौजूद है, उन पर मैं बात नहीं करूंगा। जुवेनाइल जस्टिस एक्ट की धारा 83 आपको बताई जा चुकी है, और 93 भी, जो भारतीय न्याय संहिता 2023 की धारा 93 भी आपको बताई जा चुकी है, जो कि नया संशोधन है। तो इस तरीके से मैं बस आप लोगों से यही अनुरोध करूंगा कि बच्चे के सर्वोत्तम हित में काम करें और स्वयं खुश रहें और दूसरों को खुश रखें। धन्यवाद, नमस्कार।
थैंक यू सो मच सर। अब मैं हमारे आदरणीय डीआईजी महोदय से रिक्वेस्ट करूंगा कि सर लोगों को मोमेंटो प्रदान करें एज ए टोकन ऑफ रेस्पेक्ट। सबसे पहले श्री विभांशु जोशी सर को।
और जरूरत पड़ने पर परिवार में अंगदान जरूर करिए, ये मेरी अपील है। और विशेषकर पुरुष साथी, जब भी परिवार में अंग की जरूरत हो तो कहिए मैं हूं ना। मैंने 2009 में लाइफ किडनी डोनर आपके सामने खड़ा हूं।
Thank you very much, short and sweet and with lot of a smile.
सर
थैंक यू सो मच सर। और मैं डीआई सर से निवेदन करूंगा सर यहीं आसन ग्रहण करें। निदेशक महोदय बस पहुंच रहे हैं, हम लोग वैलिडिक्शन सेरेमनी शुरू कर रहे हैं विद इन 2 मिनट्स। थैंक यू सो मच सर। और हम लोग प्रोसीडिंग शुरू करें उसके पहले मैं थोड़ा एक इम्पोर्टेंट अनाउंसमेंट करना चाहूँगा। ये हमारे पास एक लिस्ट है अटेंडेंस की, इसमें सभी अधिकारी साइन कर चुके हैं। कोई अधिकारी जिन्होंने साइन नहीं किया, चलिए थैंक यू। और मैं बस 2 मिनट का समय ले रहा हूँ सर।
ठीक ठीक डाल रहा हूँ मैं इसको। चलो
of case law, statutory provisions, and guiding principles from international norms highlighted the robust yet evolving framework aimed at protecting child's rights. The next session was delivered by Dr. Asa Bajpai online from Chennai. She is a noted author and former founding dean and professor of law at TIS, Mumbai. Her presentation focused on the rehabilitation and integration of children in need of care and protection, particularly those affected by child sexual abuse, CSA. Key points and observations given by her was rehabilitation as a weak component, 2. Need for post-abuse support, 3rd was core principles of the UN Convention on the Rights of the Child, that is UNCRC. Next one was she elaborated on right to life, survival and development. And the last one was respect for the views of the child. She linked these principles to the Indian Child Protection Framework, showing how they inform policy and practice in addressing the rights of CNCP and CSA victims. Intervention-wise coverage, she mentioned from 2012-2018, and she presented data-driven insights on the effectiveness of various interventions from 2012 to 2018, analyzing the gaps and areas for improvement in rehabilitation services. Good practices in child protection. Dr. Vajpayee shared examples of best practices and successful models in child rights, advocacy and rehabilitation. These examples illustrated how effectively community engagement, coordinated institutional responses, and innovative support programs can enhance outcomes for vulnerable children. Mr. Amitabh, while talking in the last session, he was talking about what the job he has done, and here in Bhopal, he is working with Adivasi children. And then he mentioned about the role of Gaon Budha, youth leaders, and the various experiences he got in Nagaland while doing job with Assam Rifle there, deployed at the borders there, guarding 1600 plus kilometers of Indo-Myanmar border. Dr. Vajpayee further mentioned about 5 pillars, that all these 5 pillars are required to do their job in consonation, so that we have a synergy and we are able to achieve the target. So let us play our role in each role given to all the pillars for the welfare and protection of the care and protection of the children who are in conflict with law. So this was the summing up of the sessions we had from morning till half an hour before we had, and hope this will be very useful for all of us, and we will be our resolve to do good for the children will get a proper boost. Thank you very much. All the very best.
Thank you so much, sir, for the summing up report. And now I'll request Vinod, please play the video of Honorable Justice, sir. Pawan, light off कर दीजिएगा स्टेज का, प्लीज.
हम लोग यहाँ दिखाई देख सकते हैं ना?
जी सर.
Prison and Correctional Services, Madhya Pradesh, Shri Shailesh Kumar ji, DIG, CAPT Bhopal, Shri Prakash Barodia ji, Assistant Director, CAPT Bhopal. आज हम लोग फर्स्ट नेशनल सेमिनार और इसके वैलिडिटी फंक्शन के लिए एकत्रित हुए हैं. इस फंक्शन की विषय वस्तु जानने पर मुझे मालूम पड़ा कि कुछ अनछुए विषयों पर डिस्कशन हुआ है. जुवेनाइल जस्टिस jurisprudence, rehabilitation and reintegration of children in need of care and protection. यह यह विषय काफी सारगर्भित है एवं नया दृष्टिकोण और विशेष प्रकार की संवेदना की मांग करता है। इस प्रसंग पर मुझे बोवन और जो फ्रेंच राइटर है उनका एक फेमस कोट याद आता है, जब वो ये कहते हैं कि इमोशंस हैव टॉट मैनकाइंड टू रीजन। आदमी ने भावनाओं के माध्यम से तर्क करना सीखा है। एडजुडिकेशन के सेंस में हम लोग बोल सकते हैं कि सेंसिटिविटी हैज टॉट वेरियस टू एडजुडिकेट। ये सेंसिटिविटी जो है, ये शायद जुवेनाइल जस्टिस के लिए एक मूल मंत्र है, एक शी एंकर है। पुलिस ऑफिसर्स, पुलिस पर्सनल, डॉक्टर्स, लॉयर्स, जजेस, और अब अगर हम देखें तो डिपार्टमेंट ऑफ वुमेन एंड चाइल्ड डेवलपमेंट या डिपार्टमेंट ऑफ सोशल जस्टिस, ये सब वो लोग हैं जो जुवेनाइल जस्टिस से किसी न किसी रूप में जुड़े हुए हैं। तो इनसे एक सेंसिटिविटी, विशेष प्रकार की संवेदना की अपेक्षा है। एक जजमेंट में मैंने रिपोर्ट करते हुए कहा है कि लॉयर्स, जजेस, पुलिस ऑफिसर्स, डॉक्टर्स, दे आर लीडर्स ऑफ सोसाइटी। ये कुछ ऐसे प्रोफेशन हैं, कुछ ऐसे सर्विसेज हैं जहाँ आदमी किसी न किसी रूप में आहत होकर आता है, वुंडेड रहता है, इंजर्ड रहता है, और प्रॉम्प्ट रिस्पॉन्स से, सही संवेदना के साथ कार्य करने से उसकी उस चोट पर, उसकी उस पीड़ा पे मलहम लगता है। मेरा लीडर्स ऑफ सोसाइटी। दूसरे शब्दों में मैं हर बार उसको कोट करता हूँ, उस फ्रेज को जो मेरे हार्ट के बहुत क्लोज है, और मैं हर बार उसको कई जजमेंट्स में भी मैंने कोट करा है कि every file with same alphabets contains a line F-I-L और L-I-F-E, इनके अल्फाबेट सेम है। तो अगर एक पुलिस वाला, पुलिस ऑफिसर या पुलिस पर्सनल एक FIR या एक कंप्लेंट को एक लाइफ मांगता है, क्योंकि वो अदरवाइज वो फाइल है, चार्जशीट एक फाइल है, एक FIR एक फाइल है, इसलिए उसको वो फाइल को एक लाइफ मांगता है। तो जो सेंसिटिविटी है, जो फीलिंग है, वो कंप्लीट है। जैसे डॉक्टर है, पेशेंट को फाइल के बजाय कोई लाइफ मांगता है, तो वो उसका मेडिकेशन या क्योर फोकस कर पाता है। वैसे लॉयर है जो उसके पास फाइल है, जज के पास जो केस है, वो फिजिकली तो शायद फाइल हो सकती है, लेकिन इट कंटेन्स लीगल राइट्स। तो जो लीडर्स ऑफ सोसाइटी है, उनको ये ध्यान रखना चाहिए कि वो हर फाइल जो है वो उनके लिए एक लाइफ होना चाहिए। और क्योंकि हम अगर जुवेनाइल जस्टिस के रेफरेंस में देखें तो ये बात काफी फिक्र से महसूस की जा सकती है कि सेंसिटिविटी के साथ किया गया कार्य ही जुवेनाइल जस्टिस की आत्मा है, स्पिरिट है। सेक्शन 3 जो है जुवेनाइल जस्टिस एक्ट का, उसमें जो प्रिंसिपल दिए गए हैं, वो प्रिंसिपल वर्चुअली reiteration of sensitivity, reiteration of retouch, और reiteration of emotions है, जिसको अलग अलग संदर्भों में, इसमें अलग अलग रूपों में बताया गया है। क्योंकि जुवेनाइल जस्टिस कॉन्फ्रेंस का होता है और उस सहयोग से मुझे जुवेनाइल जस्टिस कमेटी संदर्भ में इंटरैक्शन के मौके मिले हैं और उनकी कई प्रॉब्लम से दो चार होना पड़ा है। कुछ प्रॉब्लम्स को एड्रेस करने के लिए कुछ हम लोग एडमिनिस्ट्रेटिव साइड पे काम कर रहे हैं, जैसे कॉम्पोजिट इंफ्रास्ट्रक्चर बनाने की कोशिश है, जिसमें जुवेनाइल ओल्ड एज होम्स और ह्यूमन रिहैबिलिटेशन सेंटर्स और हॉस्टल्स ये सब एक जगह पर है और जुवेनाइल जस्टिस बोर्ड भी उसी डिवाइसेस में रहे ताकि एक दूसरे का आश्रय रहे। इसके अलावा जुडिशियल साइड पे कुछ मैंने अपने ऑर्डर से इनोवेट करने की कोशिश की है और मेरी आपसे रिक्वेस्ट है कि उस कॉन्सेप्ट को अगर इतना संभव हो अपने डिपार्टमेंट में भी अपने कार्य क्षेत्र में भी अगर चलाने की कोशिश करें तो हम जुवेनाइल्स के लिए हम बच्चों के लिए काफ़ी कुछ कर सकते हैं, चाहे वो चिल्ड्रन नीड ऑफ केयर एंड प्रोटेक्शन हो या चिल्ड्रन इन कॉन्फ्लिक्ट विद लॉ। ये कॉन्सेप्ट है सोशल ऑडिट का। कई बार कोर्ट में कोई केस अगर वकील नहीं आते हैं वो डिस्कस हो जाता है, तो जब रेस्टोरेशन की एप्लीकेशन लगती है तो मैं उस रेस्टोरेशन की एप्लीकेशन में कॉस्ट लगाने के बजाय कई बार सामान्य तौर पर कॉस्ट लगती है 1000 रुपये 500 रुपये लीगल एड सोसाइटी या बार एसोसिएशन को दी जाती है, उसके बजाय मैं 1000 रुपये की मिठाई या फल ले जाने का कहता हूँ उनको अनाथालय में या नर्सिंग होम में या महिलाओं के कोई आश्रम में, जहाँ वो व्यक्ति 1 घंटा बिताने का रहता है, उसको फल और स्वीट्स ले जाना पड़ती है, खिलाना है साथ में और उसको वहाँ आकर एक अनुभव बताना है कि उसको कैसा लगा, एक रिपोर्ट देनी है कैसा लगा और वहाँ व्यवस्था में और सुधार की क्या गुंजाइश है ये बताना रहता है। इस तरह से हम समाज का जो साधन संपन्न वर्ग है या जो एक्ट है उनके पास कुछ संसाधन है और जो समाज की मुख्य धारा में है उन व्यक्तियों को ये जिम्मेदारी रहती है कि वो उनका ज्ञान जो कई बार चिल्ड्रन ऑफ लेसर नॉट कह देते हैं, लेकिन वो हमारे बंधु बांधव है, हमारी समाज के अंग है, तो हम उनको अगर हम उन तक पहुँचते हैं तो उनमें एक इंक्लूसिवनेस की फीलिंग आती है और जो आदमी जाता है उसको भी अपनी सामाजिक जिम्मेदारी का एहसास होता है। और तीसरी चीज कि वहाँ आश्रम या जो नर्सिंग होम है या अनाथालय है वहाँ के जो करता रहता है जो मैनेजमेंट है उसको हमेशा डर रहता है कि सोसाइटी यह जो थॉट है वो उनको सब सही दिशा में काम करने के लिए या कोर्स करेक्शन करने में मददगार होता है। केवल लॉयर्स या जजेस चाहे इसके साथ साथ पुलिस ऑफिसर्स भी जा सकते हैं, डॉक्टर्स भी, सरकारी हॉस्पिटल के डॉक्टर्स भी जा सकते हैं, सरकारी कॉलेजेस के प्रोफेसर भी जा सकते हैं और दूसरे जो समाज के प्रतिष्ठित या जो समाज के स्पेशली सरकारी विभागों में कार्यरत अधिकारी क्योंकि अकाउंटेबिलिटी रहती है उनकी, वो लोग जाके एक तरह का सोशल ऑडिट कर सकते हैं, तो उनको एक जिम्मेदारी का एहसास होगा, बच्चों को एक सम्मिलित होने का एहसास होगा और जो मैनेजमेंट वाले उनको एक डर रहेगा या उनको एक अंकुश रहेगा कि उनके ऊपर समाज की नजर है। इसके अलावा एक कॉन्सेप्ट है शौर्या दीदी का। मुझे खुशी है कि इस कॉन्सेप्ट को गवर्नमेंट के थ्रू जब पास करा तो उसे डिपार्टमेंट ऑफ वुमेन एंड चाइल्ड डेवलपमेंट ने बहुत सकारात्मक दृष्टि से लिया और पुलिस डिपार्टमेंट ने उसको बहुत आगे बढ़ाने में बार कुछ बच्चियाँ जुवेनाइल हमारे यहाँ आउट ऑफ लव एंड इमोशन या आउट ऑफ एड्रेनलिन रिटर्न इसी के साथ चली जाती हैं, फिर उनको छोड़ देता है, या कई बार रेप विक्टिम रहती हैं, कई बार फैमिली नीड ऑफ इवन प्रोटेक्शन रहती हैं। अनेक संदर्भों में वो लोग के सामने जब आती हैं और पाया जाता है कि वो बड़ी डिप्रेस्ड हैं, कई बार वो पढ़ने लिखने में उनकी रुचि नहीं है, कई बार सामाजिक स्थिति कमजोर है। उनका केस तो चलेगा, उनका केस में हो सकता है सामने वाले को सजा भी हो, लेकिन ये केवल प्रोसीजरल हेल्प होती है जब हम ये सोचें कि उनकी प्रोसीजर में क्या मदद की जाए, उनके व्यक्तित्व को, उनकी मनस्थिति को समझने के लिए और उन्हें उस डिप्रेशन या डिप्रेशन की स्थिति से निकालने के लिए ये शौर्य विधि कॉन्सेप्ट है, जिसमें एक लेडी सब इंस्पेक्टर या अगर संभव हुआ तो लेडी कांस्टेबल भी, इसमें कई बार वुमेन एंड चाइल्ड डेवलपमेंट डिपार्टमेंट की कोई लेडी ऑफिसर, इसको उसकी शौर्य नीति बनाया जाता है और कहा जाता है कि साल भर तक she will act as friend, philosopher and guide. She will mentor her. वो उसको इंकरेज करेगी, उसको वो अपने उदाहरण से बताएगी कि अगर उन तरह पे खड़ी हो तो उसकी सामाजिक और आर्थिक स्थिति कैसे सुधर सकती है। इस तरह से वो बच्ची को रेगुलर टेलीफोन पे बात करती है, अगला उसके घर जाती है, कई बार उसके माता पिता से बात करती है और कई बार आसपास के वातावरण में जो उसके ऊपर दबाव डाला जाता है या कई बार कुछ लोग उसको परेशान करने की कोशिश करते हैं, ऐसी स्थिति में वो उसको दबाव झेलने की सीख देती है और उसकी मदद करती है। पुलिस कांस्टेबल या पुलिस सब इंस्पेक्टर हमारे समाज में एक प्रभाव का प्रतीक माना जाता है और एक वुमन एम्पावरमेंट का प्रतीक है। ऐसे में वो अगर शौर्य दीदी एक्टिवली उसको सपोर्ट करती है बच्ची को, तो बच्ची कई बार डिप्रेशन से निकल आती है, नहीं तो कई बार सुसाइड करती है बच्चियाँ, कई बार उनके माता पिता उनकी पढ़ाई छुड़ा देते हैं, कई बार उनके माता पिता उनकी जल्दी शादी कर देते हैं और कई बार बच्चियाँ स्टॉकहोम सिंड्रोम का या दूसरे सिंड्रोम का शिकार होते अपने परपिट्रेटर को ही सरेंडर कर देती हैं दुनिया में दूसरे लोगों से बचने के लिए। तो ये सारी सिचुएशंस जो हैं, सारी परिस्थितियाँ बड़ी उचित नहीं होती हैं जुवेनाइल के लिए या उस बच्ची के लिए जो अभी पढ़ना चाह रही थी, इन्हीं परिस्थितियों से इस दुष्चक्र में फंस गई। तो ये शौर्य विधि का जो कॉन्सेप्ट है जुवेनाइल के लिए बड़ा कारगर है और मुझे खुशी है कि वुमेन एंड चाइल्ड डेवलपमेंट डिपार्टमेंट को जब परसुएट करा तो हमारी जुवेनाइल जस्टिस कमेटी ने तो नेशनल फॉरेंसिक साइंस यूनिवर्सिटी गांधीनगर के साथ कोलैबोरेट करके हम लोगों ने करीब 30-32 शौर्य विधि की मास्टर ट्रेनिंग कराई है। जून में 6-7 दिन का उनका कोर्स, वहाँ उनको लीगल, मेंटल, इमोशनल कैसे काउंसलिंग करना है सारी उसके बारे में ट्रेनिंग दिलाई, क्योंकि ये शौर्य विधि का जो कॉन्सेप्ट है ये थोड़ा ट्रेनिंग की दरकार करता है ताकि वो जो वुमन कांस्टेबल या वुमन सब इंस्पेक्टर है उसको ये मालूम रहे कि उसकी जिम्मेदारियाँ क्या हैं और उन जिम्मेदारियों को वो किस तरीके से पूरा कर सकती है। इसके अलावा मैं जो पुलिस की ब्रोकन विंडो स्टोरी है उसका भी जिक्र करना चाहूँगा, क्योंकि वो भी जुवेनाइल के लिए बड़ी कारगर प्रभावी उपाय हो सकता है। वो है ब्रोकन विंडो स्टोरी। कुछ न्यूयॉर्क या कुछ शिकागो वगैरह में कुछ पुलिस इन्फोर्समेंट की एक स्टोरी रही है और ये जजमेंट में मैंने उसको अपने एडजुडिकेशन में भी इनकॉर्पोरेट किया है। ब्रोकन विंडो स्टोरी ये कहती है कि इफ a window of a building is broken and remain unattended, then soon other windows signs of disorder or neglect encourage further crime and misbehavior. तो अगर हम छोटे क्राइम्स को, छोटे इनजस्टिस को अगर हम कर्व कर दें, निपिंग इन द बड, तो बड़े क्राइम होने से रुक जाते हैं। जो स्ट्रीट हैरेसमेंट है लड़कियों का, बच्चियों का, महिलाओं का, वो स्ट्रीट हैरेसमेंट या टीजिंग या जो कुछ ऑफेंस की तो चौपन एमपीसी के जो हुआ करते थे, जिनको कई बार नेग्लेक्ट कर दिया जाता था, अगर उनको हम स्ट्रिक्टली फॉलो करें, उनको इम्पोज करें कानून को या कल्प्रिट्स को प्रॉपर एक्शन लें, तो बड़े क्राइम्स उन जुवेनाइल या उन बच्चों के प्रति होने में हम रोक सकते हैं। इसलिए जब मैं ये कह रहा हूँ कि पुलिस ऑफिसर्स या पुलिस पर्सनल, पुलिस एम्प्लॉय, वी आर लीडर्स ऑफ सोसाइटी, तो उसका आशय यही है कि जो छोटी जो कंप्लेंट है वो एक पुलिस मुंशी के लिए या एक पुलिस ऑफिसर के लिए एक फाइल हो सकती है, एक निरीक्षण हो सकता है, लेकिन जो गुजर जिसके ऊपर आप बीती हुई है उसके लिए वो एक लाइफ है। तो जो फाइल और लाइफ का डिस्टिंक्शन या उसका एक यूनिजन जो है या आपस में ओवरलैपिंग जो है, वो अगर कॉन्सेप्ट को हम बेहतर से समझ लेंगे, अगर हम ये समझ लेंगे कि पुलिस ऑफिसर्स, जजेस, लॉयर्स, डॉक्टर्स और WCP वाले और सोशल जस्टिस वाले, दे आर लीडर्स ऑफ सोसाइटी। हमारा काम हीलिंग का है, एक हीलिंग टच लेने का है। दूसरे प्रोफेशंस बड़े प्रोफेशंस हो सकते हैं, लेकिन उसमें हीलिंग टच देने की संभावना या प्रवृत्ति कम होती है। तो अगर हम हीलर्स हैं तो हम फाइल को लाइफ समझेंगे, और जब हम फाइल को लाइफ समझेंगे और हम शौर्यनीति या हम ऐसे कॉन्सेप्ट्स पे वर्क करेंगे, तो जो जुवेनाइल्स हैं हमारे, उनको न केवल जस्टिस मिलेगा बल्कि जुवेनाइल प्रोटेक्शन भी होगा, क्योंकि जुवेनाइल जस्टिस से थोड़ा पहले की स्टेप है जुवेनाइल प्रोटेक्शन। चिल्ड्रन इन कॉन्फ्लिक्ट विद लॉ भी कई बार वल्नरेबल सेक्शन ऑफ सोसाइटी के रहते हैं, और चिल्ड्रन इन नीड ऑफ केयर एंड प्रोटेक्शन जो है वो भी आमतौर पर वल्नरेबल सेक्शन पे रहते हैं, अफवाह होते हैं ऑफकोर्स। तो अगर हम पूरे जुवेनाइल जस्टिस को, पूरे जुवेनाइल जस्टिस एक्ट को, रिहैबिलिटेशन को, रीइंटीग्रेशन को हम इन संदर्भों में देखेंगे, इन तरह के कुछ जो मुझे लगे कि व्यवहारिक कुछ पहलू हो सकते हैं, इसलिए मैंने चर्चा करना उचित समझा है। इसके अलावा सेक्शन 18 में जुवेनाइल जस्टिस एक्ट में कम्युनिटी सर्विस का एक प्रोविजन है, जहाँ बच्चों से अगर पाए गए कि वो CICL है तो उनको कम्युनिटी सर्विस कराई जा सकती है, कुछ क्रिएटिव परस्यूट्स में इन्वॉल्व किया जा सकता है। वो क्रिएटिव परस्यूट्स या कम्युनिटी सर्विस बहुत तरह की हो सकती है, उसमें हम उनको पेड़ लगाने का भी कह सकते हैं, उसमें हम उनको हॉस्पिटल में अगर उस स्टेज पे है, उस एज ग्रुप में, तो हॉस्पिटल में जाके मरीजों की सेवा करने का कर सकते हैं। कुछ हम स्कूल में या कुछ दूसरी जगहों पे उनको काम करने का कह सकते हैं, खुद पढ़ाई करने का एक आदेश दे सकते हैं वो। तो वो कम्युनिटी सर्विस जो है हम BLS में भी आती है, और सहयोग से जो एक्यूज लोगों को बेल दी जाती है, तो मेरा एक उद्देश्य रहता है जेल में देते वक्त में हमेशा अगर केस किस तरह का है तो मैं 2 पेड़, 5 पेड़, 10 पेड़ लगाने का डायरेक्शन देता हूँ। सहयोग से ग्वालियर रीजन में 26-27 हज़ार पेड़ इन एक्यूज लोगों ने लगाए हैं, इसमें 2-3 पहाड़ियाँ हरी भरी करने का श्रेय इन सारे एक्यूज या लिटिगेंट्स को है, जिनको किसी डिफॉल्ट के कारण, जिनको किसी बेल में जब दी गई है, कंडीशन ऑफ बेल लगाई गई और उसमें उन्होंने वो सहर्ष स्वीकार किया और आज ग्वालियर क्षेत्र में काफ़ी पेड़ लगाने की मैं इन लोगों की भूमिका रही। ऐसी हम कम्युनिटी सर्विस जुवेनाइल्स के लिए भी कर सकते हैं, इस बारे में भी हम सोच सकते हैं। और एक BPR&D के ऑफिसर्स हैं, सीनियर मोस्ट ऑफिसर हैं, और CAPT अपने आप में जूनियर इंस्टीट्यूशन है। और संयोग है कि मुझे आज पहली बार आप सबसे मुखातिब होने का मौका मिला है। तो मैं कुछ एक दो और जो मेरे कॉन्सेप्ट हैं उन पर मैं थोड़ा प्रकाश डालना चाहूँगा। जैसे एक कॉन्सेप्ट है दृश्याविधि का, जिसमें फिल्म की किसी सीन को लेके उसको ऑडियो विजुअल रूप से क्रिमिनल लॉ बनाने की टेक्निक डेवलप की है। पिछले 2-3 साल से उस पर काम कर रहा था। हम नेशनल लॉ यूनिवर्सिटी जबलपुर में उसको रिसर्च प्रोग्राम के तौर पर एक्सेप्ट किया है। उसमें भी हम पुलिस ऑफिसर्स को या पुलिस जो पर्सनल हैं उनको हम ये ऑडियो विजुअल माध्यम से क्रिमिनल इन्वेस्टिगेशन कैसे बेहतर किया जाए ये बताया जा सकता है। उदाहरण के लिए मैं शोले फिल्म की क्लिप का उदाहरण देता हूँ। इसमें एक ट्रेन डकैती का सीक्वेंस है। उस ट्रेन डकैती के सीक्वेंस को दिखा के मैं ये 4 टीमें बनाता हूँ: इन्वेस्टिगेशन, प्रोसिक्यूशन, डिफेंस और ट्रीटमेंट रेटिंग। और उनसे अलग अलग इन्वेस्टिगेशन में अलग अलग व्यक्ति को अलग अलग पार्ट देता हूँ। इन्वेस्टिगेशन का किसी को सेक्शन 161 CRPC के बयान बनाने को, किसी को सीजर मेमो बनाने को, किसी को सेक्शन 27 ऑफ एविडेंस एक्ट का मेमो बनाने को। और हर आदमी को जो बनाना है वो उसको पूरा उस पर लॉ डेवलप करके बताना रहता है कि सेक्शन 27 पे लेटेस्ट लॉ सुप्रीम कोर्ट और हाई कोर्ट का क्या है। पुलिस वालों के लिए ये ज़्यादा ऑडियो विजुअल मोड ऑफ लर्निंग इसलिए बेहतर हो सकता है कि जो सीन देख के आप कौन से ऑफेंसेस लगेंगे, कौन से प्रोविजंस में आएगा और किन किन चीज़ों की सावधानी रखनी है, ये सब उनको बताया जा सकता है। ये कॉन्सेप्ट है। कुछ एक दो केसेस में मैंने NIC टीम को इनकॉर्पोरेट किया है। उनको रिक्वेस्ट की है कि वो एक संदेश ऐप बना रहे हैं, जैसे WhatsApp होता है वैसे संदेश ऐप है। तो जैसे कोई बड़ा क्राइम होता है तो उसमें इन्वेस्टिगेटिंग ऑफिसर और दूसरे स्टेक होल्डर धीरे धीरे ऐप बनाते हैं, जुड़ते जाते हैं, ग्रुप बनाते हैं। जैसे WhatsApp ग्रुप बनता है वैसे संदेश ऐप ग्रुप बनता है। उसमें जो ट्रायल कोर्ट में जितनी प्रोसीडिंग्स हो रही हैं वो उस ग्रुप में मैसेज के तौर पर आती जाती हैं ऑटोमेटिकली। और कंप्लेनेंट की भी लिमिटेड एक्सेस रहेगी उसमें, ताकि कंप्लेनेंट को ये मालूम रहे कि उसके कंप्लेंट पे जो इन्वेस्टिगेशन हो रहा है वो कहाँ तक पहुँचा है। अगर ट्रायल हो रही है तो वो ट्रायल बनता है, उसमें उसको समन्स भी टाइम पे मिले। इस कारण से वो सर्विस भी कम होगी, जिसमें कंप्लेनेंट को ये मानना नहीं रहेगा कि वो क्यों नहीं आ पाया और इंटिमिडेशन होता है या उसको नारा धमकाया जाता है। उसके लिए भी वो कंप्लेंट कर सकता है IO को, और उसके लिए पोर्टल बनेगा जिसपे वो कंप्लेंट IO तक आएगी। तो ये कुछ इस तरह का ये करा जा रहा है। एक टास्क दिया है मैंने जो कि BPR&D वाले ऑफिसर्स हैं, इसलिए मैं थोड़ा सा कहना चाहूँगा कि ये कोशिश कर रहे हैं कि NIC वालों को बोल रहा है कि सीन ऑफ क्राइम जो है उसकी जो वीडियोग्राफी होती है, उस वीडियोग्राफी का एक प्रोटोकॉल तय किया जाए, एक रेजिमेंट बनाया जाए, एक स्टेप्स तैयार किए जाए कि इन स्टेप्स को फुलफिल करना है वीडियोग्राफी में, ताकि उस सीन ऑफ क्राइम के इसेंशियल इंग्रेडिएंट्स आ जाए। साथ में ट्रैक बनाने का भी कहा है कि अगर वो सारा सीन ऑफ क्राइम की वीडियोग्राफी अगर इसमें ऐप में डाल दी जाए तो क्या ऐप इंटरप्रेट कर सकता है नेचर ऑफ क्राइम या सस्पेक्ट्स या how the time to place और जो assessing probable है वो कहाँ किस डायरेक्शन में गया है या कितने लोग थे जिन्होंने ये काम किया एक probable है आउटलाइन दे सकता है क्या जिससे इन्वेस्टिगेशन में अगर कोई एक इन्वेस्टिगेटर के पास समय कम है या वो एवरेज इन्वेस्टिगेटर भी है क्योंकि वो एक्ट जो इंटरप्रिटेशन है उससे उसको काफी मदद मिल सकती है तो ये कुछ चीजें हैं जो मैं आपको शेयर करना चाहता था ये एक इंडियन इंस्टीट्यूशन है मेरी बहुत दिनों से आने की इच्छा थी आज हमारे यहाँ की रिटायर हो रही है मुझे वहाँ ग्वालियर में रहना जरूरी था इसलिए मैं भोपाल व्यक्तिगत तौर पर उपस्थित नहीं हो पाया मुझे बड़ा दुख है और मैं आशा करता हूँ कि अगली बार मैं रूबरू आप दोनों के साथ अपने विचार शेयर करूँगा और आपके जो अनुभव है आपके जो विचार हैं उसको एक्सेप्ट करूँगा फिर डिस्कस करूँगा आप सभी को बहुत बहुत शुभकामनाएं कि अच्छा कार्यक्रम आपने करा बधाई आपको और फिर मेरी आपसे फिर कभी मुलाकात होगी मैं सभी को अंत में धन्यवाद देना चाहता हूँ जय हिंद।
मैं महोदय का तहे दिल से धन्यवाद ज्ञापित करना चाहूँगा ऑन बिहाफ ऑफ डायरेक्टर CAPT एंड ऑफिसर्स एंड स्टाफ जो सर ने अपने बहुमूल्य समय से हमारे लिए समय निकाला और मैं उम्मीद करता हूँ कि आगे आने वाले कार्यक्रम में सर फिजिकली जैसा सर ने हमसे वादा भी किया फिजिकली यहाँ पे पहुँचे सर हमारे बीच में आए। अब मैं हमारे सीनियर मोस्ट पार्टिसिपेंट श्री राजेश भंडारी सर से आग्रह करूँगा टू डिलीवर द वोट ऑफ थैंक्स ऑन बिहाफ ऑफ ऑल द पार्टिसिपेंट्स रेस्पेक्टेड सर। तो भंडारी सर का रिटर्न हो गया तो एनी विलिंग ऑफिसर एनी वॉलंटियर प्लीज आए सर।
Very good evening, everyone. This was my first experience at CAPT Bhopal, and I can say from the beginning, from making a call to Prakash Badolia sir, first of all, and on behalf of everyone, first of all, I want to thank Prakash sir, who is such a coordinator. मतलब it does not feel कि हम कितने दूर से आ रहे हैं, किस destination से आ रहे हैं. He makes everything so smooth. The CAPT staff, official, everyone, and obviously everything happens under the guidance of Anil sir, director sir of CAPT. Therefore, thanks to all the CAPT members and all the participants. Those who have went obviously are also very important. Who came all along. There were people sleeping after traveling so much. I came 2 days ago. Why? Because obviously there was one weekly train. यहाँ पे बहुत लोगों से मिलने का मौका मिला, लगा कि जैसे महाराष्ट्र से 10 जुडिशियल ऑफिसर्स आए हुए थे, तो मुझे लग रहा था मैं झारखंड से नहीं, अब मैं महाराष्ट्र कैडर से ही हूँ. तो इट वाज रियली वंडरफुल मीटिंग सो मेनी पीपल फ्रॉम ओडिशा, वेस्ट बंगाल, छत्तीसगढ़ एंड मध्य प्रदेश. So I'm really happy that this all went so good. It was such an encouraging sessions by everyone. We got to learn a lot. Thank you, everyone, and we'll surely look forward for such good seminars in future, sir. Thank you. Thanks a lot, sir.
Thank you so much, sir, for your kind words. And now I will request all the officers to please join us for the high tea. Thank you, and wish you all happy journey.